Good morning. Good morning. How are you? How are y'all doing? I'm here. I did something stupid yesterday, but I'm here. Good morning, y'all. Well, it looks like we may go to jury today. We will be going to jury today in the Laurie Shaver case. Um, and then it's going to be over. We'll be in verdict watch. I cannot believe I expected this to last another couple days. I did not expect for them to just not hold on, my camera got it. There we go. I did not expect this. Honestly. How does this happen? Is my cat playing with my camera at night when I'm not here? She was in here. She knocked a bunch of stuff down. Oh, yeah, that's not balanced. Oh, I'll get there, guys. I'll get there. There we go. That's more better. But anyway, I don't know. I don't know. I got to get my fan fixed too. So it'll be interesting. Closing arguments are going to be real interesting. What did y'all think about her testimony yesterday and that of her daughters? I struggled with that one. I'll confess it. I struggled. I struggled. Good morning, Toxic. Let's see, who was it first in chat? Out and about with Diane. Well, at 3:30 in the morning, my time. Girl. I know you're on a whole different time zone. Uh Andriel, you missed it. Go back and watch it. uh First okay, Kristen. Good morning. Welcome our new mod, Miss Kristen. Oh, thank you so much. I know it's early, girlfriend. I know. We need to get some cases on the West Coast. We don't ever get very many over there, do we? Good morning, Miss Toxic. Good morning, Andrielle. Waking up today and it's not going as I expected. Do I touch that? Oh, well, I did something stupid last night. Well, I say stupid. It was good, but my body is saying, stupid choice. Soon as the live was over, I have been wanting to. I have a Blackstone griddle, the big one, has the air fryers underneath. Had it for 2.5, 3 years. I haven't touched it in over a year. Um, Hi, Michelle. Welcome. Yes, anxious to hear the closing. The defendant's testimony was odd, to say the least. But I went, took the cover off, and it's totally rusted, which happens with those. They're cast iron. So I was getting ready to clean off all that rust. So I got my power washer, and I thought, I need to wash this bad boy outside, inside, everywhere. So I started doing that. And then as I brought the power washer down, I have a rock patio, and I noticed this white streak. And I went, oh my God, is it that bad? My patio? And I mean, you don't notice it. So I power washed the patio. And then I went around back of the um, grill and was hosing it all or power washing it all. And then I did the same thing to the driveway. And I'm like, in comparison, it looked black compared to the white, clean stripe the power washer left, and I'm all like, I got to do it. I did my entire driveway. I did my sidewalk. We have limestone rocks bordering our yard, front yard. I did the entire rock border, the sidewalk, the walkway up to the house. I even power washed the front of the house, the entire driveway. Yeah. My body's saying, nope, this morning. Michelle, it is so satisfying on a psychological level. But my body is saying, honey child, what the hell you doing? You too old for this crap. I'm like, yeah, I know. I know. My hand, look at it. This is the hand that I use. It ain't happy. I have rheumatoid arthritis, and I knew. What do you want? I gotta get the camera on. Is somebody here? No, we're good. Good girl. So, yeah, who cannot chat in the chat? I don't know why. Does she go by a different name? Let me go to my as the gavel drops. I mean, as a gavel. Well, we need to do that anyway. Ladies and gentlemen, we have a new sponsor. Let's have a word from our sponsor. Welcome as the gavel drops. They are a channel on Discord. And if you love to dive into documents that are court related and keep up with what's going on, oh my gosh, this is the place you need to be. As the gavel drops, has almost 500 cases that they're following at any given time, and they are our go to for documents. So please go to As the Gavel Drops and subscribe, become a part of the channel. They'd love to have you. In the meantime, thanks for joining us today. I gotta I gotta get a recording on that. Let me um, do this, this, Control V. I did it. I okay. Toxic, is she reaching out to you? Because I know I left her a message yesterday. Um, and I didn't hear back from her. I have no idea if there's another name that she goes by that's different than what's in the gavel drops. I mean, in the Discord. Then I need to know what that is. I have no idea how to fix that. But the name or her whatever that she's going by in Discord is not on our block list. So I don't know how to fix that. Good morning, Lois. We are waiting. I don't even see a new stream for her. I'm looking for a new stream and I don't even see it yet. So, y'all, I'm trying to wake up. Forgive me. Forgive me. So I got in bed at like 11:30 last night and I slept hard, real hard. So hard to get up. But look at my hand. I held that thing for like 5 hours, 6 hours. I power washed yesterday. It was work, but so satisfying when I got up this morning and looked out and saw my nice white driveway. Now, the other thing is if y'all don't have pecan trees, when their pecans drop and you run over them, there's so many pecans in my driveway. Or you come home and the squirrels have gotten them and they're just broken shells everywhere. They stain bad. I didn't know that. I didn't know it. Didn't see it because my driveway was gray black. I didn't realize it. It was awful. So, oh, baby girl, who's your baby girl? Yeah, she's my pupper's got her head on my leg. She's like, Mommy, do you need something, my dear? Is that what you want? Um, so this, I was concerned. I wasn't sure how long this trial was going to go, and I was worried about it interfering with um, Donna Adelson. Thank goodness this is not going to interfere with Donna's Adelson. Is it Adels, Adelson or Adelson? I've heard it pronounced two ways, and I'm not sure which way we need to pronounce it. So I need clarification on that, y'all. Okay, let's talk a little bit about the. Well, I guess I can. Sensei, stop. Let me get to the first true witness of the day. Really was a the internet guy over Facebook, and then you had the psychologist. But what gets me, and I'm going to replay it a little bit. Let's replay the daughter. Let's replay some of the daughter while we're waiting. Yeah, I saw it. I answered her. Let's do this. Zoom, 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 zoom. Yeah, I see Miss Toxic. There was a long bit of silence there. Okay, we're going to go live. And here we go, guys.
Okay.
So they are currently, I think, working on the
All right. We have 3.3 D, possession of a firearm,
jury
discharge of great bodily harm or
instructions.
death. And I think in the first sentence, we need to add the word committed. If you find that Laurie Lee Shaver committed murder in the second degree, is that agreeable?
Yes, sir.
Okay.
Another thing I just asked, just for as a stylistic thing, and it just stopped, if we could line the margins up through the paperwork and double space it for purposes of cleanliness and ease for the jury. I'll make it for you.
All right.
That's what we want.
Thank you.
All right, Toxic.
All right,
I got Miss
3.6,
Kevin on it when she can get
lesser
to it.
included crimes or attempts. Now, Mr. Wiggs, were you asking for battery?
Yes, sir.
Okay.
Okay. You didn't want manslaughter, but
I didn't want the manslaughter.
Miss Toxic, go to private chat, please.
That is a mandatory, but as a permissive, we asked for 8.3 battery.
well, manslaughter was granted, and state's position on the battery request.
Oh, wait, you're not in private chat. Never mind. You will be. We'll get you there. Thank you.
States that they're not entitled to non-homicide lessers in a homicide. I'll read from that case. What we have here is the death of a human being, which was either unlawful homicide or lawful homicide. The death of the victim is not an issue. It is an incontrovertible fact. The jury's duty is to ascertain whether the defendant caused the victim's death, and if so, whether the homicide was justifiable or unjustifiable. If the jury finds that an unlawful homicide has occurred, they must then determine what degree of murder or manslaughter. They're not in, goes on to say, in light of the above discussion, we hold that where a homicide has taken place, the proper jury instructions are restricted to all degrees of murder, manslaughter, and justifiable and excusable homicide. This is in accord with our previous decision in Brown 2, to the extent that Apple, Elmore, and Herman conflict with this, they are
Judge,
The volume's better.
Yes,
It's
sir.
clear.
the juries, the law sets forth permissive lessers. It is plausible that the jury may feel and find, based on the evidence that they heard, that Jeremy Townsend committed the offense, or Isabel committed the offense, but that Laurie was engaged in a battery before the event occurred. So the state has not clearly defined it as to the other offenders in the case. And we know we have a defense of others instruction, and it falls within a permissive lesser authorized within the statute. So we'd ask that it be granted.
All right. State, anything further?
The defendant testified in this case, the child testified in this case, there's no evidence to support a battery conviction of baseball by Ms. Shaver. And once again, that case clearly states the death of the victim is clear, and they're not entitled to the non-homicide lessers.
No, I disagree, Judge. You look at the permissive lessers, that's within the discretion of the court. And it's to the jury as the finder of fact to determine whether or not those facts exist. That law doesn't state that it weighs in the permissive discretion of the court. Again, the facts are very vague. We know there's some form of an entry. We don't know who the initial aggressor was. Those are facts for determination by the jury.
All right. The request is denied. Okay. Manslaughter 7.7. Is that satisfactory as drafted? All right.
We're asking that it not be given nonetheless.
Okay. And that request is denied. The manslaughter instruction will be given. Okay. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm, 3.3A. Satisfactory?
Well, the state's entitled to it, Judge, and I think that's the form, instruction. You have to say yes.
All right.
I do see an extraneous bracket last year, but we'll take that out.
All right. Thank you. Yes, after the word firearm, correct? Okay. Accessory after the fact, 21.18. Is that acceptable as drafted?
That is the standard elements, yes, Judge.
All right. 3.6F, justifiable use of deadly force.
And here's where we gotta tailor this, Judge. I sent in a proposed instruction, and based on the testimony that we've heard in this case, by Laurie Shaver and Isabel Shaver, it does contemplate prior bad acts and the history you've heard habit testimony in this case, that we, requested a proposed instruction as to justifiable use of deadly force that is submitted to the court. And I've used the standard jury instruction. You may see within it, I left in there certain sections for us to talk here at the conference about what could be omitted. And that begins on, well, actually on the first page and throughout, but you'll see certain ones that I've said omit, that they weren't relevant. You'll see,
Let's go through the document because it is multiple pages. We'll go through it paragraph by paragraph and then discuss each request individually. So first paragraph, acceptable, correct? As drafted by the state. We're looking at the states.
I'm not looking at the states, I'm looking at mine because the state didn't insert some of this data, Judge, that I tailored for the court.
But the states is the standard instruction, correct?
Mine's a standard instruction.
Okay, so let's look at the states, and if there's something you would like to add, then please raise that as we get to the appropriate portion of the instruction. So the states, paragraph number 1, any issues?
I think that's the standard there, Judge.
All right. So we're moving on to Laurie Shaver was justified in using or threatening to use deadly force if she reasonably believed that such force or threat, that those 3 paragraphs.
When I put Laurie Shaver, I put in it, Laurie Shaver was, oh, wait a second. Yeah, that Laurie Shaver does not have the burden of proving.
That's in there. That was the first paragraph that we already addressed.
No, that's
Yeah.
the one above it.
Yes, well, that is the first paragraph in the document. Laurie Shaver does not have the burden of proving.
Laurie Shaver. see, Judge, the states here, right here, it says, um, if she reasonably believed that such force or threat of force was necessary for the imminent death or great bodily harm to herself or another. And it says imminent commission of an applicable forcible felony against her or another. But it doesn't define at that stage what the applicable forcible felony was against her or another. So that's where I think you gotta insert the required language or what she reasonably believed was the applicable forcible felony for the jury, and that needs to be defined.
All right.
I agree, that's why it's set up this way to be addressed.
Right.
It is printed in bold, so.
Felonies, where you ask for
Look at my at my jury instruction, I think I defined it in there.
All right, you listed attempted murder or aggravated battery, correct?
You may have to go down further, Judge, where it says threats of forcible felony. On the following page.
Yes, I'm there, page
Yes,
2.
okay, and that's where, I think there's a definition that's provided, well, in it throughout. And the applicable forcible felony was an attempt to murder or create great bodily harm. And those elements, I think, are specified or should be specified.
You're asking for the imminent commission of attempted murder.
You listed aggravated
Or
battery.
aggravated battery.
Correct.
Okay.
And those elements be asserted within that self-defense instruction.
There's a place for it.
Okay, that's what the evidence was.
But the previous paragraph of defining every forcible felony, I don't see how that, one, that's not the standard. I don't see how that's necessary. We're not dealing with carjacking, aircraft piracy.
No, that's what I just said, an attempted murder or an aggravated battery. And then give those
Okay.
those elements.
Got it.
That's it.
All right. Now, the next page, in deciding whether Laurie Shaver was justified in the use or threatened use of deadly force, you must consider the circumstances by which, now that portion, that page,
Well, 1 second, Judge. I think you skipped the, if Laurie Shaver was not committing any crime.
And I'm gained up
yes,
as
is
much
that
as I
acceptable?
can be. I'm sorry.
That's the middle paragraph of the 3.
Laurie Shaver was not committing any crime other than the alleged.
Toxic, please go to DM and Discord. Thank you. Good morning, Britt Eller.
Okay,
Good morning, Melanie.
Laurie Shaver was not committing any crime.
okay. Laurie Shaver was not committing a crime. Yeah, that's.
And they don't have captioning. Let me see if I can get a better feed.
And the next one regarding the dwelling.
You know, we have to add in the attempted murder or aggravated battery in the voltage bracket area based on the defense's request.
Correct.
Yes, sir.
Yeah, and on that page, we just need to put in, I think where it says defendant, you want to put in the defendant's name, throughout here and tailor it, take out the himself, herself.
Relevant to this case. We're looking at that right now.
Do you follow me, Judge?
Yes, sir. I see where we're at. And are you objecting to that portion being in?
It just needs to be, the use of deadly force is justifiable if Laurie Shaver reasonably believed that force was necessary to prevent imminent death or great bodily harm to / herself.
It's all the same feed. Sorry,
We'll
I can't do anything.
just track with the language and the rest, all the brackets.
And the sound is
Thank you.
on the right for me, too.
When it talks about the applicable
I-
felonies, we will use.
I'm gained 100%. Let me look.
All right.
That brings us to in deciding whether Laurie Shaver was
That is as far as I can go.
Okay. Any issues with that page?
That's fine, Judge.
Okay, the entire page is acceptable? All right. Okay, and the next page. If you find that Laurie Shaver, who because of threats or prior difficulties with Michael Shaver had reasonable grounds to believe, any issues there?
No, sir.
All right. Okay, then we're on to 3.6G, justifiable use or threatened use of non-deadly force. Okay, let's discuss page 1.
Well, Your Honor, the state is objecting to that instruction in its entirety. Under,
We talked about a proposed instruction I drafted.
yes, your proposed instruction for justifiable use of non-deadly force.
I thought it says a mandatory lesser under the, giving of the other statute.
Your Honor, I'm citing to Hosendel, Hosendel, State
Thank you.
128 Southern 3rd, 400. Your Honor, this case and others cited within it stand for the proposition that the discharge of a firearm is deadly force as a matter of law. And the discharge of a firearm is the only scenario in which the court should basically only give the justifiable use of deadly force and not extend the justifiable use of non-deadly force. I would direct the court's attention to page 4, the end of starts on page 3, goes on to page 4, which is the head notes 3, 4, and 5. On page 4, it goes on to say the discharge of a firearm has been held to be the use of deadly force as a matter of law. In Miller, the court found that firing a firearm in the air, even as a warning shot, constituted as a matter of law the use of deadly force by the defendant. Thus, the trial court did not commit reversible error by not giving the instruction of the use of non-deadly force.
All right, Mr. Wiggs.
Yes, I would say this, we have a separate requirement in the jury instructions proposed by the state that they separately and independently have to find that there was a firearm used. Okay, if there's not a separate finding that a firearm was used, then that becomes a discretionary issue for the jury, and they could conclude that there was non-deadly force. So I think it's appropriate, I think it's mandated right in the instructions themselves.
Actually, the instruction or the justifiable use of deadly force specifically cites to this Hosendel case and says that in those situations, only the justifiable use of deadly force instruction should be given.
All right, the state's objection is sustained. 3.6G, justifiable use of non-deadly force will not be given to the jury. Only 3.6F, justifiable use of deadly force. Is there anything further? We have plea of not guilty, reasonable doubt, and burden of proof. Is that acceptable?
Your Honor, can you give us one moment to go back to deadly force?
Yes, sir.
About 4 paragraphs from the bottom, if you find that Michael Shaver had a reputation of being violent and dangerous person, there's been no reputation evidence, so that paragraph should be stricken.
So, Judge, we've heard actual
The
physical.
next 2.
Yeah, we've heard testimony, we've seen exhibits offered into trial about consequences and acts of physical violence. So it becomes those specific instructions should be included within the jury instructions and not excluded.
Your
They're standard instructions.
Yes, sir.
evidence that he's referring to that he wants to reference as to why that this is permissible use of deadly force is covered in the previous paragraph. If you find at the time of the alleged murder in the second degree, Laurie Shaver knew that Michael Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver reasonably believed it was necessary for her to use or threaten to use deadly force. The two paragraphs that I am asking to be stricken specifically go to whether or not reputation evidence was presented. First, reputation of being a violent, dangerous person, and whether or not that was known. And then two, reputation of being a violent, dangerous person. You may consider that as far as whether or not he was the initial aggressor. There's been no reputation evidence. There has been acts of other violence, which is covered in the.
Good morning,
I'm just asking for the
Karate Mom.
Language that deals with evidence that has not been presented.
Judge, there's case law, and it's in Earhart sitting on my desk, and it talks about that the family is such a narrow community, you can never establish reputation to offer that specific conduct. So we do have evidence that there were past acts of violence. I'll leave it to the court as to whether you want to just delete the paragraph or you want to put in, again, reference to past acts of violence as demonstrated through witness testimony.
You're saying leaving in the second paragraph stating,
I believe, yeah.
all right, so you have no objection to the reputation being removed.
No, I just think if you want to tailor that, it should have to be tailored to represent that you've heard testimony that there were past acts of a physical nature of violence. Such acts may be considered by you in determining who was the initial aggressor. I think it could be tailored that way because, as I stated, Earhart declares that you can't establish reputation within a home environment.
He's conceding that there's no reputation evidence, so these two reputation paragraphs should be taken out.
No, I'm
And what-
saying they should be tailored.
And once again, the paragraph that precedes the ones we are talking about, the two paragraphs that we precede that we're talking about, if you find that Laurie Shaver, because of threats or prior difficulties with Michael Shaver, had reasonable grounds to believe that she was in danger. And then two, if you find at the time of the alleged murder in the second degree, Laurie Shaver knew that Michael Shaver had committed an act of violence, both of those cover what he wants. There's the next two deal with a specific presentation of evidence that hasn't been presented, and that's why they should be redacted.
All right, state's request is granted. The two paragraphs relating to reputation evidence will be removed.
Your Honor, the last thing I just want to address on the record before we move on, the way the standard instruction is drafted and presented basically is very much focused on a self-defense claim as opposed to defense of others. And the state realizes that this is what they really are going for is whether or not Isabel Shaver was aware of these things and acting in defense of others. So I believe that those areas
They need to be included.
where I would say in that if you find that Laurie Shaver, who because of threats or prior difficulties, I think that we can put or Isabel Shaver in acting in defense of others.
Any objection?
No, I made notes on that as well, and I didn't know what the specific instruction was. I thought the state knew that Isabel was going to say this, and I thought actually they put it in their primary instructions.
So please modify the instruction accordingly.
Yeah, just put in the defense.
I was kind of waiting to hear how the defense would want to handle that, sir, but that's why I brought it up.
Yes, sir. So there's no objection.
And we will work on that. We will make sure we print out prior to any final instructions. Just we'll address that again to make sure there's no further changes that need to be made later today.
Yes, sir. All right, 3.7, any objections?
Judge, one moment, please.
Yes, sir.
Since we're dealing with the substantive crimes and instructions up to this point, let's say, we had requested instructions on consequentity.
He wants to go back to the accessory after the fact.
All right, I have that. Consanguinity as a defense. I've read over it and the state's position.
He's referring to a statute that has been modified and changed the statute. The cases that he cites refer to a statute that was modified in 2006. The statute that's currently written, I have copies for. Your Honor, may I approach?
Yes, sir.
That is 777.03.
Thank you.
Paragraph B, any person who maintains or assists the principal before the fact or gives the offender any other aid knowing that the offender had committed the offense of child abuse, neglect of a child, aggravated child abuse, aggravated manslaughter. Apologize. Paragraph C, any person who maintains or assists the principal. Any person who maintains or assists the principal or an accessory before the fact or gives the offender any other aid knowing that the offense had been committed a crime, and such crime was a capital life, first degree or second degree felony, or had been accessory thereto before the fact with the intent that the offender avoids or escapes detection, arrest, trial, or punishment is an accessory after the fact. The discussion of people being in relation, which is what Mr. Wiggs is referring to, is in paragraph A, which deals with someone that is a accessory before the fact. So the language that he is requesting is not appropriate, and that's why the standard instruction does not include any of that.
Any person not standing in the relation of husband or wife, parent or child, grandparent, brother or sister by consanguinity, who maintains and assists before the fact, okay, or gives the offender any aid, knowing that the offender had, which is after the fact, committed a crime, and such crime was third degree, and that's third degree,
Right.
okay, or had been an accessory there too before the fact with the intent, okay, and the offender who maintains, which I could read this almost.
Your Honor, you can't be an accessory after the fact if you are a relative to a third degree felony.
No, that's fair. Let me read.
All right, please take turns. Mr. Cabuccio, anything further? Okay.
No, I think it's still applicable based on the law that I cited to the court. And I don't see where this case has been overturned, Judge, which was Brown v. State. And it states that Marshall had been charged with a second degree murder, and Brown was charged with being an accessory after the fact. He first asserts to one guy that there was a relationship of consanguinity as a defense, and that was his defense. The court said, well, you're too remote in the relationship to assert that to a second degree murder. I don't see where clearly what Mr. Calucci at the last minute, having produced these weeks and weeks ago, is providing that says that this has otherwise been revoked or overruled. But your Honor, this does provide something with my type to try to read off of. I've read the statute update. I don't see, this is a 2006 version. I've read the latest version of the statute, and I don't see where it changed, as Mr. Calucci was suggesting here.
Your Honor, may I approach?
Yes, sir.
Here's the copy of the statute that was in effect before 2006, which cases that Mr. Wiggs cites was the statute at the time. So in 2006, when the Florida legislature changed the statute, the standard jury instructions were changed to comport with the statute. And that's how the cases of Brown and Bowen, Bowen was from 2001, Brown was from 1996, have been abrogated.
I don't believe so, Judge. I'm looking at the current statute, and I don't think that's the position. I think it's still in effect, it's a still viable defense, and we request the instruction.
All right, the request is denied. Three point seven, plea of not guilty, acceptable?
If this is just a standard, Judge?
Yes, sir. Okay. 3.9, weighing the evidence. We have to decide yet as to what or if all or any of 6, 7, 8, 9, and 10 will be given.
Where you're looking at.
3.9,
Mine goes from maybe 3.7 to the self-defense. Okay, now 3.9. These are the standard.
yes, sir, except for 6 through 10. Do the parties want 6?
We had testimony from Adam Narvaez about the reputation for truthfulness as to Laurie, Isabel, and Travis. I request that it be included.
Your Honor, I don't think we have any evidence of 6.
Correct.
I don't think we have any evidence of 7. We do have,
Judge, I'd ask that 6 remain in, and I'll tell you why. We did hear from Jeremy Townsend. He's represented by counsel. He has an arguable and viable interest in the case. There may be an inference that he has negotiated some kind of
Good morning, Ronnie.
obligation or with the state. He's under compelled testimony of the subpoena, so I'd ask that remain in.
So it reads, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
I think that he could be charged, so there is an interest, so there could be a preferred treatment. That should remain in.
The state's response?
we can leave it in, but there has been absolutely no evidence of any sort of deal. And his arguments that this can be inferred when he knows that I have a Brady obligation to turn over some sort of deal on that, I think would be an improper argument and completely improper.
I'll tell you what, I worked with the state, I worked with Brad King, I worked with Rick Ridgway, and those gentlemen would infer a preferred treatment with counsel and not put it in writing, and it would be silently implied. So to just say, I don't have anything in writing, there still could be an innuendo that somebody's receiving fair treatment. And to just say, I would do it, and I would turn it over, I'm sure if you had it in writing.
I'm quite frankly offended by the attacks on the character of former state attorney Brad King and former chief assistant state attorney Rick Ridgway at this point. But what really matters is the fact that I do have a Brady obligation. I would have to turn that over. There is no agreement. There is no preferred treatment. And to just make stuff up and infer it to the jury is improper argument.
And I agree, and I work with those same individuals, Mr. Wiggs.
I've worked
Yes.
life cases with them, and that's why they dealt with me.
And the state has a Brady obligation.
Yeah.
And so if there was any type of agreement, you would have knowledge of that. So 6 will be stricken. Okay, number 7.
I don't think there's been any evidence of any pressure there
Well, what evidence has there been, Mr. Wiggs?
I think they can imply something. I think they may infer from their common sense what they heard that there may be.
I've heard no testimony as a state.
Yes, sir.
A 7 will be stricken. Number 8, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court?
There's evidence.
Okay, so 8 will remain. 9, has the witness been convicted of a felony misdemeanor involving dishonesty, false statement? Yes. So Mr. Filmer testified to 3 felony convictions. 10, does the witness have a general reputation for dishonesty or truthfulness?
Yes, that remains.
Your Honor, actually what was asked of Mr. Narvaez is, do you know of their reputation? He said yes. He actually never gave a response as to what it was. But if the defense wants that one in there, that's fine.
All right, 10 will remain. So 8, 9, and 10 will remain. 6 and 7 are stricken. Okay, the defendant has testified, so the last 3 paragraphs are applicable.
Yes, sir.
3.9A will be removed, defendant not testifying. 3.9B will remain, defendant's statements. 3.10, rules for deliberation appear to be standard. Is there anything further on that?
We move on. Okay. 3-9.
We're a little behind. Do you know what, guys?
Yes, sir. 3.9B will remain. Any modifications?
In the state's packet after 39B is when I included the closing arguments section, because that in the past has been when the cases I've tried have broken up the 2 sets of instructions before and after closing arguments.
Yes, sir, and I will read the initial instructions prior to closing argument and the remainder after. So I have the closing argument instruction, both at standard. Okay, 3.10, rules for deliberation.
These are just standard, Judge, over 3 correct?
All right. 3.11, cautionary instruction.
That's standard.
3.12, verdict.
Correct, that's standard.
3.12A, single defendant, multiple counts or informations. Okay.
Submitting defense?
Yes, sir. 3.13, submitting case to jury.
That's fine, Judge.
And we have the verdict forms. Does everyone have a copy of the proposed verdict form?
One of the proposed instruction I did.
Yes, sir.
Was the duty to report. I had submitted proposed instruction on that, but there was no duty to report on just because you had observed the crime. And I attached the authority on that. I think the law is clearly still the same on that issue today.
All right, state's response.
Yes, Your Honor. Let me get that right. As far as the law that relates to special jury instructions, the defendant must prove 1, that the special instruction was supported by the evidence; 2, the standard instructions did not adequately cover the theory of defense; 3, the special instruction was a correct statement of the law. That is Wheeler v. State 4 Southern 3rd 599. The court does have wide discretion in deciding whether or not to give or withhold a special instruction. I will say that we have found no case dealing with any sort of special instruction to say that it's not a crime. No one is saying that she is guilty solely by failing to report the crime, so there's no need to instruct the jury as such. It also creates confusion because we are obviously going to argue that the fact that she doesn't report anything.
Not at all, Christian. Do what you got to do.
Veracity and credibility of that
We're
statement,
good.
and also that we're dealing with consciousness of guilt for the murder itself. So, and there's also the fact that she not only does not report the crime, but lies to law enforcement about the fact that she witnessed this crime, which is part of the accessory after the fact charge. So giving this instruction would be misleading and confusing, and based on the fact that they need to establish that it is necessary and that it's not misleading and confusing, then it should be stricken.
Judge, she's not charged here with lying to law enforcement. That's not the charge. She's not charged with bank fraud. She's not charged with anything other than the charge of murder and accessory. The law still directs that if there's any reasonable evidence to support the proposition of the defense, the court is to grant the proposed instruction. And to do otherwise is an abuse of the discretion of the court. There is, again, the state is thinking that that the jury's supposed to render a verdict because somebody went on Michael Shaver's account or she made a misstatement to law enforcement. That's not the law. That's not found with any of the instructions that we just went through. So any evidence that she thought that the body had been removed somewhere else, which we've heard that there was evidence that she believed that the body was taken off the site by Mr. Townsend. Somebody called and said there was a trespasser, and the body later shows up there. The defense is entitled to the instruction that the defendant had no duty to report the crime. Specifically, there must be a factual determination by the jury that the defendant committed the crime. So we're entitled to that instruction, and the state's vague statement to the otherwise is not supported.
All right, I'll grant the request. Where would the parties like to have it? When would the parties like to have it read?
Your Honor, should probably go after the self-defense instruction.
All right, is that acceptable, Mr. Wiggs?
Yes, sir.
All right. All right, I will read it after the self-defense instruction. State, please include that. And I think we have the verdict forms remaining. We have count 1 and count 2. Count 1, is it acceptable as drafted? Yes, sir. Okay. And so verdict form count 1 is acceptable to the defense. Verdict form count 2 as presented.
Judge, I'm going back. Let's go back.
Yes, sir.
Verdict 1. Was the defendant in actual possession of a firearm? I think you need to put the language in there that was used in the commission of this crime. She's not guilty of just having a firearm in the house.
Well, no, that's not. So it says, if you checked A, please answer the following questions. So clearly, if the jurors determine that Ms. Shaver is not guilty of second-degree murder, they do not proceed to 1, 2, and 3. So as phrased, it is appropriate and properly worded. All right. Then we're on to count 2.
Okay, guys, I need some opinion. How does that look?
That's fine, Judge. Count 2.
Toxic.
And I believe that concludes the jury.
Are you a foster parent?
Yes, sir. As it relates to accessory after the fact, and the way the standard instruction and is tailored discusses
Prayers for you to get that done, and thank you for what you're doing.
Underlying events that they were being accessory to. That's why I included the accessory after the fact manslaughter. Suppose I actually change that to accessory after the fact manslaughter with firearm, and then accessory after the fact manslaughter on
Take down my logo. What do you mean?
We have to include accessory after the fact instructions that refer to the manslaughter instruction. We will add that as lesser included to the accessory after the fact of second-degree murder, and we'll submit those with our final instructions.
All right, and the numbering or lettering on the verdict form as to count 2, there's
The logo at the top corner needs to stay, because if I have a deaf person that comes across this, they see that, they know I can sign, and that means I can interpret, and all they have to do is ask.
a D in there, should be a C.
Yes, sir.
God love
All right,
you,
anything
child.
further? Before we call the jury in, let's take a 5-minute comfort break. Thank you.
Well, There's no caption, and when there is, I'll modify. I get what you're saying. Yeah. So, like, if we go here, play.
Relevant to this case.
Oh, they don't have captioning. Sorry. Oh, okay. So this is captioning. So we're gonna zoom. Let's zoom. Play.
I'll let you know who those witnesses would be. It looks like there's a couple witnesses that have been engaging in social media on this cause.
Right?
Okay, if I can approach witness.
And what are their names?
Well, Mr. Philbrook said his wife doesn't go by.
You want the sidebar to go on, or you want?
I don't care.
Okay. All right.
There's this Philbrook. Right. She goes on social media by Philbrook. Okay. And they have like okay. Uses the name Philbrook. Miss Jimenez, she's on the internet as well.
Her first name?
Hey, Robin. Yes, bless you, Miss Toxic.
Yes, sir. Let's do that. Can you bring it first, please? Please come up to the witness stand. Good morning. All right, please be seated and let me know when you're ready to proceed. Okay, please state and spell your full legal name. Okay. Thank you. Please raise your right hand. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? All right. And have you yesterday or during this week viewed any broadcasts of the trial? Okay. So only over the weekend, okay? But no picking or selecting of jurors occurred over the weekend. That began on Monday morning, okay? So you did view some broadcasts regarding the case prior to trial. Okay. And did you go on social media and post anything concerning the case? Okay. Did you view anything about the case on social media? All right. Does the state wish to inquire?
Mrs. McManus, anything that you have seen at this point, would that be news reports about the case?
Not news reports, just it, like, I'm sorry, just stating news over Channel 9, stating that there was a trial going to begin, and that's it.
There has been live stream of testimony from this case on Court TV and maybe other sources. Have you watched the testimony of any of the witnesses that have testified this week?
No, sir.
Mr. Wiggs?
The rule of sequestration was invoked at the pretrial, and the evidence we submitted to the court shows that she has been engaged looking at and discussing the matter with other people on the internet. We believe that is a violation of the rule of sequestration.
Do you have that document? Show that document to the witness, if you would, Mr. Wiggs. It's up here. You may approach.
Yes, sir.
This shows communication on a date specific at the top of this, and communications transpiring, correct? And your name is on that document,
Down here, sir?
correct?
Yes.
Okay, and there's discussions about the case on a particular date referenced from this communique, correct? So while this court case was open, the rule had been invoked. There was to be no discussions by any witnesses and no reviewing of social media. Um, when did you look at this?
I did not, sir, but
Okay.
my,
Let me ask, why does it
Yes.
have your name on
because my daughter and my husband, they all use my phone.
it? Okay.
But I did not because I got an email from somebody from the state attorney saying not to look at that. And that was, I think, on Tuesday or Wednesday, something like that.
And you have abided by that
Yes.
request, correct?
Yes, sir.
All
I
right.
think that's sufficient, Judge. The state wants us to assume just because there's an internet browser in this household, nobody else had access to it, nobody else could internet it or enter that same site. That's the inference they want to inform the jury about. I'm not satisfied. I ask that Ms. McManus be excluded.
All right. Anything further from the state?
Can we excuse, is there going to be any more inquiry of Ms. McManus?
State have any inquiry?
Let me ask.
I have no more. I do have cases in the rule. I'm just, if Ms. McManus can go back outside.
Mr. Wiggs asked for a minute to
One moment.
review documents. He may have some additional questions.
I want to know who in the hell has he hired to sit there and do this search? Oh, Lord have mercy. Y'all. Mm, I gotta get me some meds. This is pain, pain, pain. Oh, I didn't save it the way I wanted. Mm. So I understand that sometimes, um,
11:55 this week, correct?
I don't know. I do have my phone and I can.
My client has her phone record showing that. Judge, I don't, but we know it's during this week time. That's when we found it and discovered it. She's acknowledged that people within the household, she declares were using her phone. I'm not satisfied with that. Yes. And my client has her phone records.
All right. And Ms. McManus has testified under oath that it was not her, but a family member.
Right, that doesn't seem
like
to
that better.
jive with the state when my client testifies to those same facts, Judge.
Is there any more inquiry?
Not as
Further,
big.
Mr. Wiggs?
No, thank you.
You may step down from the witness stand. Thank you.
Your Honor, I do
Please
have
remain outside the courtroom.
the Florida statute 90.616, which deals with rule of sequestration, along with Hines v. State 719 Southern 2nd 358. Provide those to the defense and court. The rule of sequestration only extends to the viewing of testimony. Watching news reports or anything like that is not contemplated by the rule of sequestration. And in Hines, the court points out that the appellant correctly, this is from Head Notes 1 and 2, appellant correctly argues that the trial court
Toxic.
A trial court must first determine whether the testimony of a witness would be substantially different after having heard the testimony of other witnesses in violation.
Wow.
To determine whether the violation was intentional or inadvertent, and if intentional, whether it was the witness, party, or attorney who acted in bad faith. Once it has been determined that the circumstances surrounding the violation, the trial court may then exercise its discretion
Aww.
whether or not exclusion of the witness is necessary. In this case, the testimony of Rena McManus, she is the teacher of Isabel Shaver during the calendar year in question, and she is just going to testify about the child's demeanor, and that there was never any period of time where there was any sort of change. And also I have the school records of Isabel showing her attendance, her grades, things of that nature. So there's no evidence that she has actually viewed any testimony in this case. Whether or not she or someone in her family liked a post about the case does not warrant exclusion in this case.
Mr.
Well,
Wiggs?
to the court, Judge, the data, the information she's looking at is court TV. It's not just a little blog from one person to another. The heading directs that she's observing this. But that she's observing the trial matter as it's proceeding. It's not just a little blog from one person to the other. So I believe the witnesses violated the rule.
Let's not talk about the bio family.
Motion to exclude is denied. As to Ms. McManus. Now we're on to Ms. Urbanowski.
Thank you, Toxic. When you get a chance, go into my Discord, scroll
Good morning.
down.
Please come up to the witness stand. Please be seated. Make yourself comfortable.
Real quick, while we got you before you have to get going, please go into my Discord, scroll down under mods, look for live communication, and read my note, please. And blessings and good luck.
And let me know when you're ready to proceed.
Who is this?
Are you all set? Okay. Please state and spell your full legal name.
My name is Rebecca Urbanowski. It's Rebekah. Last name is Urbanowski.
And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please proceed.
Ms. Urbanowski, have you viewed online any of the testimony of any witnesses in this case?
No, sir.
Did you have a Facebook profile?
Yes. A business and a personal. Yeah.
And there was a reference, I believe it might have been a like on a Court TV post with your Facebook profile liking the post. How did that come to be?
I'm not sure. I scroll pretty fast when I'm going through Facebook, and a lot of the news channels were covering this. If I might have hit that, then that's my fault. I don't know, but
Even if you were to like posts such as that nature, that doesn't necessarily mean you viewed the video on it, correct?
correct. No, I did not.
Have you viewed any of the testimony in this case?
No, sir.
All right, Mr. Wiggs.
Have you been looking at court TV?
I've seen some, not this week. I've seen some, not this week.
That's your name, Rebecca Filmer?
Yeah, it's me.
Okay. And Rebecca Filmer on this one, correct?
Yeah, it's me.
And that says court TV up there, correct?
Yeah, that says Court TV.
Okay. You go by Urbanowski?
That's my legal name, but I go by Filmer.
Okay. Yeah, we heard different from your husband this week. But this would have been Wednesday?
Who in the hell is
Okay.
providing him all of this?
If that's what it says.
Is that correct? You think?
I
You don't know. Okay. So we'd ask these be admitted into evidence, and because of the questionable nature.
Well, as far as the hearing, that is fine.
All right.
Because, yeah, correct.
So admitted into evidence as to the hearing only, not as to the trial. And What exhibit are we up to?
I think this would be exhibit one for
Purpose of the hearing, this will be it'll be a composite of three documents. It'll be defense exhibit A. It'll be entered into evidence without objection as defense number one for the purposes of this hearing only.
I don't have any further questions this morning.
All right, and please proceed. You have further questions? Okay. All right, you may step down from the witness stand. Please remain on standby outside of the courtroom. Thank you. All right, proceed with argument, Mr. Wiggs.
Because of the sensitive nature of the case and the clear instructions of the court to every juror and the obligation of the state.
Are you kidding me?
And this matter has proceeded more than once throughout the trial. The state has had ample opportunity to properly advise the witnesses not to be talking. I know the court repeatedly questions the jurors whether or not they should look at that. They don't look at anything. This woman was not responsive, not definitive as to those questions. Yet we have physical evidence that's now in evidence that she has been viewing objects. We ask that she be excluded from this cause.
All right, state's position.
She gave definitive evidence that she has not actually viewed any testimony of the case. That is what would invoke the rule of sequestration and the inquiry. And there has been absolutely no testimony about how that would have impacted or altered her testimony in any way, even if it had been viewed. So therefore, the request should be denied.
Motion to exclude is denied. Is there anything further before we call the jurors back in?
No, Your Honor, not from the defense.
State?
No, sir.
All right, let's bring the jury in. Thank you.
Okay. I'm going to mutt while they do that. Okay, guys. Been fine tuning this little banner. That way it can hide the logos on the left and right. Oh my God. Woo. Thank you, Toxic. And good luck with the wee one. I'm so grateful for people like you. I was in the foster care and in orphanages, etc., for the first almost 5 years of my life, just shy of 5 years. So, someone did what you're doing for me when I was a baby. I was 7 months when I went into the system with my twin brother. But I have a special place in my heart for you, love. I really do. I could not be a foster parent. I get it's too too close to home for me. I'm sure I can get used to it, but oh, someone asked about my shirt. I am native. Oh, sorry.
Anything about the case? Everyone has answered no.
Okay, he's doing that real quick. I'm native and Irish, and native women are the number one missing, uh, wrongfully taken and forced to do things they don't want to do women in the nation right now. So I support my sisters.
All right, then the defense has rested. State, you may proceed.
State calls Rena McManus.
Lourie can. She's the defendant. But somebody else is because they're going deep.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus, RHINAMCMANUS.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
She needs to comb her hair.
Hi, my name is Rena McManus.
Do you know Isabel Shaver?
Yes, I do.
How do you know her?
She was my student at Pine Ridge Elementary.
And what year was she in your class?
She was in my class in 2016.
Would that be the school year then going from 2015 into 2016? Please introduce yourself to the jury.
Hi, my name is Rena McManus.
Do you know Isabel Shaver?
Yes, I do.
How do you know her?
She was my student at Pine Ridge Elementary.
And what year was she in your class?
She was in my class in 2016.
Would that be the school year then going from 2015 into 2016?
Yes, it is.
Now, what grade did you teach then?
First grade.
How old are students in first grade generally?
Generally 6 or 7 years old.
And did you know Laurie Shaver?
Yes.
And what about her father, Michael Shaver?
Yes.
And how did you know them?
I had met, they were parents of Isabella, obviously, but I had met them both meet the teacher that school year.
And both Michael Shaver and Laurie Shaver attended that event?
For meet the teacher, yes.
And how were they acting during that time?
Normal parents, inquisitive about how the year would be, wanted to find out about me and the curriculum. It was very pleasant.
Now, over the school year that and you were dealing with Isabel Shaver, she had good attendance,
Yes.
good grades,
Yes.
and did you ever notice any issues with her?
No.
Was there any time that you saw some sort of behavior change in her?
Not at all.
Any time where she appeared to become more withdrawn or acted in a different way?
No.
Going to go ahead and at this time admit the records, school records of the children, showing defense states MMM for identification. Around the state moves into evidence, states MMM as the next numbered exhibit, as a business record.
Dang.
Proper business record certification and notice.
Wee bit loud.
I believe we're up to 65, correct? Okay, thank you. Any objection?
Judge, no objection.
Without objection, states MMM will be admitted into evidence as states number 65.
And I'm showing witness red number 1205 on the bottom. You recognize these as the records for Miss Shaver while she was in your class.
Yes.
And does that confirm everything you've been saying about attendance, grades, no behavior problems, things of that
Not at
nature?
all. Yes, it does.
Sorry, y'all. Had to get the fan on.
Throughout your teaching experience, do you encourage students to talk to you if they have any sort of problems?
Yes, of course.
And did she ever talk to you about any issues that she had at home?
Never.
Did you also teach her brother Aiden?
Yes.
And when was that?
2 years later.
And how was his behavior when you were teaching him?
Just like hers. Sweet.
Nothing further, Judge.
All right, thank you, Mr. Wiggs.
How old was Isabel?
7.
7 going on 8?
I'm not 100% particular about her birthday.
Correct. Okay. What degree do you hold?
I have a master's in education,
Anything else?
my teaching degree.
Okay. You have a degree in psychology?
No, sir.
Okay. How large is your class?
Usually from 17 to 20.
Okay. So you're here talking about the mindset of Isabel
That's small.
Shaver,
Ours has up
correct?
to 30.
Well, I'm talking about not her mindset, but the behavior that I witnessed.
Right. Okay. And your mind may reflect your behavior to a sense, correct? Okay. Your behavior actually may be shielded by other events in your life, correct?
My behavior?
No, anybody's.
Oh, yes.
Okay. They may want to lock up, they may want to be quiet, correct? Isabel was relatively quiet, was she not?
Yes.
Okay. Do you hold any degree in psychology?
No, sir, I don't.
Any degree in sociology?
No, sir, I don't.
But they are
How
trained to
large is your
notice
class?
behavioral differences.
Goes from like 16 to 20 students.
How many sit downs did you have with Isabel Shaver on a one on one?
Many.
Any?
Most, it's all academic, so we do small groups.
No, I'm not talking about a small group. I'm talking about you on one with Isabel Shaver.
In what manner, sir?
I'm just asking you, did you have any one one sit downs with Isabel Shaver?
In processing education, the way we teach, yes, sir, I
Um,
did.
You sat with Isabel Shaver individually without anybody else around.
That's not what I'm understanding
I
from
don't
you.
know.
So I have
What?
never.
No, ma'am. Let me ask.
Objection.
Please allow the witness to finish answering. You may finish your answer.
Sitting on a one-on-one in a room isolated, that's not what we do.
Correct. I don't care about what you do. I'm just bringing that point out. You didn't do that.
I
Hey,
think you
quit
should
being
care
a
about what I
jerk.
do because I'm a teacher.
Ma'am,
Okay, sir.
you're not sitting there with Isabel Shaver doing any kind of psychological analysis.
No, sir, that's not my job.
Okay. You don't have a degree to do that, correct?
No, sir, and I would not.
Correct. Thank you.
All right, state.
Mr. McManus, would you have individual conversations with all of your students throughout the course of a year, although other students may have been present in the room?
Yes.
Nothing further, Judge.
Thanks. We have no further questions.
Should be released from our subpoena.
Yes, sir.
Thank you for appearing today. You're released from further testimony. Have a good day.
She's like, I'm out of here.
He calls Jared Strickland.
There is no reason for him to be a jerk to her this early in the morning. I can't handle it this morning. He is a patronizing fool. Here's my frustration. Cross should have redirect should have handled this. Even though teachers don't have a degree in psychology, they must study psychology at least 2 levels to 3 levels. They are trained and they learned how to recognize physical and emotional changes in behavior. My father was a teacher. They are trained in some level a little more than the average Joe. And if she saw anything concerning or different in the child, that's when you go get the school counselor. Yeah, I agree with you, Ronnie. There is no way that little girl could walk into that school at 7 years old unless she's a psychotic. Mm. I'm not going to do that because I'm not going to. People, there are people who have the conditions and they can't control it, and I'm not going to say it. But my point is this: there is no way humanly possible that you can't go and get a degree in teaching and not have a certain level of psychology courses because you use some of that in observing and viewing and understanding where your children are. This pisses me off. That guy's a certifiable ass. Oh, I have a stand that I'm trying to use and it's very difficult. Oh, let me do this. I'm going to come off camera for a split second. Well, no, I'll get this up and then I
Good
will.
morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
Never, never ready to proceed. Oh, PD.
All set? Okay. Please state and spell your full legal name.
Jared Strickland, Jarrod, STRICKLAND.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you
Is
give
that
today
correct?
shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
I'm sorry, I can't get these names. Don't be mad at me, please.
Good morning. All set? Okay. Please state and spell your full legal name.
Jared Strickland,
Got it.
JARRODSTRICKLAND.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Thank you. Please proceed.
At this point, I'm pretty sure the jury knows you, but can you reintroduce yourself?
Sure. Corporal Jared Strickland, Lake County Sheriff's Office.
We've been having various discussions about Facebook profiles. The last section I want to cover with you did you view various pictures of Laurie Shaver and child Isabel Shaver from November of 2015 through May of 2016 on Laurie Shaver's Facebook?
Yes, I did.
Showing defense was previously been marked for identification as states 10 and 10. Showing the witness was previously been marked for identification as states N and N. Do you recognize those photos?
Oh,
And are those photos from the Laurie Shaver Facebook profile that
my lower
They are.
back is killing me, y'all.
and into evidence as the next number exhibit?
All right, that would be 66. Any objections?
Yes, Judge, a standing objection as to the motion regarding additional data and the relevance issues we raised previously.
All right. The objection is overruled. States NNN will be admitted into evidence as states number 66.
And Detective, it's easier to reference the posts from the packet I gave you and publish. Good. So this first photograph that we are looking at, when was that posted?
November 18th, actually November 16th, 2015.
Approximately 6 days, approximately a week after the last known sighting of Michael Shaver.
Correct.
Moving on to the next post, when was this photograph posted?
November 21st, 2015.
Have a series of I believe this is about 6 photos. When were these posted?
Are these the pictures with the cookies?
Yes.
November 22nd, 2015.
And that would extend on to the picture that appears to have a gummy worm coming out of her mouth, out of her nose.
I don't know if I'm in order.
I know, right, Jules? I hate this.
Photo here is part of that same people post, correct?
What I really hate is how the defense attorney is treating these
Yep,
witnesses.
there it is.
It's like, dude, really?
I believe that those are, the dates are out of whack. Looks like the end of March 2016.
And then the photos here, first of all, this
Good morning,
photo
Jules.
starts with page 1828, goes on to the photo
Get
1829.
on the mic.
You have the date for the post. Actually, I'm going to go over to
May 3rd, 2016.
Finally,
Hi, beloved.
picture of her in the black dress, the post that went along with that. When was that posted?
May 19th, 2016.
Going back to the excavation of the Shaver residence, were you involved with contacting Miss Shaver after the warrant had been completed?
Yes, I was.
And how did you contact her?
By phone.
So she was not in any sort of custody.
That's correct. She was not.
And when you were calling her, what was the purpose of that call?
To let her know that we were finished with the search warrant and that she could return to the house, and also to let her know the items that we had taken.
And at that time, were you asking her any questions, or were you just informing her of those facts?
Just informing her of those facts.
Showing the defense what has been previously been marked as states AAA for identification. Showing the witness states AAA. Do you recognize that?
Yes, I do.
And what is it?
This is a CD copy of the phone call that I made to Miss Shaver.
How do you recognize that?
It has my initials on it.
And have you reviewed it and listened to it before initialing that?
Yes.
Is that a fair and accurate reporting of that conversation?
Yes, it is.
This time the state who states AAA into evidence as the next numbered exhibit.
Is there any objection?
No objection. We just object irrelevant.
Objection is overruled. States AAA will be admitted into evidence as states number 67.
You're going to ask to publish?
Permission granted.
We're good. I can always reload it, Kristen, from StreamYard if I need to. Just copy and paste. So we're good. Exactly, Ronnie. There was no obvious changes in behavior. Just saying. I know. I can't, Swamp Girl. I have got the court gained up so much, and there's nothing I can do about it. It's frustrating as hell. Nothing I can do, babe. I apologize. I really, really do. I don't know what else to do. Wish I did. Ugh. How? Oh. Who in the hell are they calling? Case one, they just have done jury instructions. They had a teacher come on and testified. She didn't notice anything unusual. That's about it. And the defense attorney is being a little ass. Oh my God, I figured it out. I've been trying to figure this out for like ever. I figured it out. I got a border around me. It's too dark. I gotta fix it.
During this phone call, did you inform Ms. Shaver there was human skeletal remains found on the property?
I did.
Did she react in any way?
No, she just said okay.
There was some mention of
I like it when I learn something new.
pesky cards, things of that nature. Were those ultimately reviewed to see if there was anything relevant about the time frame of this homicide?
Yes, they were.
And was there anything relevant on those various electronic items that were?
There were not.
Nothing further, Judge. Mr. Wiggs, just a minute, please.
I'll return in a second.
May it please the court.
Yes, sir. Please proceed.
Deputy,
Corporal.
Corporal, sorry. You were quite polite on that call, correct?
Excuse me, I can't hear you.
I believe you were quite polite on that phone call, don't you?
Yes, sir, I do.
I believe that Laurie Shaver was quite polite on that phone call, don't you?
Of course.
And I don't believe we heard any confession of a crime or any implication of any guilt on that phone call, do we?
To repeat what I've tried to say for the last 2 days.
No, sir.
Whenever you take
No,
all
sir.
of the evidence as a whole,
Sir, please answer the question directly.
As to this phone call, do we hear any confession of guilt?
I didn't ask her.
No. Do we hear any confession of guilt?
No, sir, you do not.
Very well. Thank you.
Thank you. State? All right, sir. Thank you for appearing today. You're excused from further testimony. Have a good day.
State calls Kendall Davidowski.
morning. Please come up to the witness stand. Please be seated. Make yourself comfortable and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Kendall Davidowski, KendallDavidowski.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Thank you. Please proceed.
Can you please introduce yourself to the jury?
Kendall Davidowski.
Did you know Michael Shaver?
Yes, I did.
How did you know?
We originally worked together at Spaceship Earth over at Walt Disney World from November of 2014 till about May of 2015.
And what was your position?
24. Originally,
God.
You're gonna hate me.
Thank you. Please proceed.
Sorry.
Can you please introduce yourself to the jury?
Kendall Davidowski.
Did you know Michael Shaver?
Yes, I did.
How did you know?
We originally worked together at Spaceship Earth over at Walt Disney World from November of 2014 till about May of 2015.
And what was your position?
I was an electrical apprentice at the time. He was a mechanic.
And at the point that you met him, where was he?
He was living at the Warbirds hangar in Kissimmee.
What is that?
It's a airplane hangar. I mean,
And do you know Laurie Shaver?
I know of her. Yes.
Well, I'm glad you made it, Miss Karen.
At the time that you met Michael Shaver, well, let me ask you this: at some point, did you start a dating or physical relationship?
Yes, we did.
And what was the status of his relationship with Laurie Shaver while he was living at the hangar?
They were separated at the time.
Now, are you aware of what caused Michael to separate and move into that hangar?
I was told.
State response.
Can we approach?
Sidebar, please.
What? Y'all, we're gonna have to have a boom boom catch up. Sarah Boone has a motion to strike the defendant's notice of intent to rely on defense of the BDS and the motion in limine and the state's motion for examination. Oh, jeez. Okay, while we're in jury watch, we're gonna go through all of the latest Sarah Boone. I've got so much stuff on her, it's not even funny. So during verdict watch, we're gonna go through and watch and do all that stuff. Okay, that's live. OMG, y'all. OMG. Britta, not really a whole lot. We had a teacher get on the stand, testify that they were quiet, sweet young children. Everything was fine. And then the only thing you're missing is a lot of spice and sass from the defendant's attorney. And then so the teacher basically stated that the kids were good, no issues, that kind of stuff. What the hell is going on with my hair? Thank you. She can't. She's incompetent to represent herself, but not incompetent to withstand trial. She has shown more times than we count through her letters and appearances that she is capable of understanding what's going on. So she screwed the pooch on that. I'm not sure. Who don't like you that much? You're doing, Jules, you fabulous. Boy, at least do it. I'd rather them turn the sound completely off. Oh, the state is rejecting the battered spouse incident. Yeah. So we're going to go over all of that during the jury verdict watch. We'll go read all of it. You're right. She's not stupid. She's manipulative, used to getting her own way. He is an attorney. I don't disagree with that, and he is doing his job. I just think that there's a time and a place to push a witness and to be a little bit, but that teacher just got on the stand and he laid into her. I'm like, dude, too early in the morning for this crap. Oh, Sarah Boone has 3 lawyers now? Who's the freaking 3rd lawyer? Yeah, I know. I was talking about this Kate, not the Sarah Boone case. That just reminded me I wanted to say that. Who's the 3rd lawyer? Someone pray tell? I haven't read all that yet. I got to get to reading. I think in some ways Lori is that way. Honestly, if they're sitting there, they've got some of it. Okay? Just saying. If you're sitting in that chair and behaving the way you is, yes. But I think Sarah Boone is far worse, just in my humble opinion. The attorney, her primary attorney did state. I got to bring this down. It's driving me crazy. It keeps popping up. There we go. I don't mind if my hat's cut off. I just need more chin room. Her attorney did state that he was going to have to bring on multiple attorneys to help with the defense because he only had 30 days to get ready for trial. So having other attorneys on the team is not surprising. They're coming in and helping him out as a courtesy. But what so that to me is okay. I'm not surprised by that in the least. And I don't have a clip. Do I have a hair scrunchie in here? Yes, I do. So that doesn't surprise me. But what surprises me is where in the hell is that money coming from? All right, guys, I'll be right back.
The events that led to
Come on, baby girl.
He had told me why he was, yes.
Go.
was that related to his arrest or domestic violence?
Yes, it was.
Now, did he talk? And I'm not going to ask you to say what he told you about that event, but did he explain what had happened that night to you?
Yes.
Based on that, did he express fear of Laurie Shaver or his safety?
Yes, he did.
And could you explain that?
He was concerned of his safety and the children's safety with Lori and a gun.
Laurie, what?
And her having a gun.
Now, did you ever see Michael Shaver interact with his children?
I saw him interact with his son, Aiden, once.
And how was that?
They seem to get along very well.
And at some point did your dating relationship with Michael end?
Yes, it did.
And when was that?
About April of 2015.
And who ended it?
It was kind of mutual decision. It was just becoming too much at that point.
And at that point, was he trying to reconcile with you?
To my knowledge, yes.
Did you remain friends with him?
We weren't friends. We still worked in the same area, so I mean, we were cordial, but we didn't speak to each other.
After he went missing, did you make attempts to reach out to him to see where he might be?
Yes, somebody from Spaceship Earth had contacted me, seeing if I had contacted him or heard from him. I had not, so I reached out to him around November of 2015.
And did you ever hear from him?
I believe he said that he had left and that his children, or he just left the children. But at that point, I didn't know if it was actually him or not.
You and Ed, well, first of all, was that a phone call
It was through Facebook. It was through Facebook Messenger.
And had you interacted with him at Facebook before?
Previously, before May, yes.
And when you guys were dating?
Yes.
Was there anything unusual about the contact and the contact that you had with him in the content photos?
It just didn't seem like him to just up and leave. He spoke so highly of his children, so I didn't see that happening. And it was very short. It was just all very short, one-word answers. So that was not usually like him.
And have you ever initiated any sort of sexual harassment claim against him?
No.
Nothing further.
Mr. Wiggs?
You never filed a sexual harassment claim against Michael?
No, I did not.
You know anybody that did?
I had a sexual harassment claim filed against me.
You're sexually harassing people?
Supposedly, yes, according to
Okay.
Disney.
How long did you date Michael?
From about, I would say December of 2015, December of 2014 to April 2015.
So you heard Michael's version of events,
Yes.
correct?
Yes.
Did you see any physical? Did he show you any photos of any battered women? He showed you any police reports involving Michael Shaver? Did you ask him about that?
We had a brief conversation about it.
Okay. Did you ask him about any involvement with law enforcement or any agencies? You know who killed Michael Shaver?
I did not.
Thank you.
Redirect.
Ms. Davidowski, was anyone involved with this case involved with making that claim against you?
According to Disney, it was Laurie Shaver.
Nothing further, Judge.
Any follow-up? Thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Robert Sellers.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
I'm ready, sir.
All right, please state and spell your full legal name.
Robert Sellers, Robert, last name Sellers, Sellers.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Please proceed.
Please introduce yourself to the jury.
My name's Rob Sellers. I'm currently an FBI agent. I was a Lake County Sheriff's Office deputy for 5 years, and that's how I'm involved with this case.
In 2014, what was your position with the Lake County Sheriff's Office?
At that time, I was on road patrol, assigned to Sector 3, which is the southern portion of Lake County.
And what will your duties be as someone on?
I'm his road patrol, just like the guys and gals that are on the street now, responding to 911 calls and answering calls for service in the southern portion of the county.
Now, did you have an opportunity to come into contact with Laurie Shaver and Michael Shaver in September 2000?
Yes, sir, I did.
Were you the arresting officer of Michael Shaver from December 2000?
Yes, sir, I was.
And when you got there, did you speak with both Laurie Shaver and Michael?
I did. I spoke with Lourie first and then ended up making contact with Michael a little bit later on.
Fair to say that there's first contact.
Yes, sir.
Now, were there photographs taken of both Laurie Shaver and Michael?
Hello, Britt.
Yes, sir. I believe Deputy Suttles took those photos.
I'm showing
We
you
appreciate you too, La Jules.
QQQ.
All right, sidebar, please.
Yeah, I agree, Jules. They're probably already making a show about all this. Tony Henderson is the new attorney. Okay. Well, thank you, Alita. Thank you. Ooh. Mm, mm. Coffee. I love coffee. I love tea. I love a coffee and an ivy. Coffee and tea and the jiving in me. A cup, a cup, a cup, a cup, a bag. I so need an ivy of coffee today. Oh, I gotta take my meds. For those of you who just joining us, thank you so much for joining us. We appreciate you. Y'all are awesome. I'm sorry the kitty got scared. I'm so sorry. Jules, I'm looking forward to going to coffee with you when I can finally make it out to Florida West Coast to visit my parents. I I want to meet up with Jules too. I'd love to go spend a couple of days up there. I really would. Every time I've gone to Florida, it's been for business and I just stay at the conference center and I've never even made it to the beach. Isn't that sad? Never made it to the beach. Go figure. Well, it'll happen. I can pick you up and we can go for a week and
sir, I
go
do.
traveling somewhere.
What are those photos?
Those are photos that were taken the night of September 4th when we responded to. I guess the first couple photos are from when we met Laurie Shaver in the target
That may
parking
be
lot in
true.
Rosemont, and
I
then the
just want to
last
say
couple
I've been there,
photos
done
would
that.
be when we met Mr. Shaver at the residence, and
Give
photos
me
of the
the
residence itself in
mountains.
Claremont.
Do they fairly and accurately depict the things that photographed as part of your investigation, in this case back in 2014?
Yes, sir, they do.
Evidence is the next number of exhibit.
All right, Mr. Wade, without objection. Without objection, states QQQ will be entered into evidence of states number 68.
I've been to conferences in Fort Lauderdale and all of that, but never did anything just but the conference.
That's what
Couldn't.
been published. Photo number one.
Nolans is overrated. Smells like pee and poo.
It's Laurie Shaver.
Photo number two. What is this photo depict?
The photo of
Kristen.
her left arm,
Photo number three.
her right arm,
And photo number four. Who is this?
Mr. Shaver.
And during the course of your investigation, did you observe any sort of laceration to his head?
Yes, sir.
Photograph number five. Does that demonstrate that laceration?
That would be the laceration.
And photograph number six. What is depicted here?
The residence.
Photograph number seven. What is shown in this photograph?
Broken door to the residence.
Did Laurie Shaver give you any explanation about how that happened?
I don't recall.
Photograph number eight. What is that?
That'd be interesting to know. How did the door get broken? Who broke the door?
Photograph nine.
Two firearms that were involved in the altercation.
Photograph 10.
Be the bathroom.
The two firearms that were involved. That was something that someone was kind of having a discussion about yesterday. Yes, there were two firearms.
There's
What I want to know is why is that guy not in jail?
indication of an entertainment center that was damaged. Did Laurie Shaver give you any explanation about how that happened?
Not that I recall.
Any explanation of the broken vase that
Not-
belonged with the slide glass door?
There was, but I think there was a story from Mr. Shaver about how that had occurred.
But Ms. Shaver gave you that.
No, it's not that I recall.
Where do you live, Robin?
Did Laurie Shaver give you any explanation of how Michael Shaver got the injury to the top of his head?
Yes, sir, she did.
And what was that?
She stated that Michael had the pistol in his left hand and that they'd fought over the pistol. And while they were fighting over the pistol, it somehow went up and struck him in the head. He did.
Were there any adult witnesses present when any of this happened?
No, sir.
No. Were there any attempts to talk to any children in this case, specifically the oldest child, Isabel Shaver?
There was, yes, sir.
Was she able to tell you anything about what happened?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs?
What a name. Wigs.
We move this thing. Madam Bailiff?
Yeah, I've been to Shreveport. But every time I've gone to Shreveport, Louisiana, it was flooded and a hurricane had hit that area as a first responder. So I've only seen it with a bunch of floodwaters and me hopping out of airboats. Just saying.
I'm sorry, what do you, may it please the court?
Yes, sir.
What do you go by now? What's your,
I go by Rob, but my legal name's Robert.
okay, I know you're with the FBI now.
Yes, sir.
What's your title over there?
Woo!
With you.
Special agent, okay.
Whoa! He
Special
moved
agent,
up.
Rob, okay. Rob, when this event transpired and you went to the scene, where was Miss Shaver?
She was on her way to the substation in Claremont, and she was told by dispatch to stop where she was at, which I believe was the target located off 50 in Claremont.
Right. Miss Shaver's the one that fled the residence for her safety, correct?
From my understanding, yes, sir.
Correct. Miss Shaver's the one that fled the residence with the children to protect those children, correct?
Yes, sir.
Very well. Thank you.
Redirect?
No, sir.
I would not say yes,
Thank you
sir.
for
I would
agreeing
say
to
that
this.
was
Appreciate
my
your other testimony and Have a
impression.
good day.
Thank you, sir.
Yes, sir.
State calls Wilma Nicholas.
This is redirects, I believe.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
I believe these are the redirects. Or whatever they call it.
All right, please state and spell your full legal name.
Wilma Nicholas,
Wilma.
WILMA
Please raise your right hand.
My aunt's name was Wilma. Never heard anybody else named that.
That any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Please proceed.
Please reintroduce yourself to the jury.
Hi, Wilma.
Now, in September of 2014, was there
Get
a
on the dang
disturbance
mic.
at your neighbor's house in Chambers?
Yes.
And how did you become aware of that?
When I arrived home from work around 6 o'clock, Mike called me on my cell phone.
Not getting into anything specific that he said, but did you go over to his residence at that point?
Yes.
And when you met with him, how was he acting?
He was kind of frantic, distraught.
Did you observe any injuries?
Yes.
What was his demeanor? Was any that he said distraught?
He was really concerned.
Did he still appear to be under the effects of the event that placed him into that condition? Still troubled by whatever caused his injuries and things like that?
Not so much of his injuries as something else.
Just for the record,
Aww.
Williams basis, under the Williams rule, the matters that we previously addressed as a court.
State.
So he approached.
Yes, let's have a sidebar. Thank you.
You know what? I can't bead right now. I am shaking too dang much. Darn it. I need to get this done. Well, that's a bummer. I am just, and it's not coffee shaking. Um, for those of you who don't know, I weeded, not weeded, I power washed last night, not intentionally, my entire driveway, the sidewalk in front of the house, the walkway up to the house, the front of the house, and the porch, and my big griddle. And I just started off to just do the griddle. And now this hand, this one's steady, but this hand, from holding it for 6 hours, took me just shy of 6 hours to do it.
So while Mr. Shaver was in this excited state, did he describe to you what had happened?
Yes,
What did he describe to you that happened?
he told me he told me that they had had an argument. Laurie was intoxicated and she had taken off with the kids. The injuries that I saw on him, he said that she had threatened to kill the children, him and herself, and he fought her with the gun and got the gun, was trying to get the gun away from her, and she hit him over the head, the top of the head with the gun.
Did you see injuries consistent with that?
Yes,
Did you take pictures of those injuries?
I did.
Showing the defense what has been previously marked for identification as states 000.
Oh, 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 O'Reilly's Auto
Showing the
Parts.
witness states
Sorry,
000.
not.
You recognize these photos?
How cool, Kristen. These witnesses are coming back.
And what are those photos of?
Those are the pictures that I took of Michael and his injuries and his torn clothes.
Does that accurately reflect how Michael Shaver was when you observed him that night after he described the events that you talked about?
Yes,
This time the state moves states 000 into evidence. This is next number.
O'Reilly's Auto Parts.
Any
Sorry.
objection?
Same objection, Judge Stanton.
Objections overruled. States 000 will be admitted into
O'Reilly's
evidence. States number
Auto Parts.
69.
I had a friend who used to live just outside of Philadelphia, Pennsylvania.
Mr. Shaver, what was his approximately height and weight?
he was about 5'6", almost the same height I think as me, and about 150 pounds.
Could you go ahead and publish photograph number 1 from the previous exhibit? What were you trying to show with this photo? Can you see it?
Barely.
Let me turn it.
Okay. You can tell that he has blood coming from the top of his head and it has come down onto his shirt. His shirt has been torn in multiple areas here
Yes,
in that photo.
she did too.
The tearing of the shirt, did he attribute that to Laurie Shaver?
Yes.
Photograph number 2.
Here you can see the top of his head and the injury a little bit better here.
Did you take a top view of that in photograph number 3?
Yes.
Photograph number 4, what are you showing here?
He had the keys to her truck in his pocket and she was fighting him and tore his shorts to get the keys out, and she succeeded in getting the keys out.
And did he express why he was trying to prevent her from having those keys?
Because she was drunk and she was taking off with the children.
Nothing further, Judge.
All right, Mr. Wiggs.
May it please the court.
Yes, sir.
Do you know who was charged out of this incident with any criminal offense?
Yes,
Who?
Mike was.
Correct. So you get Michael's version of the events, and only Michael's version, correct? Correct, ma'am?
Yes,
And Michael ends up being prosecuted, correct?
he does.
Okay. So you would agree the state attorney's office had a different opinion.
Objection, Your Honor.
Abstain.
So evidently, people were dealing with Michael Shaver. Michael Shaver ends up prosecuted, correct?
Based upon,
Ma'am,
yeah,
correct?
yes.
Okay. So what you got is a one-sided interview with Michael, correct?
I have heard her myself.
No, ma'am. You spoke to Michael, correct?
Yes.
Okay. Did you interview Laurie Shaver?
No.
Okay. Do you know who the initial aggressor was that caused that injury to Michael Shaver other than what Michael Shaver told you?
I wasn't there in person.
Correct. Correct. Thank you.
All right. Redirect?
Yes, sir.
All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Rebecca Urbanowski.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to proceed. Thank you. All set.
Sorry, guys, I'm on hold with my eye doctor.
It's
Oh,
Rebecca
she's back up
Urbanowski,
again?
REBEKAHURBANOWSKI.
All right, thank you. Please raise your right hand and I'll swear you in.
She's up
You
again.
solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Please proceed.
I am Rebecca Urbanowski.
Do you know Laurie Shaver?
Yes, I do.
How did you meet Laurie?
I met her at the gym through her boyfriend at the time.
And did you work for the gym?
Yes, Gold's Gym in Claremont.
And what position did you have there?
I was a personal trainer there.
And when you say her boyfriend,
Why are you not on the mic?
Jeremy Townsend.
did you ultimately start a professional client
He's not on the mic at all.
gym where you were training?
Yes, I did.
And what was her general physical status?
This is so frustrating.
She was in pretty good shape. She had lost a substantial amount of weight on her own already, but she was in good shape, better than most new clients that I get.
Was she doing strength training?
Yes, we train twice a week.
And do you know
You
Travis?
got a personal
Yes, I
trainer
do.
twice a week?
That is my
Girl, you got money.
Who's your husband?
My husband is Austin Filmer.
And when did you get married?
October 28th, 2016.
Now, did you legally take his last name?
Get
I
on the
did
mic,
not.
lawyer.
So on your driver's license, it says Rebecca Urbanowski.
It still says Urbanowski, yes.
Have you ever had any sort of social media profile where you had the Filmer last name?
Yes, I have, yeah.
But if it were said that you never took his last name, that would be the correct statement.
Legally, no, I never took it.
Did you ever socialize with Laurie Shaver and Travis Filmer?
Yes, I did.
And when did they start dating?
I don't know a specific date that they started dating, but I know that they were in contact after they had initially met and hung out.
When approximately did they meet and start hanging out?
This is the other
They met
woman.
the first time at the end of February of 2016.
And when was this compared to when she was dating Jeremy?
It was kind of in like that gray area, I think. When Travis and Laurie first met that night, Travis had already had a girlfriend at the time. So after that night, they actually left. We had gone to Old Town, and Austin and I were kind of dating at the time, or starting to date. And both the boys came, and Laurie and I had been there. And when Austin and Travis showed up, Travis felt it was uncomfortable because he had already had a girlfriend at the time. He didn't want it to look like a double date. So they left probably 20 minutes after getting there.
The period of time when she was dating Jeremy, was there like a hard break to that? And then Travis came in the picture. They kind of overlap. What was the deal there?
They kind of felt like they overlapped. So it was kind of a gray area where when one stopped and then the other one officially began.
At some point, did you live with the defendant?
Yes, I did.
And is that at the residence in Claremont?
The Sandy Pines, correct.
And when did you start living with her?
That would have been May 7th, 2016.
And at any point while you were there, would Jeremy come over, stay overnight, or anything like that?
Never overnight. I've only seen him there one time when I was there, but I hadn't moved in at that point.
And like, what time of day are we talking about when Jeremy would come over?
It was during the day, during the afternoon time.
Around her lunch break?
Yeah, I would say so. Yeah.
And while you were living there, did you see Lourie with multiple phones?
Yes, I did.
And what was her phone number at the time?
Um, Offhand, I can't say exactly what it was. I just have the one that I have now.
Is that the same number that you had back then, or has that changed?
It would have changed. Yeah.
Now, during the time,
So, are they still married?
Brent
That's what I want to know.
Laurie Shaver was
Yeah, that's right. She's still married.
in the backyard around a fire pit.
I
Not when
can't
I
keep up with how
initially
many women
no.
she's, I mean, how many men and a woman she slept with.
When that occurred.
Oh, yeah, sorry. Yeah.
And were you and Austin present when the slab was placed down?
I was actually at work most of the day. When I got back, it was there because I worked majority of the day.
The during the time frame that Lourie has been with your brother-in-law Travis Phillips, has the relationship
Why are we not hearing any lawyers?
Austin and yourself
Are y'all hearing the questions from the attorneys?
Very much so.
described?
Um, we rarely see Travis anymore. For a while, we couldn't even get in contact with him because we found out that all of our phone numbers were blocked from his phone. Um, Austin and Travis have always been very, very close. They're fraternal twins, and they've been through a lot in life together. They
It's
used to
gained up
go fishing a
100%.
lot, hanging out, but we don't see anything from him, or we don't talk to him. We don't socialize. The last time I've actually physically seen him was when their grandfather passed away at his funeral. That was the last time I physically saw him.
The Did Laurie Shaver ever tell you what happened
Yes, I'm cold.
prior husband Michael Shaver?
Just that he had left.
Nothing further.
Mr. Weeks? So y'all have a bad relationship, correct?
Who?
Austin and Lori and Travis, correct?
There is no relationship.
Correct.
Sure.
So that's what you have to testify here to tonight?
Yay, my glasses are in.
That there's a
My
bad
lenses.
relationship? Bad blood?
I guess.
You lived in the residence
So,
in a certain period of time, correct?
Correct.
Didn't see a homicide committed there, did you?
No, I didn't.
Didn't see anybody being buried, did you?
No, I didn't.
did ya?
Okay. And you know there was she was dating Jeremy for a period of time, correct?
Yeah. for a
Did
little
ya?
bit.
You have sit downs with Jeremy.
I've seen him once there.
Okay. So he was at the house once. You moved out. What was the time period you moved out?
It was the day after their wedding. So it'd have been 2008, January 1st, 2000.
You're talking about Travis and her.
Yeah, Travis and Laurie's wedding. Yeah.
So were you back there when the period of time when you was dating Jeremy?
Was I back there? What do you
Were
mean?
you living with Laurie?
When I moved in May, they weren't really dating. It was kind of an up and down.
Thank you.
Redirect?
The wedding that you referred to, that was in,
Oh,
That would have been December 31st, 2017, 2016. Sorry.
and had that been you were a guest at that?
Yeah, because we were the next day we were moving into Austin and I and Kendall were moving into our new home.
Had that event been represented to you to, in fact, be a wedding?
Yes, it was.
And
mm.
she was in a white dress.
Yeah, when I had come back from signing our lease and everything, she was already in her dress.
Wedding cake.
There was a wedding cake. Yep, a dress.
Everyone there thought that Travis and Laurie were being married at that time.
For sure.
Nothing. Nothing. All right. Thank you for appearing today. You're excused from further testimony. Have a good day.
That's Katina Vasquez.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
Never. Sorry. God, dang it, I gotta quit saying sorry.
All right, please state and spell your full legal name.
Katina Vasquez, Katina, V as in Victor, Asquez.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Yes? Okay. Thank you. Please proceed.
Please introduce yourself to the jury.
Hi, I'm Katina Vasquez.
And do you know Laurie Shaver?
Yes, sir.
I do see her here in the courtroom today. You can identify her by something that she's wearing.
A black jacket.
And how did you meet Laurie Shaver?
Through Scott and Matuccio, my ex-fiance.
And do you remember approximately what year you would have met Laurie Shaver?
I believe we started dating 2006, 2007, and we ended the December 2014.
And did you know Michael Shaver?
Yes, sir.
And how did you meet him?
Through Scott.
And
I think it is
Scott,
case one because they're clarifying
Yes.
some of the information.
Through meeting Laurie through boyfriend Mike, did you develop a friendship with her?
Yes, sir.
Did you develop a friendship with Michael?
Because these love triangles got real confusing.
With her than Mike?
Yeah.
Morning, hazelnut pretzel.
To the Shaver residence
Oh, sorry.
after Mike disappeared in November of 2015.
Yes, sir.
And why were you going over there?
She said he had left, and I went over just to see how she was doing.
And did Laurie say anything to you about where Mike was?
No, just that he left in a black SUV in the middle of the night.
And did she reference anything to you about Mike's work or whether or not he was still working?
That I don't think he was going to work.
And did she tell you specifically how he informed his employer that he was no longer going? You don't remember anything about that? While you were there, did you see anything that you thought was unusual based on the story that she gave you that Mike had just left?
Yeah, all his stuff was still there.
When you say all this stuff, what do you mean?
She was in the she was on the porch on the phone, and I went to the bathroom, and like all his stuff was like still in the closet and stuff, and the car was there.
Talk about clothes, toiletries, things of that nature. Is that yes?
Yes.
Did you see any extra phones in the residence?
There was a black phone on the counter.
Now, while you were there, was the defendant trying to sell or get rid of any of Michael's property?
Yes.
And
I'll do the best I can.
She was on the back porch on the phone and was trying to sell guns. And I asked, why are you selling Mike's guns? Isn't he going to need them? And she said she bought them. They were hers.
now,
Doesn't matter who bought them, whose name are they registered under is what I want to know.
was arrested in 2014.
Yes, sir.
And how did you become familiar with that?
Laurie told me.
And what did she tell you about that 2014 domestic violence case?
At her house, she said, because Mike had come back into the home, he was living at an airport. And she said that, and I was kind of like, why is he here? Kind of. And she said that she was working with being honest with her therapist and that Mike didn't touch her. Like all the wounds were from her. She threw a vase and broke a door. It wasn't Mike, and he was actually trying to stop her because she had a gun and was trying to kill herself.
When did your friendship with Laurie Shaver end?
2017.
And at the time in 2017, when the friendship ended, did she make any statements to you relating to Michael Shaver still being alive?
Yes, sir.
And what did she tell you?
She was going to move up to Gainesville because I had a son and couldn't afford daycare. And she was going to drive up, look for houses. She got my Starbucks order, took pictures of the kids in the car, and then disappeared. Didn't hear from her for 2 weeks. Took me off Facebook. 2 weeks went by, and she finally got in touch with me and said that she panicked because Mike was in the parking lot. And she thought maybe Scott told Mike that she was coming up there and he was stalking her. And I'm like, well, why haven't you called me? And she said that the cops had her phone and the truck was at the police station because he was tracking it.
And this is in 2017 that she was saying Michael Shaver was stalking her.
Yes.
So clearly after May of 2016.
Yes.
And clearly after September of 2016 when the cement slab was put in her backyard.
Yes.
Nothing further.
Mr. Legs?
Please support.
Yes, sir.
Ma'am, did you file a letter to support Laurie Shaver on an injunction?
No.
No? You never submitted any letter to DCF?
How would you know about a letter? Whoa, wait. If there is a DCS, if they call it, we'd call it DPS, investigation, he wouldn't have that information. Well, unless he subpoenaed and the judge signed it. I don't think that happened in this case.
Did Michael ever obstruct your relationship with Laurie? Okay. Now, when you said that Laurie was selling property out of the residence, do you have any understanding whether that was only Michael's property or whether it was marital property?
It was.
That she was by law prohibited in any manner.
She just said the guns, and I know the guns were theirs. And
Okay. Do you know anything about marital labor and contribution to the marriage?
no.
Correct. So you just assume this is Michael's property and she had no right to touch it, correct?
It depends on whose name the guns are in.
They're guns. He built and restored guns. So
Do you know why the property was being sold?
no.
Do you know
That
if
was
it
a fair
maybe the
assumption.
need for groceries and necessities?
No.
Do you know if there was any plan to aid anybody with those funds to escape detection of a crime?
Nice try.
Did you ever witness a murder or any event occur at the house? Now, the event that you spoke about an incident that occurred at the house, a crime, a battery? Were you there to witness that event? Thank you.
Redirect. All right, thank you for testifying here today. You're excused from further testimony. Have a good day. Next witness.
At this time, the state of Florida rests.
Hmm.
All right, let's take the jurors out at this point. Have a comfort break.
Yes, we need a comfort break. What I need is a break long enough for me to go and get my glasses fixed. I'm hoping my prescription's right.
Jurors have exited the courtroom. Are there any motions at this time?
Yes, Judge, we'd renew our motion for judgment of acquittal.
Oh,
on the
God.
grounds previously stated. We'd also make clear
He's doing his job.
that any these acts of violence that have been spoken of have been only offered for prejudicial value against the defendant. There's no probative value. There's no notice. It's not substantive evidence established to prove a prima facie case. It's purely circumstantial. The state supplied the court with case law. In that case law, there's a notation to a fifth DCA decision speaking about any relative probative value can be outweighed by the substantial prejudice that it presents. It should not have been presented to the jury. The digital data that the state relies on is not sufficient to establish causation. It does not establish the nature of the offense. It does not defeat a claim of self-defense.
Thank you,
There's
Hazelnut.
been reference to sale of guns. There's no distinguishing that this is non-marital funds, that Ms. Shaver had no right to sell this property, nor does it advance any claim to an accessory after the fact. We'd ask that the court grant a judgment of acquittal on these grounds and all other arguments previously mentioned before the court.
All right, thank you, Mr. Wiggs. State's response.
The state most favorable, the light most favorable to the state, there's sufficient evidence to present to the jury.
Motion is respectfully denied when viewed in a light most favorable to the state. The evidence does establish a prima facie case sufficient to support a conviction as to each count in the information. Motion is respectfully denied. All right. And anything further, Mr. Wiggs?
One second.
Yes, sir.
The defense has no rebuttal.
Closing arguments. Come on.
No rebuttal from the defense. How long will the state take to print out the revised jury instructions?
I have a couple questions for clarification. They're done, Your Honor?
Yes, sir.
The forcible felonies in the self-defense instruction.
So it's 11 o'clock their time. Take an early lunch.
Correct. Well, no, wait a second. I think we've declared, or my mindset is that there is an attempted first under, by Michael against her, so the elements of attempted first. Correct.
Okay. Do you want the definition or do you want the elements?
The elements.
Yes, sir. Thank you, Judge.
All right. And is there anything further? I will read the preliminary instructions to the jurors when they are called back in.
Rich, how long are you going to put that together?
We need probably 15 minutes.
Well, 15-minute break, is that sufficient? Would you like additional time for yourself? 15 minutes is good. Okay. I will plan on a 15-minute break. Yes, sir.
I'm sorry. Do you want to go direct it? What time do you want to take up closing?
Well, and again, there are no time constraints, but for timekeeping purposes, how much time would the parties like?
ADHD jelly bean, it has been increased to the max on my end. And I mean, it's 100%. So I'm not the only one struggling with this. I guarantee it. I apologize, but there's nothing I could do
Combined,
right
it might
now.
be 3 hours.
I would say, I would, yes, at the most.
And again, please take as much time as you need. Uh, Right now, it's 10:46. We'll plan on coming back around 11, and I'll read the initial instructions to the jurors at that time, and we can go into the closing at that time. We can break for lunch after. Well, we'll see. We'll see where we get, and then perhaps after the state's initial closing argument, we'll break for lunch, and then proceed with the defense and the state's second round after that.
Yes, sir.
All right. Anything further? We'll take a 15-minute break.
Hi, Uber.
Okay, guys, let's do this. My lenses are here. I got to go get them replaced. Um, I will not make it back here, but I'll be listening on my phone. I apologize, but I will be monitoring on the phone. They only have a short time period for me to get in there. I need to be there in the next 10, 15 minutes. So, um, okay. Um, is that better? It depends if there's background noise or not. Thank you, Jelly Bean. All right. So, what else? Okay. Also, you guys, Jelly Bean, and I'm going to say this in general. It's hard for me to keep upping and downing my volume all the time. So, first, try to control it on y'all's end. And then, if you're struggling, let me know. I have no problem adjusting. But sometimes everybody's computers and technical devices are different. So, it's really hard sometimes for me to gauge that. But if I'm in generally loud, then I have no problem. So, I'll leave it at this volume for now. So I'm going to let this run and um, I'll be back as fast as I can, 15 to 30 minutes. I apologize, but I got to go get my glasses. All right, guys, I'll be right back. I'll leave my camera like this. Okay, see you in a minute. Okay, guys, we got it. Yay. Oh, so now I'll be able to monitor it, hopefully. There we go. Yay. Wonderful. Yeah, guys, I'm sorry y'all can't hear the court very well. There's really nothing I can do anymore about that. Unfortunately, unfortunately, the stream is up as high as I can get it to go. Yes, I'm getting. Oh, there we go. I'm connected. I'm going into StreamYard. Hey, we did it! Woohoo! All right. Can y'all hear me? Please, somebody comment if they can hear me, because I can't hear me. Um, I got puppers with me. We're gonna go get my glasses. Oh, yay! Okay. So what's happening is unfortunately the feed that we have is um, if they're on the microphones, everything sounds, today's the best I think I've ever heard it sound. So that's a good thing. However, the lawyers are not staying on the microphones. And so the lawyers are kind of putzing around court talking and not talking on microphone. I wish they could put microphones on the attorneys and during sidebars or it is nothing I can control more than I have. I have gained my sound 100% on the computer. I have gained the sound through the Rodecaster 100%. So that's all I can do. Um, when I get back, we will. Hazelnut asked if we will do kind of a quick run through. I will go through and hit some highlights and points when I get back. Tinte, Tinte, you gonna say hello? She's like, nope, I'm laying down. I got my puppers back there. But the thing is, I was hoping we would have already ended closing arguments today and that we would be already in a verdict watch. But my question is, did the witnesses this morning, the rebuttals, help anybody at all understand some of this information better? For me personally, I think it did. I think that, um, it just kind of refreshed my brain that there were two guns. It refreshed my brain a little more about the connections with the boyfriends and their wives. It's a little interesting. I I would be mad as a wet hen if I had to go in and testify in a trial involving the woman that my husband had an affair on me with. I guess they're still married. She said they were. Um, More power to you, honey. I don't know if I could be that forgiving. And if he's cheated once, he's probably cheated again, but I cannot label him for sure. That's just a humble opinion. That's just how I see it. But how many women, how many men did this woman have relations with? We do know that she unalived her baby. This blanket that I was using is shed all over me. We do know she's unalived the baby. And this baby, while she was married, that was not the husband's. So, how many? We know of at least 4 to 5 men Yes, yes. She testified, and I can replay parts of her testimony later, but she testified that she had gotten pregnant by one of the flames, one of the boy toys, and that she had unalived the baby, and that made him very angry. I I don't know. It's this case has more relationship twists and turns. Had I known it had all this, I would have made a chart. I could have made a flow chart. Oh, because y'all, this is pretty intense when it comes to the amount of affairs that she's had while married, and then unaliving the husband by allegations, and then the guy she's now currently married to, they had a commitment ceremony, and then years later they actually got married. I think part of it was because he was not out of his current relationship at the time. I'm very confused about some of this stuff, y'all. It's very interesting to the fact that they could do all this. It's just crazy. Okay, I am at my eye doctor's appointment. I'm going to go black screen. Hopefully we can get this done in a quick amount of time, and I'll be back on shortly.
All right, we're back on the record in case number 2020 CF 2361.
Your Honor, I made the appropriate changes to the jury instructions. I would ask that Mr. Wiggs double check especially the self-defense instructions, since there were a lot of changes made to that to make sure it's accurate.
Please let me know once you check the instructions, Mr. Wicks. And prior to calling the jurors back in, I'd like to have a sidebar with the parties and with the deputy, if you would. Okay.
Email me that. I got the phone. Oh, he's still. Is this my copy?
Yes.
Judge, do you have a statement
Hey guys, I'm waiting for them to get my glasses. Oh, I need to do that. I'm sorry, I'm back. Okay, ADHD, I'm gonna have to delete that comment because I can get in trouble for that. Don't take it personally, but you're right. I'll be back. Okay, when I get back, we'll do the long crime feed.
All right, please bring in the jurors. Thank you. right, I see that all the members of the jury have returned. Please be seated. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Laurie Shaver, the defendant in this case, has been accused of the crimes of murder in the second degree with a firearm and accessory after the fact to second-degree murder. Introduction to homicide. Laurie Shaver is accused of murder in the second degree in count 1. Murder in the second degree includes the lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Michael D. Shaver was killed by Laurie Shaver, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Laurie Shaver may be found guilty of murder in the second degree or any lesser included crime. Murder second degree, count 1. To prove this crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, the death was caused by the criminal act of a Laurie Shaver. 3, there was an unlawful killing of Michael D. Shaver by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. An issue in this case is whether Laurie Shaver did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Laurie Shaver was in fact so provoked and did not cool off before she committed the act that caused the death of Michael D. Shaver. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her guilty of second-degree murder. Possession of a... Yes, sir. I will read that again. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her not guilty of second-degree murder. Please make that correction. Thank you. possession of a firearm, and discharge causing great bodily harm or death. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime, she discharged a firearm and in doing so caused great bodily harm to or the death of Michael D. Shaver, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or the receiver of any such weapon, any firearm, muffler, or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means the defendant A. carried a firearm on her person, or B. had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included offense. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Michael D. Shaver is dead. 2. Laurie Lee Shaver intentionally committed an act or acts that caused the death of Michael D. Shaver. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm. If you find that Laurie Lee Shaver committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Laurie Lee Shaver committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find her guilty only of manslaughter. Accessory after the fact to second-degree murder. To prove the crime of accessory after the fact to second-degree murder, the state must prove the following four elements beyond a reasonable doubt. Number 1, a murder.
I agree with you, Ronnie.
2, after the murder in the second degree was committed.
Y'all, I can see!
Maintained, assisted, aided, or
Wow, I was bad.
that other person. 3, at the time Laurie Lee Shaver knew that other person had committed. At that time, Laurie Lee Shaver knew that other person had committed the murder in the second degree. 4. Laurie Lee Shaver did so with the intent that other person avoid or escape detection, arrest, trial, or punishment. The elements of murder in the second degree have previously been given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of accessory after the fact to second degree murder is accessory after the fact to manslaughter. Accessory after the fact to manslaughter. To prove the crime of accessory after the fact to manslaughter, the state must prove the following four elements beyond a reasonable doubt. Number one, a manslaughter was committed by another. Two, after the manslaughter was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. Three, at that time, Laurie Lee Shaver knew that the other person had committed the manslaughter. Four, Laurie Lee Shaver did so with the intent that the other person avoid or escape detection, arrest, trial, or punishment. The elements of manslaughter have been previously given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Justifiable use of deadly force. It is a defense to the crime of murder in the second degree, including lesser included offenses, if the actions of Laurie Shaver constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Laurie Lee Shaver does not have the burden of proving that she was justified in using or threatening to use deadly force, or that Isabel Shaver was justified in using or threatening to use deadly force in the defense of Laurie Shaver. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force in Florida is as follows. Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel Shaver was justified in using or threatening to use deadly force in defense of Laurie Shaver, if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The elements of attempted first-degree murder are: 1. Michael D. Shaver did some act intended to cause the death of Laurie Shaver that went beyond just thinking or talking about it. 2. Michael D. Shaver acted with a premeditated design to kill Laurie Shaver. 3. The act would have resulted in the death of Laurie Shaver, except that someone prevented Michael Shaver from killing Laurie Shaver, or he failed to do so. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The elements of aggravated battery are: 1. Michael D. Shaver actually and intentionally touched or struck Laurie Shaver against her will or intentionally caused bodily harm to Laurie Shaver. 2. Michael D. Shaver, in committing the battery, intentionally caused great bodily harm, permanent disability, or permanent disfigurement to Laurie Shaver, or used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. I believe there's a typo there as well. Great bodily harm, and after great bodily harm, there is another one as well. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include bruises. If Laurie Shaver was not committing any crime other than alleged murder in the second degree, or any lesser included crimes for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had the right to be, then the defendant had no duty to retreat before using or threatening to use deadly force, or before Isabel Shaver used or threatened to use deadly force. If Laurie Shaver or Isabel Shaver was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The use of deadly force is justifiable if Laurie Shaver or Isabel Shaver reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting any attempt to murder her or another or commit an attempted first-degree murder or aggravated battery upon her or another, or to commit an attempted first-degree murder or aggravated battery upon or in any dwelling house in which she or another was present. In deciding whether Laurie Shaver or Isabel Shaver was justified in the use or threatened use of deadly force, she must consider the circumstances by which she was surrounded at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant or Isabel Shaver actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. Laurie Shaver or Isabel Shaver is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using or threatening to use defensive force that was intended or likely to cause death or great bodily harm to another if a. The person against whom the defensive force was used or threatened to be used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B. Laurie Shaver or Isabel Shaver knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A. The person against whom the defensive force is used or threatened to be used has the right to be in or is a lawful resident of the dwelling, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or B. The person or persons sought to be removed is a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used or threatened to be used, or C. The person who uses or threatens to use defensive force is engaged in a criminal activity or is using the dwelling to further a criminal activity, or a person who unlawfully and by force enters or attempts to enter another's dwelling, presumed to be doing so with the intent to commit an unlawful act involving force or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporarily or permanently or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. If you find that Laurie Shaver or Isabel Shaver, who because of threats or prior difficulties with Michael D. Shaver had reasonable grounds to believe that she or another was in danger of death or great bodily harm at the hands of Michael D. Shaver, you may consider this fact in determining whether the actions of Laurie Shaver or Isabel Shaver were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Laurie Shaver or Isabel Shaver knew that Michael D. Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver or Isabel Shaver reasonably believed it was necessary for her to use or threatened to use deadly force. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Laurie Shaver, Isabel Shaver, and Michael D. Shaver. Defendant's failure to report a crime. The state has charged Laurie Shaver with the murder of Michael Shaver. Further, the state has charged Laurie Shaver with being an accessory after the fact. You must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. All right, it's about 11:30 right now. I think at this time we'll take our lunch break. Uh, Parties have anything further? State? Yeah, come on up, please.
Okay, guys. Yes, she has been cheating on him for a long time. Really has. Um, I'll see if I can get permission from Brandy to maybe us watch it live again if we have a long deliberation. We'll wait and see the time frame. Guys, I can't believe how
Questions
bad I was
for each of
seeing.
you prior to breaking for lunch. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whether the words reasonable doubt are used, you must consider Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said.
She's waiting for her puppy cup.
One, did the witness seem to have an opportunity to see and know the things about which the witness testified? Two, did the witness seem to
Watch
have an
this.
accurate memory? Three, was the witness honest and straightforward in answering the attorney's questions? Four, did the witness have some interest in how the case should be decided? Five, does the witness's testimony agree with the other testimony and other evidence in the case? Six, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Seven, has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? Eight, does the witness have a general reputation for dishonesty or truthfulness? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or part of an expert's testimony.
Hey, Pamela.
You have
Yes,
heard
she
the
does.
testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: one, whether when the defendant made the statement, she had been threatened in order to get her to make it, and two, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out of court statement was not freely and voluntarily made, you should disregard it. All right, and was that to the satisfaction of the parties?
Yes, Judge.
Okay. And at this time, is there anything further before we break for lunch?
Nothing from the defense, Judge.
Thank you. All right, we're going to break for lunch at this time. Again, please do not discuss the case with anyone, including each other. I would ask the parties to return to the jury assembly room at 12:45. So that'll give you over an hour for lunch. Thank you.
Yay! Lunch! I got lunch! Yikes! Turn off the mic. Yep, my puppers always gets a pup cup when we go by. Freddy's not sponsored. Wish you were. I eat enough of it. So anyway, that poor guy, he couldn't understand my order, and then he he got our drinks wrong 3 times. I just gave up.
Is there anything further before we break for lunch? We'll be back at 1 o'clock. All right, and we'll begin closings at that time. Mr. Wiggs, anything further? All right, thank you. We're in recess.
Okay, so 12 o'clock our time. We'll have an hour. And what we'll do is, let me get back and get my lunch in me. And then what we'll do is go over and kind of recap this a little bit. Oh, somebody asked, what is this? Yes, I legitimately have a badge. I actually have 2 of them. This style and one other. I am an emergency services chaplain of Texas, and I have a badge. Helps me get on scene when I need to. Well, I think right now, I agree with that, but, but, if the child truly was acting in defense of mom in self-defense, or, for fear of limb and life, or life and limb, as they say, then they can't give that charge because the child saved a life, I guess. I'm not a lawyer, but the thing is they also have to, there's a lot of stuff that they have to prove on that. Um, I am highly concerned for the mental status of this 15-year-old. In fact, the mother did persuade her to lie on the mother's behalf. Um, yeah, but the problem is like an attorney told me yesterday, the child, it's hard to bring that child up on any kind of charges. Number one, because at a certain age, they just don't. At that age, they couldn't charge her. Number two, for the unaliving of the father. But number two, is it misremembering, or is it out and about, out and right lying? And at that age, it's kind of hard to tell, because at the age of 7, children can be deceived and manipulated very easily, and we see it all the time. So it is a little crazy to me that they have not charged her with her, and or yeah, the husband. Yeah, they haven't charged her for the access to firearm. Then again, if she gets found guilty for unaliving the husband, then that's a mute point. They could stack a whole lot of charges on her, I know, but it would be a mute point. Okay, guys, I'm going to go off camera so I can get my lunch into the studio, and I'll eat quickly, and then I'll be back with you probably within 15 minutes. Once again, thank you guys for joining me. I greatly appreciate you, I'll see you in a few minutes. My God, y'all, mm, this is no bueno. I had no idea my eyes were this bad, y'all. I see dirt. I see friends. I see. I mean, oh my gosh, y'all. I didn't know my vision was this bad. I kid you not. I knew it was off, but I had no idea it was this off. Holy crap. I'm not having to squint. I'm trying something new. I'm trying a hamburger lettuce wrap from Freddy's. It's a lettuce wrap. Let's see how it is. Mm. Mm. That's actually not bad. I'll try to bring up. Let me go. I asked. Okay. Can y'all hear me? Because I can't hear myself. Hello, testing, testing. No, that's why. I've got to get my hearing aids connected. There we go. It's working. They're trying to anyway, trying to connect. They're not going to connect with that there. Okay, this is what I had asked an attorney, and this is why am I having this screen balance issue? Ugh. I asked an attorney, and this is what they said. Why are you not finding my hearing aids? Am I connected over here now? Jeez. Okay, they said they could bring. Oh, there we go. Yay. They could bring Isabel up for perjury if they had proof she was lying and not just misremembering. But very rare that perjury charges are actually brought because of the proof someone is lying is not remembering or misremembering. So as far as actually calling the police, it's possible they could have charged her if she did it, but some states won't charge children under a certain age because they can't prove intent. Child can't form intent. I mean, so at her age, even if she had done it, they're not going to charge her because they can't. She's too young. I asked if there was an evidence of a second shot because she said there was a second shot and two guns were retained. The lawyer said if there's evidence of a second shot, then sure. But as for evidence in this case, they don't see it yet. So there we go. There we go. And then they would have to determine which shot actually killed the victim, which that, oh my God, I'm going nuts over these glasses, y'all. So that's what the attorney said. Let me unpin this. Sorry, having to get my lower back. Let me eat real quick and then we'll start doing a little recap for those who are wishing to have a recap. I am not usually fond of burgers in the lettuce wrap because usually they don't give enough lettuce to truly keep it wrapped. Y'all, this is good. There's enough lettuce. The whole hamburger's in there. Everything's in there. And it's not too nasty as far as falling apart. A little more messier, but I'm okay with that. I'm trying so hard to cut the carbs. Mm. So that's where we is. Are y'all having lunch? If you are, what are you having? Oh, and the other reason why I don't do lettuce wraps, a lot of times in drive-throughs, they charge you more when it's lettuce is worth less than the bun. And why? Oh. Why is it more expensive to eat healthy? Oh, I'm sure you are ADHD. I've never understood that. Why does it cost so much more money to eat healthy? Now, if you're in like South America, I know some people who are down there right now, and like way south Mexico, going into South America, vegetables and fruit are super cheap compared to the unhealthy food. I've never figured it out. You complain about the obesity of this country, but you make it to where the prices of the healthy stuff are 10 times more than the unhealthy. I wish it was one time a year. Now, I got to get used to, and I had it with the other ones, but my prescription was so off that I can't just cut my eye. I have to turn my head to read and look. I can't just cut my eye over here and read it. It's all blurry. So now I've you because the center is the prime spot. But the bifocals, oh my gosh, it's going to be so much easier to bead because I know I squint. I know I squint when I bead and I get headaches, but I'm able to read this fine print on this bottle. Even with my old glasses, I couldn't read that. They said my left eye has changed dramatically. Right one, minimally. I'm like, mm, mm. I wish I had time to do that. I wish I had time to make things by scratch. I don't. I just don't. I am going to start trying to be home as soon as I'm done here, like at 6 o'clock, 6:30, and I would love to be able to cook. But now that I'm a student, mm-mm. I'm sorry if I'm a little overwhelmed at the moment. I can actually, yeah. Now I need to go clean. My eyes were bad enough that I couldn't even see these fingerprints on my hat makeup from my makeup. I didn't even know that was there, y'all. I I am so sorry for looking like I'm a unkept person. I couldn't see it. Wow. Now I get it. Eventually, I'm going to get glasses like EDB. I talked to my doctor about it, eye doctor, and they said we don't have anybody in Kerrville that does it, but they're very well aware of them, and they felt that it would really help me with the dyslexia and all that. So we're all good. Yay! And what's good is that these still have that bluing and still have the ability to okay. I can look up at that light and it's not like a blurry halo. It's actually defined edges. Hello, Brit. It very well may be. But I'm not kidding. When I used to look at my light, it was very soft edges. I didn't even see any of the defined trim around it. Wow, that's huge. Maybe I can bead faster now. That would be nice because I'm slow right now. Okay, y'all. I'm gonna go wash my hands and take a comfort break, and I'll be back, and then we'll go over some of this stuff. Okay. Thanks for waiting. I don't yeah, I can't afford those programs. I really can't. Yeah. Do you know what? I'm sorry, it startles me when I see this screen this sharp. I see every flaw. It's driving me crazy now. Um, it costs a lot of money to prepare a meal nowadays. And I tell people, I said, sometimes it's cheaper to eat out as a single person than it is to prepare food because I mean, preparing food for one person is can be quite expensive and difficult because we tend to waste because we can't eat it all, especially when you only have a stomach like mine. So it's just I don't know. Yeah, Canada's outrageously since they under mm, well, 4 years ago our food was almost half price for some items, not everything. Mm, yeah, Canadian. Oh, don't talk about sugar. Don't talk about candy. Don't talk about sugar. Don't talk about cake. Don't talk about cookies. No mas. You're killing me. And what's killing me is how sharp this is. I know I'm freaking out, y'all, but this is incredible. I forgot. Misa forgotsa. I did. I did forget how wonderful it is to be able to read and everything's clear on the screen and I'm not struggling. Let's test it. Okay, let's go and talk about the Laurie Shaver trial. Let's kind of run through what we've seen quickly. Okay, Lake County, Florida is charging Laura Shaver for unaliving her husband and burying his body in the backyard. Um, on March 18th, the investigators searched the property near Claremont, and at that point, um, Michael Shaver shared with his wife Lourie. Hmm. Let's see. Investigators found Michael Shaver's remains under the concrete slab at the property 1 month after a friend told deputies he'd not heard from the man since 2015. So this is 2018. Holy crap, 3 years? Officials believe that Laurie Shaver assumed Michael's identity over text and Facebook messages after he was deceased. Um, that's kind of what I believe. Yeah, bet, Corina. According to Lori arrest affidavit, the messages were sent from someone claiming to be Michael, even after investigations. Investigators believed that he was no longer alive. The messages included requests for family members to leave him alone, messages to his boss saying he quit his job and moved to Georgia. In a wild twist to an already bizarre murder investigation, Shaver claimed a child pulled the trigger, meaning she accused her daughter of unaliving her husband in 23. She still claims that she did not unalive her husband, but her daughter and a boyfriend at the time. The daughter did testify in the defense. Uh, the interesting thing is now the minor. I'm not going to use her name. I don't feel appropriate using her name. She's still a minor. Can re now recall that she committed this crime, and it was done so in protecting her mother. So, um, so the jury is 3 men and 3 women. So this is not a DP. This is possible life or an extended time. They began their opening statements. The evidence suggested the defendant gradually got rid of or removed Michael's property She sold his tools and his guns. She knew Mike was never going to come back. She knew Mike was no longer with us. Let's talk about the guns real quick. Okay. If you have a business or hobby building guns, there's going to be receipts who purchased all the parts. So they can find that out. But if it's a registered weapon, whoever's name is it registered in is the owner. So if I have a weapon registered in my name and I permit someone to use said weapon, oh, finally got a pop. Sorry. I allow someone to use said weapon, well, it's still mine. I'm still responsible for it because it's still in my name. It's like your vehicle. You have a vehicle, you're permitted to allow, I mean, you allow someone to use the vehicle, but you're ultimately responsible. So if someone came to me and said that they had weapons that I knew that so and so may have owned, I would not buy them from what they call a third party purchase. I would not do that. Yeah, I agree with you on that case one. There was way too much detail on that, and I also felt that the detail that was said was in a way very similar to the mother. I know it's interesting fact, but family members tend to form and shape their sentences very similar. However, some of those details should have been dove into by the DA because if you sit there and you have someone who's saying that they did it, even at the age of 7, and they're saying that he was sitting in the chair and she pulled the trigger, okay, where did you come from? First of all, where was the cabinet? How did you access the weapon? Were there bullets in the weapon? Did you have to load the weapon? Then, what path through the house did you take to get to him, and how long did that take? Were you holding it in your right hand or your left hand or both hands? Mhm. Did you have to pull the trigger, or is it one of those that you have to semi-automatic? I would have asked a whole lot more details. I don't care. She's 15, almost 16. You chose to get on this witness stand, so I'm going to treat you like any other witness. Now, if she was 8 and 9 years old, that's a whole nother story. But at 15, 16, if you're willing to get on that stand and potentially lie, I'm going to catch you in it. I thought the prosecution should have gone a lot further, and they did not. Um, Mr. Shaver, you will hear, was very positive. He was combative. I mean, he was very possessive. He was combative. He was very destructive. He imposed fear in his family over and over again, said Wiggs. The testimony continues. Um, they talked a lot about the kind of work that Shaver did, Shaver's property, the suspicious area that led officials to believe Mike's body would be found there, including testimony from family and friends. Yeah, nobody does. Um, One of the co-workers, Robert Mercado, said that Michael vanished out of nowhere, which was out of character. Yeah, if I vanish, guys, because I'm a highly communicative person, if I vanish, somebody better start looking in 24 hours. He was kind of just stopped talking to me, said he wanted to be left alone. If someone went from being my buddy at work and we're friends and everything's great and then they disappeared, they don't show up anymore, I'm getting weird texts when I try to communicate with them, I would have called for a whale check then. But a lot of people don't really understand and know of well checks. Several members of the family, Michael's family, made similar testimonies saying that he just disappeared, dropped off the face of the earth. even though they weren't very, very, very close physically. And but they did talk through the year. Different people he talked to more than others. There was no contract. My mother had got sick, was in the hospital. We couldn't get a hold of him to let him know about her illness. That was Brian's Schaefer, Michael's brother's statement. There was no contact. And in fact, that doesn't surprise me after hearing the phone numbers were changing. The corporal from the Lake County Sheriff's Office has testified about the suspicious issue with the cement slab in the Schaefer's backyard, which was where his remains were under at that point. You clearly see a depression that was approximately between 6 feet and 3 feet in dimension and about 8-inch depressed. So, what they did not account for, my dear friends, is when you put a deceased person in the ground, as they decay, everything's going to compact down. So that's why when you notice that a lot of times at cemeteries, even when they bury them the way we do now, they have extra dirt on the mound. So as everything settles under the weight and everything, and the rain and everything, it compacts and it's somewhat level. See, they didn't account for that. And then after you pour a concrete slab on it, the weight of that slab is going to go because that ground is not as dense because you dug it up versus the other part of the ground has the same density to it. So they did not take into any account of that situation happening. So I am not surprised that they saw an indent. Oh, what was a baby girl? My puppers is laying completely under my legs. I found it interesting that several times the defense kept asking the witness, "Did you actually see a murder committed?" And that they had no concrete proof that a crime was committed. Who's coming in here? Oh, she didn't. Somebody brought donuts. Um, on Wednesday, the 11th, her current husband testified in her trial. Shaver listened as her current husband testified in the trial for second degree murder. And oh my gosh, we have a visitor. Come on. Oh, never mind.
No, you got like, she knocked over your trash can.
Oh, snap. What's
Present.
this?
I don't know, present from her.
Oh, thank you, Kathy. I'll come out and see you in a minute. She brought me cake. She brought me cake. Oh, thank you, love. I'll eat it in a minute. I just brushed my teeth. I got cake. Yesterday, I had a hankering for cake, y'all. It was hardcore hankering. Um, anyway, the former husband said she called me sobbing and crying. I asked her what was wrong. She proceeded to tell me detectives showed up at the house asking about Michael. Excuse me. My thing's loosening up. Um, there we go. Mr. Filmer and Laurie got married after the disappearance of Michael, and he stated he was unaware of Michael's whereabouts and only knew what Laurie had told him. She told me that they were divorced and that he wanted nothing to do with the family, did not know where he was, and he was not around. Filmer also helped pour the slab, testified he didn't notice anything unusual at the time. Um, you didn't notice the dip in the ground? That would have been something I'd fill in. Obviously, they didn't know what the hell they were doing. He also mentioned that he advised Laurie to get a lawyer after the body was found. Earlier in that day, the neighbor testified that he had purchased a handgun for Laurie. The lead shooter, excuse me, was the same caliber of bullet that unalived Michael Shaver, but a firearm expert could not make a positive match due to the lead's poor condition. And that's not unusual when it goes through hitting bone and stuff and that period of time. It happens. Robert Popper, a mentor to Travis Filmer, recounted that Filmer had told him about Michael Shaver's disappearance. So that's interesting that you would talk about it like that. Disappearance versus, we're divorced, we've separated and gone our own way. That's the end of it. Like my ex husband and I, we never talk. I don't know what's going on with him unless I find out from somebody in his family. So the word disappearance to me is a very interesting choice of words. It wasn't a matter that he was missing, he was no longer walking the earth. That was the comment. Wow. Filmer's brother collaborated that he had heard Travis make a similar remark. Yes, they did ADH Jelly Bean. Concrete proof. I was it was hard for me not to laugh. Wednesday afternoon, Laurie Shaver's defense attorney cross-examined a detective attempting to undermine the state's case by suggesting that the discovery of the body led to premature conclusions about Laurie. Dude, ah, you go where the evidence leads you. It led her to Laurie. The state called a man who was brief relationship with Laurie Shaver around the time of her husband's disappearance. Jamie Townsend told the jury that he met Laurie Shaver at the park and their two sons were playing together. Townsend said Laurie Shaver said her husband had taken off and moved out. Townsend was having marital problems at the time, so the two started seeing one another. The defense said that Michael Shaver was abusive to her and suggested Townsend may have come over to defend her. And the state asked him if he was anywhere near the Shavers' home the time the state believes Michael was harmed. Yeah, they did. He kept saying no. Now, Laurie Shaver listened to her daughter's testimony before taking the stand herself. The 15-year-old daughter, who we will not be naming, testified. I mean, she was named, but I'm not using it. That her mother is her best friend and that her relationship with her father was poor due to his physical abuse towards the mother. Quote, I grabbed her and I quote, and I grabbed her and I grabbed her gun and I went back out and I went to the door. The door was already open and he had my mom on the ground still laying on the ground, kicking her, and I shot him, said the daughter. Well, but then didn't she say he was in the chair? I could have sworn I heard something about him sitting in a chair. I could have been wrong. You know, being deaf and all. The state challenged the daughter's theory, noting that they had met with her on several occasions and never heard this version before. The daughter also claimed that the family friend Michael Shaver, after she did, shot him. But the man testified he never met Michael Shaver. Police evidence indicates that Michael Shaver was not exactly a one-time connection with Laurie Shaver. Oh, I'm sorry. Let me go back. Physical evidence indicates that Michael Shaver was shot exactly one time, not two. So then today we had witnesses come up. Laurie said that. That's correct. But the medical examiner said there's only one bullet hole in this victim. So there is definitely between several people, including Laurie, her daughter, and whomever, that yeah, this is not adding up. I don't think so, Toxic. I think they were trying to find evidence that he was shot twice, but they didn't. I'm going to take another comfort break. I got to go take my little girl to the bathroom, and I'll be right back. They did not have any evidence that the man shot twice. Lay down. So, I could see a child defending their mother if abuse was consistent in the family, but in this case, I don't believe it. If it were true, I think the police would have been called and the mother would have. Um, First of all, in my humble opinion, which to some people don't mean crap, I think that if the daughter did do it, then the mother shoulda, woulda, coulda call the police immediately, try and get help, 911. All of that should have happened. It did not happen. In fact, none of it happened. So I am having a hard time believing their story. Really struggling to believe their story. Um, to me, it's a no brainer. And how can you sit there and allow your child to testify on your behalf? I would go to jail protecting my child. I don't care what the case is. You know, well, if my child committed a crime, then I, the child needs to, suffer consequences. But, if it was one of these situations where the child did something thinking they were protecting us, a parent or someone, and then somebody trying to prosecute them, heck, y'all, I'd go to jail to protect my child from false prosecution. Yeah, I won't go to jail and try and get my child off. But if there was innocence there and I knew the innocence, I'm not putting this very well. Let me back up. Number one, I would not throw my child under the bus to go to jail for me if I committed a crime. Period. End of it. But if no crime was committed and the child was being charged with it, and the child is that young, I'd confess to it. I would do that for my kid. But in reality, my kid wouldn't be in that position. That's something else that I wanted to. I don't know why I keep doing that. My kid would not ever be in that position to begin with. Because, honey, the first time somebody laid hands on me, I'd be gone. I wouldn't be cheating on him and having these affairs and getting pregnant and ending the life of the baby and doing all this kind of cray stuff. I wouldn't be doing it. It's called growing up and being a parent. My child comes first. End of discussion. That's it. No more. I don't care. When I have a child, now my life is that child's life until they turn 18. I brought the child into this world. I'm going to be responsible for that child. Oh my gosh. I'm trying so hard not to break into this cake, but I'm just going to have to do it. I'm only going to take a bite or two because I'll have it with coffee later. My other concern is why? If my child shot my husband, even though he was beating the living hell out of me, the police would be called right then because there's evidence all over me that I was being beaten up. Right? Where's the evidence that she was being beaten up? If I'm being beat up and my child had to discharge a weapon to protect me, 911 would have been called. Heck, 911 probably would have been called before that. And I would not teach my children the first thing you do is go grab a weapon. The first thing you do if anybody's beating up on mama or daddy is you get on that phone and you call 911. I told my kids a long time ago when they were the age 5, 4, 5, 6, I was teaching them 911. And I said, if somebody breaks in the house, call 911. If mommy's being hurt by somebody, call 911. You know, so why did she go to the gun and not 911? Mm. 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 Mm-hmm. Mm-hmm. That is so good. Kathy, thank you. Mm. Why did she not call 911? That's my mind is. How would she have known at that age the first thing you do is go grab the weapon? Can somebody answer me that? And the excuse that the kids were being taught all this by their father, I don't believe. Um, a part of me wants to say there's no way a parent in the right mind would be handing a 6, 7 year old a weapon, teaching them. But where I live, there are those who do. It's going up. But the reasons are different. It's not to go hunting and provide food for the family, like this person said. I don't believe that for 1 minute where they lived and how they were living, that was a necessity. My papa, of course, he's 90 this year. His mom and daddy were super poor. At fourth grade, third and fourth grade, he was getting up at 4 in the morning to go shoot game. Could have been squirrel, it could have been possum, it could have been a deer, it could have been anything. Because if he didn't, they wouldn't have any meat. So he get up before going to school. His job was go hunt, bring it back, and Mama would take care of it. Come home, there'd be dinner. But this is a different time, a different place. This is like he was born in 1934. Oh my gosh, that's a long time ago. That's making him sound old. He didn't act it or look it by any means, but in today's day and age, I struggle with the thought that unless you're living in rural America and your parents, you have to survive on gaming. I struggle with anybody handing a child that young a weapon. There are people who do. I'm not saying that you parent how you want to parent. I'm just saying I'm not comfortable with it. I remember my kids at that age. Mm-mm. So anyway, that's where I is. Let's look around, look at comments. Ronnie, are you still there? Toxic Orchid, are you still there? ADHD Jelly Bean. I know it's real quiet right now. Everybody's at lunch. I get it. Right now I'm saying a special blessing for Toxic Orchid. She is a foster parent and is getting a 5-day-old foster child. Let me go hop on over to Law and Crime. I couldn't get it from there earlier, so let's see if it's there now. That's good. Teenage star Freddie Flip off Field of Dreams star. The child in the movie Field of Dreams died in a car crash. Oh, how horrible. How horrible. Oh, prayers and blessings to your family. That's horrible. Oh, everyone's, yeah, I'm cooking. Okay, Ronnie. ADHD, I'm around. I'm just tired. Okay. Okay, get to the point of her testimony where they were talking about the pregnancy. Of course, Michael's going to be living. Andrielle? Our kids wouldn't know how to use a metal protector at 7. Yep. I'm trying to go to another feed for you guys. You'll say it's better. We'll do that. When I tried to go on earlier today, it was not available. So we're going to just switch feeds. Oh wait, I want to see what their Okay, here's their poll. Guilty, not guilty, hung jury. 85% say guilty. 7% not, 8 hung. Okay, that's fair enough. Fair enough. Okay. Then I'll delete this other live. Hopefully this will be much better for y'all. I have mentioned the pregnancy. I don't want to go there any further because number one, it's alleged. There's no proof. Number two, if that's the case, the unaliving of babies is a very touchy subject. So I don't want to get a big debate going in my live right now about it. But it has been stated by me multiple times that she allegedly unalived her baby from an extramarital affair. And of course, I'm sure Michael was not happy about it. She said he wasn't. So, nothing else to be said. This girl was I'm a hoe. She's a hussy. I mean, if anybody had reason to leave that marriage and to be angry, it was Michael, not her, because she caused the problems. And if he truly was that bad, why would she leave and come back, leave and come back, leave and come back? I understand the battered wife syndrome. I understand a lot of that, but usually once you're out, I don't know. Yeah, I'm saying alleged because I'm not sure. She enjoys the position. That's all I say about that. Somebody and I said, she enjoys that position. Make of it what you will. That's all I'm going to say about that. We will be, once the jury goes into deliberation or we have a word of that, then I will go and start going over some of the Boone documents. When you say you're not excusing his violent behavior, but the word BUT null and voids what you just said. So are you not condoning the behavior? And that's fair, Andriel, that you can't stand her and you don't know how much to believe. That is perfectly fair. I wouldn't have put any trust in what she says. Her behaviors and her bed hopping and everything and all that, I don't have much faith in what she says. But what's important is not what we believe, it's what those 6 people believe in that jury. And I always think 6 jurors come back quicker than 12. So hopefully we'll have something pretty soon. I know you're not condoning it. God, everybody's starting to talk about Halloween costumes. I'm like, I'm not ready for that. I'm still struggling over these glasses, how sharp they are. But I'm used to just turning my eyes and now I have to remember I've got to turn my head. And they're so clean. There's no scratches. They nice and new. I didn't get a case with these because I already had the frames. Ronnie, I don't think he was abusive. They had the one altercation with the police, but nothing after that was reported. I think she used the one incident as an excuse, and she very well could have. Very well could have. You were so right about that. And couples have arguments. Some people are very physical in their arguments, which I don't agree with, but I don't necessarily believe it was to the point that he had to be unalived. I don't think he was in the I don't think the unaliving was called for. Even if the daughter may have brought the mother the weapon, and that's something I thought about last night while I was 6 hours of power washing the front of the house driveway and everything. The girl may be telling half truth. Sometimes there's whole, sometimes there's full truth and no truth, and then there's half truth. What if the mother yelled at her, "Go get the gun"? And she went and got the gun and she took it to mama. And as soon as she handed it to mama, mama shot. And then mama messed with the memory as that child was growing up and said, "No, honey, I didn't shoot. You did. I took the gun away from you." That happens a lot with parents. They manipulate a little part of it. So is it very much true that she could have gotten the gun and had the gun in her hand? Yeah. And another reason to call the police immediately because they would have tested her hands for gunshot residue, both mama and daughter and that man. Oh, so it is plausible the girl had her hands on the weapon. If the mother was screaming, "Go get it, go get it," they did have an altercation and she gave it to mom's. Mom instantly pulled the lever and um so the girl thinks that, yeah, I brought the weapon to her. Mom tells me I fired. So over time, she believes she fired. I mean, it's funny how the brain can work. Your memories can be influenced. It's your truth doesn't mean it's the truth. When I talk to people, and sometimes when I go and do notification and next to kins, I'm very specific in the order and way I give information because that makes me consistent and makes it clear and makes sure that the information is given. And several times I've had people say, "You never told me that. I didn't do this. I did this. I recall this. Are you sure I said this? I don't know where the keys are. Do you know where the keys were?" And I said, "Ma'am, you picked up the keys off of the dresser. You took them into the kitchen and put them on the kitchen counter." Why? Because I take note of everything. "No, I didn't. I had you go get the keys." "Where are they?" And I said, "There was a toaster next to a coffee machine. Go over there and look there." And they were halfway between and behind. That really happened. So her truth was, I got the keys. But reality was, she did. But in the state of mind that she was in, it just was all mixed up. True, toxic. Very much true. Very much true. Look at Johnny Depp. I mean, he's a perfect example of how, he didn't report it. And now he wishes he did. Things worked out for him, thank goodness, but still. Oh, toxic. I hope you get reimbursed for all this. I think you do, don't you? I think you do. I wish if you were anywhere near me, I'd help you. But I'm nowhere near you. We have a ton of wonderful resale shops that have a ton of baby clothes. Yeah, now, I don't get bad stuff. Don't worry. But might as well, you know. Nowadays, though, that some of the stuff is so cheap, you might as well just buy it brand new and send it with the child if the child still fits in it. I still have the dress Well, my grandmother made a dress for me um, while I was in the foster care system. She gave it to me on a visit, but I still have the outfit I wore when my parents picked me up from the foster care. I still have it. Yep, I sure do. I'm grateful my mother saved it. She did. I still have the shoes, the little socks, the dress. So, yep, got that. They should be back any minute. I apologize if you see me kind of wrenching. My back is screaming. Ugh, that lower back. I have 3 herniated discs between 1, 2, 2, 3, 3, 4, 4, 5. All those lower right on to the very base of the spine are herniated. And I guess this constant motion like this for 5 hours just flared me up. So I'm really not feeling that great. So yeah, doesn't that seem more plausible that they were fighting? The mother said, "Go get the gun." The girl goes and finds it, comes back, hands it to mom. Mom does the shooting, but it happened so quick after the girl had given it to mom that in the end, mom has manipulated the memory into she doing it. I can see that because mom's going to do everything she can to save her butt. And then what's going to happen is then they decided they needed to bury him. So they said, "We're putting in a pit here. This is half dug out. Let's put him here." I think that she almost got away with it. Almost. But that's my own humble opinion. That's what I personally believe. Doesn't make it gospel truth. But that is the most plausible part of the reason why, if the girl truly believes that she's involved, is that reason right there. My hat just looks crooked, y'all. It's driving me crazy. Oh, it's straight. I guess it's the shadowing. It's throwing me off. So, here they come back, y'all.
Back on the record in case number 2020 CF 2361. Are there any preliminary matters, or can we call the jury?
Your Honor, I just have a corrected copy of the verdict form for you, given it to.
Yes, sir, please approach.
I made the typo changes as well as replacing the packet.
Thank you, sir. Appreciate that.
We reviewed them, Judge, had no objections.
All right. Anything further?
Yes, sir.
All right, then we'll call in the jury.
Oh, Jesus.
No, you didn't, Corina. Just lunch. Boy, they have their thing awfully high. We can do that one.
All rise.
We'll do that. No, we can't. Dang it. I don't use this one, so let's redo this one.
You may be seated.
All right, thank you. Thank you again. I see that all of the members of the jury have returned, and thank you again for your time and attention today. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to them. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State, you may proceed.
May it please the court.
Yes, sir.
It won't let me do it. Urgh.
On November 7th, 2015, Michael Shaver went with his family to meet up with some friends at a tractor show. This is the last time Michael Shaver is ever seen by anyone other than the woman that murdered him, Laurie Shaver. You've heard a lot of testimony and evidence over this last week discussing Facebook, phone records, bank records, all sorts of evidence for your consideration. But it's important to remember that why we are here is because Michael Shaver was shot in the back of his head without any sort of legal excuse or justification and buried in his backyard. Michael Shaver, between November 7th and November 10th, shot in the back of the head and dumped, wrapped in a tarp in his backyard. That's what
You're correct,
we've been
Toxic,
here
but
this
we
week.
won't know
That is
because the
what
police weren't
evidence
called.
has shown you, and it has shown that the person who did that is Laurie Shaver. The elements of second-degree murder are fairly simple, and it is these elements that the state must prove beyond a reasonable doubt. You can have doubt in this case, you can have doubt in any criminal case. State's burden is to prove this case beyond a reasonable doubt. These three elements, and that
But
is
the
what
gun
we
is
must prove to you. First, Michael Shaver is dead. 2, the death was caused by the criminal act of Laurie Shaver. 3, there was an unlawful killing of Michael Shaver by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. That third element is further defined by the court as an action that is reasonably likely to kill. A gun to the back of the head is obviously something reasonably likely to kill. Done with ill will, hatred, and spite. I can think of no other reason in a person's mind when they're shooting someone in the back of the head other than those three things. And 3, indicates an indifference to human life. The evidence that you have heard throughout this trial clearly show that that first element and the third element are really just not in dispute. What we are going to spend the majority of time talking about this afternoon is whether or not the death was caused by a criminal act of Laurie Shaver. And the evidence that you have heard shows that the state has met its burden for that element. As you heard the judge give you the instructions already, there is something that is called a lesser included offense to this second-degree murder, and that is manslaughter. The difference between manslaughter and the second-degree murder is it does not have that third element about an act done imminently dangerous, demonstrating a depraved mind without regard for human life. So if you feel that the state has proven that Laurie Shaver is in fact the one that shot, but didn't have that state of mind at the time she shot him in the back of the head, manslaughter would be the offense that the state has proven in this case. As we go through the evidence, I want to remind you of something that Mr. Wiggs said in his opening statement. And what said in opening statement is it's not evidence.
Not evidence.
If you've heard some things in opening statement that was going to be presented to you when it came out differently, what you heard from that stand, what you got from the evidence sitting on that table over there, that's what you are to consider, not what the attorneys talked about in opening. But what Mr. Wiggs said is you aren't going to hear just find her guilty because common sense. But the instructions that the judge gives you, and the judge will give you a full written packet of all of these instructions. So you don't have to worry about writing down the various instructions as we're talking about them. The judge will give that to you.
Be safe, toxic.
It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. So common sense is absolutely part of the instructions the judge is giving you and absolutely part of what you should use when you are weighing the credibility of the evidence, the witnesses that have testified from both sides. The state has proven this case through the totality of the circumstances of this entire investigation. It is important to remember that Laurie Shaver is the only one that stood any sort of benefit to gain by the death of her husband. She had the means, the motive, and the opportunity to do this. And when I talk about the means, the gun that was recovered from Robert Seha that he purchased from Laurie Shaver prior to the body being discovered is the same caliber and class as the projectile found in Michael Shaver's skull. And remember the testimony of Megan Cleek, the firearms investigator from the Florida Department of Law Enforcement that did that analysis. Once again, I'm going to trust that you remember what she said as opposed to what the attorneys say about it. But what she said was,
I want to get that
projectile that was found
big
in
chunk
the
of
skull
dandruff out of his
was
hair.
the same caliber, meaning that it was the right size ammunition to be fired from that pink and black 38 special. She also said that it had all of the class characteristics from that type of firearm. The only thing she said it was missing in order to make a full comparison and the thing that she would need in order to say, in fact, it was that gun, is it didn't have enough evidence of the individual characteristics from that firearm. You saw the condition of that projectile, how smushed it got once it struck the inside of the skull. You also heard her say, when she did the test fires with that weapon in the most pristine situation she possibly could, firing into that water tank, the individual characteristics that were left on those pristine projectiles were very hard to see. So between the time frame, the degradation, and the fact that this gun does not leave strong individual characteristics, it's completely understandable why 4 years later, when it's examined, they just can't find it. But all of the evidence that is in that projectile is consistent with being fired from that weapon. Motive. We actually heard evidence of a couple different motives, because it is clear that she wanted to be with Jeremy Townsend. We are going to talk much more at length about the Facebook activity, the flowers, the messages sent to Vanessa Townsend, but she wanted out and she wanted to be with her new boyfriend. But you also heard her say, when Frank Merritt came to check on the whereabouts of Michael Shaver, when she claimed that he, in the middle of the night, got into a black SUV, abandoned all of his property, his vehicle, his clothes, anything that had any sort of value, and hauled up to Georgia, that she and Michael had a fight because she found the fact that his previous girlfriend, Kendall Davidowski's phone number was still in his phone. Motive is not something the state has to prove beyond a reasonable doubt. It is not one of those elements. But we have presented you evidence of what her motives would be in this case. And finally, opportunity. That means, was this person in a position to commit this crime? I believe Detective Dale summarized it best when she said, the body was found buried in the backyard. It's not like he got carjacked and shot on iDrive.
True.
All three of those factors
point in the direction of Laurie Shaver. So now let's talk and focus on the totality of circumstances. That goes to all of that on that table, all the things that have been presented to you, showing how she hijacked his Facebook, showing how she impersonated him to his friends and family members through texts, Facebook messages, took all the efforts she possibly could to avoid anyone from starting to look. Now, you have heard various friends and family members talk about how over the course of 2.5, 3 years, they went looking for Michael. It wasn't a scenario where he talked to anybody on a daily basis, weekly basis. There were times that he would go and not visit and things of that. But he always responded. When people would reach out to him, he would respond. He wouldn't leave those messages unanswered. And when they did get any response after November 2015, every single person that talked to you about that said it was obviously different. It was not the way he would respond. Finally, when taking all of the circumstances, all of the evidence, and putting it all together, that's where the state is asking you to rely on your common sense. Because you can take any one piece of this puzzle and you can look at that and you can say, well, I mean, that's not an eyewitness that saw what happened. That's not a piece of DNA. Maybe that's not something that proves in and of itself that Laurie Shaver committed this murder. And we're not saying any one piece of evidence over there does that. We never have. We got up here, Mr. Buxman in opening was straightforward with what you were going to see. He told you there's not going to be a witness that's going to say Laurie Shaver did this, that I saw her do this. He told you what the forensic evidence was going to be. We put that up there so you could see it. But we also gave you the explanation of why, after someone is buried in the ground over multiple years and their body decomposes, the effects that has on any sort of trace DNA evidence, any sort of trace fingerprint evidence. But we were upfront about that with you. We told you that's how it was going to be. But we are asking you to follow that judge's instruction and use your common sense in looking at all of this together. Because when you look at it all together, the conclusion is crystal clear. Let's start going through the timeline. November 7th, 2015 is the last time Michael Shaver is seen by any friends, family members, co-workers, anyone other than Laurie Shaver. November 9th, 2015, after Frank Merritt had reached out first to Michael the day before, text about a gun cleaning kit, did not get any response. He followed up with that. And Michael says, well, I put air quotes, Michael says to Frank Merritt, have to quit my job to work on my marriage. Submit to you, someone going and becoming unemployed and not earning any money probably isn't the best way to go about working on and contributing to marriage. But that's the first type of response that people thought was odd. November 10th, 2015 was the first time ever that Michael Shaver did not show to work and did not call to say he was not coming in. This continues to November 12th, 2015, and ultimately leads to his termination. November 11th, from those Facebook records, the Laurie Shaver Facebook records, Laurie Shaver posts a public posting to the entire world wishing various veterans a happy Veterans Day. Most importantly, in that list of people that she thanks is her brave, loving man. Michael Shaver was never in the military. Her husband was never in the military. Jeremy Townsend was. One day after Michael Shaver has no contact with his place of employment, she is publicly posting for all the world to see, talking about her brave, loving man, veteran, Jeremy Townsend. November 12th, 2015, John Borglum receives a text message from Mike's phone that's saying he has issues at home and was in Georgia, so go ahead and fire him. Now remember, there's absolutely no evidence whatsoever that he was ever in Georgia. None of his bank records show any activity up there. His family members in Georgia, they haven't seen him. And Mike just leaves his job, his vehicle, everything behind. November 13th, 2015, because this is all extremely unusual, Frank Merritt goes to the Shaver residence to check in on Mike and is told he went to Georgia. Now, when Lourie testified yesterday, she tried to say, oh no, he must have misunderstood. I never said Georgia, definitely. That's just a misunderstanding. But remember, he's not the only one to say he got a message about Mike going to Georgia. Because John Borglum the day before, in that text message sent from Michael Shaver's phone, and whoever had that said he went to Georgia. Laurie's version of what happened in November. She kicks Michael Shaver out after the November 7th, 2015 tractor show, and he returns to live at the airplane hangar. So now the story has changed from he went in a black SUV, went out in the middle of the night to go up to Georgia, to he is living at the airplane hangar. If that is true, you need to believe all of the following. One, despite the fact that the last time he was out of the home and living at the hangar, he was still working at Disney, he somehow decides to abandon his source of income. He's kicked out of the home. He's obviously going to need a place to stay. He's going to have to pay for bills, pay for food. But that's the period of time he decides, I'm not coming to work anymore. You also have to believe that he decided to just abandon his vehicle, his source of transportation, his source of actually maybe finding another job, being able to go various places. You also have to believe that he leaves behind anything he has that has any sort of value. Guns, tools at Disney, anything. Now he's unemployed, homeless, gonna need to fend for himself, but he just leaves all of that behind. And then you heard also today from Katina, they left all of his belongings, toiletries, and clothing behind at the house. So you basically have to believe, if you believe Laurie Shaver's version as she told you yesterday, all of those things would have to be true. So what's the evidence that that's not true? Well, the person that she indicated took him to Georgia came in and said, nope, I didn't do that. All of his friends, all of his family members that live in Georgia, no, we never saw him. All of the bank activity is here.
in Claremont by the home that he lived in with Laurie. The bank activity is not even out by the hangars. There's one entry that deals with Disney, but every ATM withdrawal, Groveland, Claremont, 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 Claremont. He was not in Georgia. No outgoing phone activity after November 7th, 2015. None. And then, if he is kicked out of the home, fending for himself, there is absolutely no reason for him to just also cut off contact with friends, family, and coworkers. But that's exactly what happened. Michael Shaver was dead before November 10th, 2015, because he fell off the face of the earth. There is no bank, phone, any activity that is associated in this day and age with what people need to do in order to survive, because he's dead. These are the various records that you heard about, that you saw. Everything is in those folders so you can review it. But this is what I am talking about the bank activity from the time he was killed before November 10th, 2015, and then December 30th, when that account just becomes overdrawn and is never used again. November 20th, online purchase to wish.com. November 24th, online purchase to wish.com. 12/14, ATM deposit. What was that deposit? That was the check that was mailed to his home from Mariner Finance. And this is important because this check was sent to the place where she lives. And it was deposited in Claremont. Michael Shaver does not have a vehicle. I think Laurie was trying to explain to you how, well, he would just come by, no one would see him, no one would know anything, but he would just check his mail because it was out by the street. That makes no sense. He has no car, he has no money, no phone, but he's coming by to check his mail and get this check? No. That's just not credible. That's not believable. He then, after he makes this deposit, ATM withdrawal Bailey, 12/14, ATM withdrawal Claremont, 12/18, ATM withdrawal Claremont, 12/21, ATM withdrawal Groveland, 12/21, ATM withdrawal Claremont, 12/23, purchase from Walmart.com. Who was the purchaser there? She was. You saw the receipts. You saw the Walmart.com records. You saw it went to that address. Finally, 12/23, ATM withdrawal Claremont. And at that point, on the 30th, the account becomes overdrawn, never used again. Mike is walking around, having no contact with friends, family members between November and May. We're just getting his money. Bank account, cash out, absolutely no activity. There's no reason, if he's out trying to forge for himself now, kicked out of the home, living at the hangar, and doesn't maintain his bank records, bank accounts. But if it's depleted by Laurie, all of that activity is Claremont and Groveland. Phones. This is Michael Shaver's phone records. This is the number that he had. This is the number that you heard his friend Brendan Burns actually pull out his phone, say, I still have his phone number programmed in my phone. This is what it is. This is that 5121 number. And once again, all of these records are in Those folders, you can look at them yourself. And obviously, you can't read all the detail here. But the point of putting this up was to show you that this one in blue is that phone call he made out on the 7th to Epcot. That was the Detective Dale told you. That was the last outgoing call from this phone number. In the research, that phone number was associated with a landline in Epcot, where he worked. Before that, this is all the activity. It almost daily calls out, calls in, calls out, calls in. This first area, all those yellow highlighted, are calls back and forth between him and Laurie Shaver. After November 7th, nothing. Not a single call out from his phone. He doesn't have a car. He doesn't have a job. He's not at the hangar. None of his friends there have seen him. He's got to communicate with somebody if he's alive in order to keep going. But there's no activity because he's not alive, because Laurie Shaver killed him before November 10th, 2015. The only phone record after November 7th, 2015 is the collections call from Mariner, because the check that was mailed to her was deposited in Claremont and they were coming to collect. And when they called, remember what Tara Mitchell told you. A female answered the phone and said, "Oh, this is a new number." But we know that's not true because you have all the phone records showing the history of that phone number, and how it changed. And we'll come back to that. So let's keep going with the timeline. In December of 2015, Mike's mother becomes ill. His family is seeking him out to let him know that she is very sick. I believe the testimony from Stacy Turner was it looked like she might not make it. Couldn't get in touch with him. All the texts, phone, Facebook, whatever they tried, couldn't find him. He's dead. But they did get in touch with Laurie. And she said, "I'll get word to him." No phone calls to him. She knew she didn't have to call him. She knew he was dead. Because she killed him. March 24th, 2016, Laurie Shaver posts about the fire pit that she made. This is the area that multiple witnesses told you was a hole, was going to be a duck pond. But now in March 2014, that area is filled in. And wouldn't you know it, Michael Shaver's right there. He's in that. Isabel described it as a really big hole. April 6, 2016. This is where we start showing you how we know Laurie Shaver had Michael Shaver's phone and access to the ability to text people, had access to his Facebook, had access to everything she needed to do to keep people from starting to look for him, to keep people from investigating the fact that she killed her husband and buried him in the backyard. That phone number, 352-431-5121, on April 6, 2016, this would be approximately 4.5 months since Laurie said, "I kicked him out." But that phone number is changed. Saw those records, device brought in, changed phone number to 352-801-0941. And then 10 days later, that phone number is changed again to 352-431-8114. 8444. As a reminder, the phone numbers that were important in this case started off with the 431-5121 number, the one we just talked about, how it got changed 2 times within the period of 15 days. We know that was Mike's number. The records are connected with Laurie Shaver as the subscriber. We also heard Brendan Burns testify. That was the phone number I've had programmed in my phone since the last time I ever talked to my friend. Laurie Shaver's phone is 352-431-0419. We have our phone records. We have the screenshot from the time frame that Vanessa Townsend had reached out to Laurie to discuss the messages that she had received. We also had the screenshots from the text messages between Jeremy Townsend and Laurie Shaver, and lo and behold, the phone number associated with Laurie Shaver in those text messages is this 431-0419 number. Now, Laurie testified yesterday and doesn't seem to remember any phone numbers that she's ever had, but the records show it, the screenshots show it, the text messages show that was her number at the time. And then there's a folder that, as opposed to the call details and said this is the call out, this is the call in, that third folder we talked about with Tanner Gale shows the history of that phone number and device. And it shows how on April 6th, the phone number was changed from Mike's original number to the 0941 number. Why is that important? Well, 2 days later, after changing Michael Shaver's phone number to a new number, she reaches out through Facebook to contact Vanessa Townsend and says, here is my number, call me. Vanessa Townsend goes to call that number at one point. Remember what she said. I called this person and asked me to call them. They wouldn't answer, but they would text. Or you can't answer the phone and pretend she's Mike anymore. She has to text. Well, that number only stays in place for 10 days. She got it. She did what she needed with it. She got rid of that number, got a new number. What number was that? 352-431-8444. Why is that important? Well, in July, she's filing a court document with her address and her phone number, 352-431-8444. This shows that she had the original Mike Shaver
Yay, you're
and
home.
phone number this entire time.
When does little Peapod,
This
when does
shows
little Peabody
the
arrive?
constant link between when she killed him in November, had his device, had the number changed to contact Vanessa, and then had it changed again to the number that she represented as hers. April 6, 2016. Laurie Shaver's bank records reflect the purchase of flowers sent to Vanessa Townsend. April 9th, Michael Shaver's Facebook sends Vanessa Townsend, that's when she asked him to contact her at the 0941, the burner phone. And April 11th, 2016, Michael Shaver Facebook sends a message informing Vanessa she's about to get a special delivery. She does. The flowers purchased by Laurie Shaver, as shown in her bank records. She receives the flowers, exposing the affair. But that's not all she ultimately gets from Laurie via the Mike Shaver's Facebook. She gets pictures after picture after picture, text message, screenshot after screenshot after screenshot. I ask you once again to use your common sense.
This is Mike Shaver reaching out to inform some other person that their husband was being involved in an affair.
I thought he was going to say reaching out from the grave, and I was going to go unglued.
What does this picture do it? Why all that? Why? This was Mike. Would all that be necessary? This isn't sent by a husband trying to inform some other person's wife that their partners were having an affair. This is sent by Laurie Shaver because she wanted to drive a wedge because Vanessa would not leave. Well, sorry, Jeremy would not leave Vanessa, and that is what she wanted. September 12th through the 14th of 2016, the cement slab is poured over Michael Shaver's body. That is shown to you by the cement mixer rental being for that period. And then it is also confirmed in Facebook posts a couple days later at Isabel's birthday party on September 19th, 2016. Michael Shaver's body has been in the ground for some time now, but there is no argument that can be made that after that cement slab is put down, that his body was not there. On September 20th, 2016, after we know for a fact Michael Shaver has to be dead, there is a Facebook message to his niece, and this is the one that reached out to him and said, "Hey, Mike, how you doing?" He says, I don't know you. I don't know who you are. She didn't have a Shaver last name. Lourie didn't recognize him. She's like, "I'm your niece." She talked about how she had discussions with him. Mike knew she was getting married, knew that she was going to be changing her name. And Michael Shaver's Facebook reply is, "I don't have a family anymore. I have no clue who you are. Now stop messaging." September 20th, 2016, after we know Mike has to be underneath that cement slab, he also sends a Facebook message to Vanessa Townsend. "Hi, Vanessa, how are you? Moving good looks good on you. Hope you and your son are doing well." Now, Mr. Wiggs has talked at length with various witnesses about maybe Jeremy Townsend had this phone. Maybe he was just driving up to the house for months and months and months after this relationship was ending to try to get into the router to have the IP address match Laurie Shaver's IP address, and that he was the one that was doing all this. No reason for Jeremy Townsend to send this message to Vanessa, because it's not true. It's just as unreasonable as the idea of some sort of hacker getting into Michael Shaver's Facebook account to post a stupid meme. It makes no sense because it's not true. Laurie Shaver had access to it. Laurie Shaver had access to the devices. Laurie Shaver had the means and desire to make people not want to come look because she killed them. March 8th, 2017, after we know Michael has been dead for a very long time now, and known that he is underneath that cement slab, the Facebook profile picture has changed
to a photo taken by Brendan Burns in 2014 that he says probably texted to him back then. So who would have access to that to put it up on his Facebook profile to try to act like Michael Shaver was still alive? Someone that has his phone. Who had his phone? She did. And those phone records prove it. January 1st, 2018, that is when Michael Shaver's Facebook profile is changed to the random bar picture that Detective Strickland did research into using the reverse Google image to show that had something to do with some sort of Bloody Mary company out in the Midwest, and Michael Shaver's nowhere in that photo. March 14th, 2017 is when the cover photo changed. And that was that odd looking revolver that I think had 700 bullets in it that Detective Strickland made a joke about that's not real gun. Well, it's important to remember that the post of that cover photo and almost the 2-year anniversary of Michael Shaver's death, to put a gun after he was shot in the back of the head, shows that Laurie Shaver's Facebook account and Michael Shaver's Facebook account utilized that same IP address, meaning that they have to be in the same location, the devices that are accessing these accounts. It's the same, whether it's Starbucks, whether it's Laurie Shaver's home, it doesn't matter. It is in the same IP, the same location. Both of those accounts are accessed within 1 minute of each other. Has to be someone that has control of both accounts. There's no other reasonable explanation for that. The Facebook IP limits. We spent a lot of time talking about these. This is the summary that Detective Strickland described. And going through this, you can see how there is activity throughout a 2-year period where both of these Facebook accounts are utilizing the same IP address. Once again, we've been upfront with you since the moment we started talking about this case that we are not going to be able to tell you the physical address of that IP address. But it doesn't matter. Wherever it is, you have to be in the same location to access the IP. And when both accounts are constantly utilizing the same IP address, that shows that that is the same location, the same person accessing that. If you were to go through this and go through all 70 some odd pages, you would see there are 13 separate IP addresses that both accounts utilize over the course of that period. And you heard some testimony about how providers like CenturyLink will sometimes roll that, change your personal IP address to your home every month, maybe every 2 months. What you will see is that both devices utilize a particular IP address for about a month, maybe 45 days. And then it changes to another IP address. And then both of those devices share that IP address for that entire time. There's countless instances in there where you might see the Michael Shaver Facebook address, Facebook account access an IP address, and then the next day, Laurie Shaver's Facebook account accesses that same IP address, and it goes back and forth, back and forth. That is a folder full of those examples. But if you were to go through there, you would not only would you find 13 separate IP addresses that they use, you will see activity on Michael Shaver's Facebook account that continues after the cement slab is laid over his body in September of 2016. You will see there are 31 separate days in that 2-year period where they both access the same IP address on the same day. You will see that there are 12 days in there where there is activity between the Laurie Shaver account and the Michael Shaver account within 2 hours of each other. There is one instance, which we talked about with the gun photo on the almost 2-year anniversary of his murder, that is 1 minute and 7 seconds apart. There's another instance on July 15th, 2016, where the activity is within 6 minutes of each other. This is the same person looking at these, using these. This is one example of the type of thing you'll see in this chart. This is from April 2016 on this side, where you can see there are some days, once again, look through this chart, feel free to do so, where on certain days it's actually going back and forth. Both are being accessed throughout the day. November of 2017, towards the end of that chart, this is where you can see the actual data that I've been talking about, showing the 1 minute. And not only have we given you this summary to try to help you with going through all this information, you have the originals right there, and you can go through it yourself. And you can check it and look at all of that. Justifiable and excusable homicide. Justifiable homicide is going to be the self-defense, defense of others that we will talk about shortly. The excusable homicide instruction is given to you. You heard it, read it. I would submit to you that none of these things apply when the killing is committed by accident and misfortune in doing a lawful act. There's absolutely no evidence of any of that. Accident and misfortune and the heat of passion. Heat of passion is coming in and being so overwhelmed by something that a reasonable person would not act any different. Not to be blunt, but you come in and you see your child being attacked, molested, whatever it may be, and you are overcome with this emotion, and no reasonable person would not. That actually doesn't excuse the killing. It just means that you're not
temporarily out of your freaking
the
mind.
necessary intent to commit second-degree murder or first-degree murder. It would be a manslaughter. And when the killing is committed by accident and misfortune resulting from sudden combat and a dangerous weapon is not used. Well, we know someone was shot in the back of the head. That doesn't apply. Excusable homicide has to be given in every homicide, but none of those apply. Before we talk about the defense of others, I want to go through and talk about the tools the judge has given you to aid in your common sense in weighing the credibility and weighing the evidence in this case. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did they have an accurate memory? Were they straightforward in answering the attorney's questions? I'd submit to you that as you go through this, all of these questions that you ask yourself are pretty common sense, that these are the types of things you should use to try to assess a witness's credibility. Defense of others. The testimony that has been presented to you by the defense is that Isabel shot her dad in the back of the head. And then,
Well, there goes my
just
theory
so
about her
happened,
handing the gun to mama.
at that exact same moment, that Jeremy Townsend showed up, grabbed the gun, shot him again, and then threatened to kill Isabel and Aiden if anybody says something. They also say, both Laurie Shaver and Isabel Shaver, that Laurie took her kids to school, that Aiden had no idea anything that had been going on. Gunshot in the back porch, huge fight. Isabel said Jeremy threatened him and threatened to kill him. But Laurie said Aiden had no idea what was going on. I just needed to get them to school. And it was a short trip over to school. All I wanted to do is get them to school and then get back home. That's what she said. And she says when she got back, Laurie said when Jeremy got back,
Jeremy was gone, and there was no change in the property. She talked about how close this school was to her. All she did was take the kids to school and drive right back, yet somehow Jeremy was able to clean up the entire scene, remove the body, and I guess come back some other day undetected and bury it, and no one noticed disturbed ground anywhere. These rules of weighing the evidence and assessing credibility, the judge has told you specifically, since the defendant has testified, you are to use those same questions, those same tools in order to assess her credibility. And when you look at this story, it makes no sense because it's just not true. Now, ultimately, proving this case is the state's burden. We have to prove she was the one that killed him. They don't have to prove to you it was self-defense or defense lawyers. We have to prove to you it wasn't. And we can, because all of the evidence shows that Michael Shaver was not alive in November, was not alive when this happened, because he's been dead since November of 2015. Somehow, Isabel, who shot her dad in the back of the head and went to school when she was 7 years old, has absolutely no memory of what year or what month this happened in. What grade were you in? I don't remember. I don't know. What month was it? I don't know. I think spring or summer. What year? No clue. And she said she went to school that day and carried on like nothing happened. It's the state's burden to prove this case. But if you are fed a story that is just patently false and fails all common sense scrutiny, ask yourself, why? Why did they come up here and try to feed that to you? Because to cover up the reality that Laurie Shaver killed her husband back in November. And they're trying to give you a story, and they're trying to fit it in to the timeline that has been established over the course of this case. Because also remember, in the very beginning, when Laurie Shaver was arrested, you heard testimony that her attorney said, you need to look into two people. You really need to look at these people. Jeremy Townsend and James
Yeah, I would
Fuller.
think so, Andrea.
Okay. Well, if this is the story back when Laurie was arrested in 2020, why bring James Ballou into this? That's not part of their tale. That has nothing to do with it. But that's how the story started. And then as the evidence progressed, then in 2022, Isabel shows up as this potential witness. And despite what Mr. Wiggs told you in the very beginning, that we were offering the truth to the state, and they shut the door on us. They said, we don't want to hear it. They want to talk to her. But you heard from her attorney. What does she tell you? Every time after she became the attorney of this witness, I would see her, say, hey, anytime your client wants to come and talk, I'm here. Does that sound like the state shutting the door on his theory? Or is that just the convenient tale they want to tell? And we went through Laurie's Facebook because it has been 9 years since this happened. The person, Isabel, that you saw testify is a much different person than the little girl she was when she says she shot her dad.
These are the pictures of Isabel from back when she shot
No!
her dad in the back of the head. Went to school, carried on like nothing happened. And then this great, wonderful mother that Isabel described, who was saying that these two were involved in this horribly traumatic incident in 2016. She go get her therapy, counseling. Maybe she
Sorry,
needs to
guys, I
talk to
just
somebody
spilt all my
about the
beads.
fact she shot her dad in the back of her head.
They
and was
little.
threatened by her mom's boyfriend. No, one time this year, I saw a counselor and talked to somebody. I'm fine. No big deal. The story makes no sense because it isn't true. But the evidence completely disputes their tale. Dr. Coberly told you soft, fleshy area so as to not hit any bones. But this injury, Dr. Coberly looked at underneath a microscope, and she says there is no doubt that is one gunshot. She says even when you have a scenario where somebody takes the gun, pulls the trigger, and immediately pulls the trigger again in that exact same spot, there's going to be derivations, there's going to be enough movement that they can see kind of a figure eight type of movement, figure eight type of configuration, to show that there was more than one shot. There's also only one projectile in the skull. Probably didn't even need that explanation of the microscopic examination because there's only one bullet there. But scientifically, we know Michael was shot one time. Going back into those tests, going to those questions. Does the witness have some interest in how this case should be decided? Laurie Shaver, Travis Miller, and Isabel Shaver are the only witnesses in this case that had an interest in how this case should be decided. Isabel Shaver said, I love my mom. I don't want to see anything bad happen to her. I want to keep my family together. And I understand that. But that doesn't mean what she told you is true. Was the witness honest and straightforward in answering the attorney's questions? I want you to think about Travis Miller and target his discussion of this commitment ceremony on December 31st, 2016. No, nobody thought this was a wedding. We didn't represent this as a wedding. Was she wearing a wedding dress? Yeah. Was she walked down the aisle by your grandfather? Yes. Was there someone there conducting the entire ceremony? Yes. Heard testimony from other people. Well, they absolutely told us it was a wedding. You also saw the Facebook post that Lourie put up announcing their engagement, saying that I'm going to be a filmer. Now, is that in and of itself the big earth-shattering aha moment? No. But if you can't trust them on the little things, how on earth are you going to trust them on the big things? Laurie Shaver, as far as honest and straightforward in answering the attorney's questions, you got to see the way she testified, you got to see her temperament, you got to see all of that. But also, once again, the little things. Was this your phone number? I don't know. That's the types of tools you can use in assessing their credibility. Does the witness testimony agree with other testimony and other evidence in this case? Everything except for Laurie Shaver and Isabel Shaver, show you and tell you Michael Shaver has been dead since November of 2015. And if he's dead in November of 2015, he definitely isn't showing up unannounced 6 months later for the first time on their porch. I guess wearing his nothing but his shorts, socks, and underwear. That's how the body was found in the ground. Is that somebody that just shows up unannounced and starts a fight? Or is that somebody that was at home, asleep, in that bed, when you shot in the back of the head? Even Laurie Shaver and Isabel Shaver's testimony conflicts with each other. Isabel Shaver said her father had not been living at home since 2014, since that BB arrest in 2014. Laurie testified actually consistent as far as that living arrangement as other witnesses that you've heard from, where she says, no, he was living there. But Isabel, now Dad hadn't been there since September of 2014. Also, Isabel says, Jeremy said he was going to kill me and my brother. Laurie says, Jeremy said, if you tell anyone, DCF will come and take you away from the family. Their stories don't even match. Because it's fabricated. It's made up. It's flat out not true. And it's inconsistent with everything else that you have heard. The only witness that Laurie got up there and say wasn't fabricating something was her daughter. Scott Amatuccio. He's lying that he's actually friends with Mike. They weren't really friends. You heard from Katina, she's like, oh no, they were great friends. Frank Barrett. He's lying. I never told him Mike went to Georgia. Jeremy Townsend. All sorts of lies. He would spend the night. That right there is should be a huge red flag to you. If Jeremy Townsend was out spending the night at someone else's home 3-4 times a week, the way Laurie and Isabel tried to tell you, Vanessa would know. She wouldn't need someone to send her flowers with a card to expose an affair. Vanessa had no clue that anything was going on, because Jeremy would go over in the middle of the day the way he told you. Robert Mercado is not being truthful when he said that Laurie got upset one day and was threatening people with a gun. Austin Filmer is not telling the truth when he said that he went over there and helped Travis lay down this concrete slab. Vanessa Townsend obviously is lying, because she said there was never any time that Jeremy was missing at night. He always came home. He was always living at home. John Borglum apparently is lying about the reason why he terminated Mike Shaver, because Laurie got up there and said, no, he was fired because of a sexual harassment claim. So also, I guess, Disney's lying when they sent over all of Mike Shaver's work records and just hid any sort of sexual harassment claim against him. But today you actually heard the truth about that sexual harassment claim, and nothing to do with Michael. She called it in against Kendall Davidowski, the woman that Mike Shaver was dating when they were separate. Kendall got up there and said, yeah, I worked at Disney. Laurie Shaver called me and made a complaint about the relationship I had with Mike Shaver.
It sucks spilling beads on carpet.
Everyone is lying about Laurie, but Laurie is the only witness that you heard from that actually admits lying to other people. She admits lying to law enforcement. She admits that when they came and said, do you know what happened to your husband? She said, I don't know. That was a lie. She knows he was dead. She tries to say, I had no idea he was buried on the property. No idea that he was under this cement slab she poured. But as far as anything that happened to him, no clue. She admits lying to Ravine, her former boss, about the fact that after Michael Shaver was dead in November, she told her former boss, "Oh, he's in jail somewhere for failing to pay child support and his driver's license suspended." She admit that was a lie. She lies to her son Aiden because she says, when I told, after I saw Mike killed in the fashion they try to say it happened, she told her son that her dad went away and went to jail. Even if you're trying to cover this up and trying to tell something to the son, why say your father went to jail? That's spite. That's absolute spite on this man that she killed. And then Katina Vasquez, who testified here today, that this whole thing you heard about in 2014, on how this is just so indicative of what happens in the household and how she was abused by Michael and all of these things. What did Katina tell you? Laurie told me that was a lie. Mike should have never been arrested for that. I was the aggressor. I threw the mace. I broke the slide glass doors. I hit him with the gun. Mike can't get up here and speak for himself and defend himself, but he doesn't have to. Because people like Katina come up and tell you the truth about Laurie's lies. Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? Tammy Dale talking to Isabel. Do you know what happened to him, your dad, Isabel? I have no clue. I don't know. He just left. At the CAC. So you did not see anything that happened that would have made you have an idea of what happened to him, Isabel? No. The last time she remembered seeing him.
Is there an objection, sir? Yeah. Sidebar, please.
Really? Already? What do y'all think? I apologize, guys. I dumped an entire container on the floor. It happens. But now I'm trying to get them all picked up, minus dog hair. Oh. You know, I don't care. I think you're right on that, Ronnie. I mean, Kristen. You will always remember if you take someone's life. I don't care if you're 7. I don't care if you're 10, 50, 100. That is not something that you don't remember. Now, I will say this, and I'm only saying it because I know this is to be true, that sometimes children can block out trauma and not remember anything happening. And then years and years and years later, it comes up. It'll come up. But I don't believe what she testified to. And that's how I'm going to feel. You can agree to disagree. You can agree to agree. But that's my humble opinions and feelings on this. So, yep. You know, it's interesting. If you ever drop beads or sequins on the floor, use a lint roller to pick them up. You pick up a lot of carpet stuff too, but it's easier than trying to do it any other way. If you don't have a vacuum, now if I had a vacuum, I put a sock on the end of the vacuum
Just remember,
and use the tube and pick them up that
what
way.
Isabel was testifying about. I asked her, did you tell this to Tammy Dale? Did you tell this to CC? She admitted, I told these inconsistencies that are completely different from what she testified. Now, I will also submit to you that back when Laurie Shaver was first arrested is when these statements were made. And this, I don't know, he just left, is consistent with what Laurie Shaver told every other person that came with. In 2020, I believe the evidence is completely clear that Isabel had no idea what happened. The only thing she knew is what her mom told her, and that's that he just left. And that this story was fabricated. Travis Filmer states in depth
There you
the
go,
reason
y'all.
Laurie did not want a legal wedding was due to financial issues. Yet at trial, he said she didn't want a legal wedding because, quote, she did not want to sign a contract with another man. And he started talking about, oh, poor Laurie and the things that had happened. But when he was actually presented with that depot transcript and given an opportunity to show me where he had said any of that before, he couldn't, because he didn't say it because it wasn't true. And also, this whole thing about not wanting to sign a contract with another man, we know that's not true because they ultimately got married once they legally could. Once it was discovered that her ex-husband was in fact dead, they got married, and you heard testimony about that. So all of that, not true, completely inconsistent. Travis Filmer states to Robert Croper and law enforcement, but Laurie said it's not that the victim is missing, it's that he's no longer walking this earth. And he just flat out denied it. But his friend, mentor, Robert Croper, and his twin brother, who said he overheard that comment to law enforcement, came in to verify it. Then Travis Filmer had told his brother, Austin, that there were times that Laurie would get his phone, send texts to Austin, basically posing as Travis. I asked him, have you ever said that before? He said, no, that's never happened, no. Austin, his twin brother, came in and said, that absolutely has happened, and he's absolutely talking to me. And I could tell because we're twins. The way we communicate was completely
I
different.
bet you are toxic.
From the way she was communicating with me. Which
I
is
just
the
spilled
same
a whole
thing you've heard
canister
from every
beads
friend
on
and
the
family
floor.
member that received texts and Facebook messages from Laurie Shaver posing as Michael Shaver since his death in November. Brings us to count 2, the accessory after the fact. The judge has read you the law on this. I'm actually going to hold off in talking about this charge a little bit till after Mr. Wiggs has talked to you. I will tell you that a person cannot be guilty of the murder and as an accessory after the fact to that murder. Accessory means they were helping another person. The evidence we have presented to you proves beyond a reasonable doubt that Laurie Shaver committed second-degree murder. And because of that, the verdict should be guilty of murder in the second degree using a firearm and not guilty of accessory after the fact, because you can't be guilty of both. But the law does allow the state to present these alternate theories depending on how the jury perceives the evidence to make that final conclusion. But I will tell you that the evidence that has been presented is not that in May of 2016, Jeremy Townsend shot this man in the back of the head, and Laurie had efforts to help cover that up. It's that Laurie killed him in November of 2015, and she, in order to prevent investigation into her own crimes, covered that up. The evidence of the cover-up is still showing you evidence that she is in fact the murderer. Comes back to that common sense. We've been talking all week about a lot of different things and a lot of different evidence
Oh,
And what
that's
I've been
nice.
trying to do here is put it together in such a way to kind of condense and show you how the bank records and the Facebook records all fit together. It's up to you to decide what's reliable, and you should use your common sense in deciding. The totality of the circumstances show you that everything points to Laurie Shaver. She had the motive, the means, the opportunity. Mike is buried in her backyard. She's the one that installs the fire pit and puts the cement slab over his body. She lied to friends, family, and law enforcement about his whereabouts for years. There was no attempts to call Michael after 2015. She depleted his bank account. She sold his property. She posed as Michael through Facebook and his phone. Everything points to her. All the evidence points to her.
Follow the evidence,
Because she is guilty of murder in the second degree.
not your reasoning.
The verdict form that you are going to be presented is not as simple as just guilty or not guilty.
I hate that, man.
We talked about manslaughter being a lesser included, so that is on here as well. The judge will instruct you that you are to find the defendant guilty of the highest level offense that has been proven beyond a reasonable doubt. So I would submit to you as you start your deliberations, to start with the murder and go through those elements. Because if the murder is proven, manslaughter is obviously included, so that's proven as well. And you don't have
That
to
is
go
so
to
true.
manslaughter if you all agree that the murder has been proven beyond a reasonable doubt.
Stay on the
There's
mic,
also
dude.
a couple questions here for you that you will also have to decide
Please
that
stay
deal
on
with the use of a
the mic.
firearm. And that is crystal clear. There's a bullet in his head, a bullet hole in the back of his skull, but the law requires that you actually designate, yes, she was in actual possession, meaning that she had it in her hand when she shot Michael Shaver in the back of the head. She discharged the firearm and it caused great bodily harm or death. The state has presented to you evidence beyond a reasonable doubt. This was not self-defense. It was not defense of others, but it was murder in the second degree. And therefore, the verdict consistent with the law and the evidence is that she's guilty of second degree murder, and that all three of those questions should be answered yes. Mr. Wiggs will be up here and talk about what he believes the evidence is shown to you, and I'll just remind you what the judge said, what the lawyers say is not evidence. You're to rely on your own memory.
That's
Evidence
a
and
very
what things
important
were presented.
point to remind
So,
them.
Either myself or Mr. Wiggs are saying something and you're like, that's not what I remember. You go back to your notes and you look and you make sure what you're being told is valid. And it's actually what was presented to you today, this week. Thank you.
All right, thank you, Mr. Canocchio. Mr. Wicks?
Yes, sir. May it please the court.
Yes, sir.
He's very
Been a long
formal.
week, hasn't it, everybody? And I appreciate y'all being here. I appreciate your attention. I know it was an arduous event. All of us sitting here listening through that. All of the
Oh,
breaks at the bench,
please.
all of
Don't
those
start your bull
interruptions.
crap
It
now.
can be very annoying.
We
It
got to
can take
listen
a
to
lot
you.
of time. It's very distracting, but those things have to happen.
We got to listen to
in
you,
the
and that's
voir
annoying.
dire, you'll remember, I stressed to y'all extensively about the Constitution. This is something we don't take for granted in a criminal case. Some
The
people may want to
shade.
downplay it. Some people may want to compromise.
I got to quit yelling. The
our
shade, the
rights,
shade,
the
shade.
responsibilities, and the privileges that we have. They can't be.
You're about
They
as annoying as
cannot
me
be
spilling all these
compromised in
damn
the
beans.
slightest event. This is a privilege we have. It's a constitution that is endured. It was created by hardship for men and women like us to live under the system we have. This system goes, we'll never have it back. We will never get it back. And it is at jeopardy at this stage.
No, it isn't.
I told you that the founding fathers in this Constitution, they recognized that liberty comes with an extreme price. To deprive somebody of liberty, comes with a lot of responsibility. Not coming in here, throwing a bunch of mud on the wall and saying, yeah, there you go. There you go. Oh, she lied about this, or here's another misstatement, or here's another misstatement. Laurie Shaver is not on trial for lying. Laurie Shaver is not on trial for bank fraud. Think about that. That the state has the audacity to come in here and state money's moved, thus she committed a murder. Guns were sold, thus she committed a murder. There's a car in the yard and a misrepresentation, somebody went somewhere, thus causation. That's a huge leap, an extreme leap. Remember we spoke about in Vordaer, and I kind of used an example, and I said, I had seen on TV about, and I believe it was Joe Rogan and Jordan Peterson talking about, I think it was Rogan talking about, and he said, I see photos and stuff and talk about UFOs. And he said, and I hear this and I hear this and I hear this. He goes, I really would like to believe in UFOs. And he says, but there's just not enough to put it all together for me. And Jordan Peterson said, yeah, that's a conspiracy theory.
Yes, I'm aware about it. What are they
What
wanting
does the
people
state
to
put
do?
together here this week? A conspiracy theory. She lied about this. Here's a misstatement. Here's a misstatement here. Here's a misstatement there. She must have murdered the guy. Think about that. Think about the draw and the stretch that the state has put out. Well, she had a motive. All right. That's a big stretch. Okay. I want to talk about the law foremost, and then we'll go over to some facts. And I'm going to show you undisputably, irrefutably, how more than one reasonable doubt exists in this case. And we know what your responsibility is. And I just ask that everybody abide by it. In the instruction,
Shit, I did it again.
it talks about, yes, what are the elements of
I
a
just spilled
homicide?
them again.
The killing, okay,
Luckily,
excusable
on the table.
homicide. Now we're talking about when the killing's committed by accident or
Yes.
misfortune. Okay, was Michael part of his own misfortune? Obviously. 2, when the killing occurs by accident, misfortune, or in the heat of passion. Okay, Michael brings on his own death. Michael comes to the house when the state never established his right to be there. We know there were injunctions in place periodically. 3, when the killing is committed by accident or misfortune resulting from a sudden combat. All right. The state wants you to believe Laurie lied about this, or there's a misstatement here, or she's sleeping around. Why did we have to hear that testimony to disparage my client? To think they're going to get emotional impact out of you? Is that relevant to this cause? Is it probative to a material fact that you have to decide? No. It's
Yeah, it is.
disparagement for the attempt to pull an emotional result out of you to fill in a verdict form. I told y'all at the beginning in my board item, the state has a responsibility to seek justice. And I said, what is the state seeking here? They're seeking a verdict. That's what it is. So most of what you heard, if not all of what you heard, is an emotional ploy for you to go back there and out of anger for Laurie Shaver, fill in a verdict form for the state. That's what's going on. That's what you've heard this week. Second-degree murder. Mr. Camuccio went over the elements, so I'll briefly touch on it again. The defendant's dead.
I
We know
miss
he's
stopping.
dead, okay? The
I'm having
death
too
was
much trouble.
caused to by the criminal act of Laurie Lee Shaver. Okay. Has any single witness taken the stand and shown you one piece of evidence
Quit
that
thumping.
established Laurie Lee Shaver killed Michael Shaver?
Thumping doesn't
Zero.
help, dude.
Zero. Case over. Period.
Hey, I'm done beating.
What they've done is
I've
brought
spilled
in
it
a
3
bunch
times.
of
I'm
digital
done.
data after the fact, after the event, and said, well, she tried to cover it up, or she didn't want to talk to this person, or she didn't want to talk to that person. Well, there's a good reason she probably didn't want to talk to numerous of these people, but a lot of it probably didn't have a darn thing to deal with the death of Michael Shaver. 3, there was an unlawful killing, an act eminently dangerous to another, demonstrating a depraved mind, without regard for human life. Okay. Has anybody established a depraved mind? No. Without regard for human life? No. Laurie Shaver was in her house when she was attacked. That's what happened. Did the state offer any evidence on causation, where this event occurred, how it occurred, any different than what the defendant and her daughter testified to? No. No. In fact, you may remember Tamara Dale. She gets up there, and I talked to her about it. And I said, you don't have any DNA, do you? No. You don't have any prints, do you? No. You have nothing in the scene in the house to suggest any activity, do you? No. You don't have anything in a gravesite, do you? No. You don't have any prints in there? No. You don't have any DNA in there, do you? No. You don't have any gun that links Laurie Shaver to the crime, do you? No. You don't have any confession, do you? No. You don't have any witness, do you? No. She admitted all that. And then her response was, well, how could we solve a murder any other way if we had to have all that stuff? Because you normally have that stuff if a murder has occurred and it's attributable to one person. The state tried to compromise that obligation. Do you remember? Do you remember how? They said, hey, Mr. Camuccio said, you're not going to hold us to that standard like CIS that you see on TV, right? Trying to lower what you could expect to see in this case. You're right, he said that, because he knew he didn't have any evidence. So he wanted to mentally prepare you to get you ready to not see evidence. That's what that was all about. You remember his statement earlier as well? We talked about the burden of proof. You'll remember that. And I talked about it in voir dire, and I talked about it, I said, it's kind of like a football field. I said, in a criminal case,
I'm going to object.
this is an analogy for closing.
Let's have a sidebar, please. Thank you.
Okay, y'all. We have an objection. Sidebar. What do y'all think? What's your opinion? Waking up, I'm not going to be beading anymore today, y'all, because let me tell you, it sucks when you spill your jar 3 times, once on the carpet. Oh, and these beads are like itsy bitsy teeny weeny beads. Look how little these beads are. Microscopic. If you ever drop anything like that, and you have to salvage, lint rollers work wonders. Yeah, Pamela, that's a good way to put him. I don't like his patronizing way of talking, and I understand he's to debunk, for the lack of a better word, the prosecution. I get that. But the patronizing part of it,
Football field. And I said, look, if it was a civil case and the standard is beyond reason, is by a preponderance of the evidence in a civil case, that's just tilting the scale, getting past kind of the center of the field. But in a criminal
they are
case,
seed beads,
where
my
our
dear.
founding
I've spilt
fathers
the whole
put
thing.
the premium on
Salvaged
liberty
99%.
and the obligation on the state, I said it's the highest standard required under the law. You got to be on the end of the field down here. There's a high difference between this, which can't be downplayed in this case by the state.
Guys,
throwing
it is
some
our
mud
job
on
to
the
hate
wall
him
and
because
saying,
he's trying to
oh, there
defend
was a
her.
lie here or there was a lie there.
He's
You
good.
see, the state can't compromise that.
He's trying to put doubt, which is what he's supposed to do, and by him attacking the
Go on a little bit.
the constitutional, I don't like it,
When
but
we
I see
talk
where he's
about
going with it. I
depraved
do.
mind, and you hear that word, and you'll have a complete set of these instructions. You go through them at your leisure, need be. Okay, it says, an issue in the case is whether Laurie Shaver did not have a depraved mind, with that mind without regard for human life, because she acted in the heat of passion. Okay, inadequate provocation. In order to
Now
find
they're
that the
saying it's a
defendant
heat of
did
passion.
not have a
What is
depraved
it?
mind, then it gives you some factors to consider. There must have been a sudden event that would suspend the judgment. B, a reasonable person would have lost normal control. Driven by blind or unreasonable fury, there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act.
Does it matter? It does. Yes.
Y'all saw these photos. Y'all know there were repeated acts of violence in that house. This was not a blind event that Laurie Shaver just stepped up for her child and said, I'm not going to act. They knew what was coming. And this is evidence that they knew what was coming. We had multiple injunctions that were filed with the court. Michael Shaver had been prosecuted in the past, and the state wants to sit here and say, hey, this was some blind event and she just murdered her husband. I'd like to hear an explanation for that. Move on, son. Let's talk, because the state's going to have the last word in this case. They always do. We don't have the privilege to respond to their last word. Okay? Let's think about this. She's charged with accessory after the fact as well as a crime. What are the elements of this offense? And let's think about it. They state that a murder in the second degree was committed by another. State has a real courage to announce who that another person is in the elements or in the information. They don't have the backbone to tell you here who the actor is, who the principal is. And yet they'll come into court and say Laurie did it. Then it says, after the murder, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid another person. Stop right there. We see and hear talk about money going into the bank or going there. Okay? Is there been any showing in this trial how any money was moved to assist, aid, or attempt to aid somebody in escaping detection of a crime? No. Laurie's using money to live a life, feed her kids, that the state can't not deny is marital money, equitable money, that she didn't have a right to touch it, anything like that. But it's all a pull for you. And then it says, and at that time, Laurie Lee Shaver knew that the other person had committed murder. Okay, let's think about that. That's an important element as well. And I'll tell you why. If you have a right to self-defense, no crime has been committed. If somebody dies, no crime occurred. So you'll have to assess, was there a right of self-defense? If so, no crime has occurred. 2, where was money being spent to aid detection for somebody who had not committed a crime? You see? Does that make sense to you? Under the justifiable use of self-defense, it represents, and I'll just highlight some of this for you because I want to talk about facts. It says Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel was justified in using or threatening to use it if she reasonably believed. Now we know the history in this family. That's undisputable. That's physical. That's not to be questioned. Was necessary to prevent imminent death or great bodily harm to herself. Okay, and then it goes on and tells you, well, what's the type of harm that they suspected would happen? Michael's trying to kill her, or he's trying to commit an aggravated battery, and then the instructions tell you what that is, what the elements of first degree murder are that Michael's trying to do, or how he's trying to create another hard battery on her. Okay, and that's spelled out in these instructions. Then the instruction will tell you as well that justifiable use of force is justifiable if Laurie or Isabel reasonably believed that the force was necessary to prevent imminent death, meaning that a murder, attempted murder on her, or great bodily harm. Has the state eliminated this defense? No, not at all. They want to throw mud on the wall and say, well, she lied here. She spent some money here. But they can't say first and foremost, she didn't have a right to defend herself, to establish that a crime even occurred. It's actually, listening to this case, I got to tell you, I'm spun around listening to it. The judge is going to give you an instruction because they've made an issue in this case out of this. And it's an important instruction because it kind of strikes a nerve in all of us. And it says this: you must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. Laurie Shaver could watch Jay Townsend shoot somebody and had no duty to call the police. Isabel would have no duty to call the police if she hadn't shot him or done anything. Okay? That's a fact. That's a law. The state will act otherwise. Like, no, they could have called 911. Why didn't you call 911? Again, we spoke about this in board. Let me grab. foremost, I'm going to say, excuse my handwriting. Okay? Probably the worst penmanship in the state of Florida. Anybody. But anyway, the judge will tell you that a reasonable doubt, they're in your
Y'all, I'm going to
instructions.
take a
I
comfort break. I'll
briefly
be right
spoke
back.
about it because this is very important. If there's one reasonable doubt, it is the requirement, the responsibility, the necessity of any and every jury to return a verdict of not guilty. Not guilty. How does it arise? From the evidence. It can arise from the evidence itself. It can arise because of the lack thereof in the evidence. It can arise by a conflict in the evidence. Those instructions tell you. And they further say that if your feeling is not stable, but one that wavers and vacillates, you got a reasonable doubt. You see? Now let's shift over to the facts and talk about some of those facts. One we spoke about, and I want to remind you, the burden of proof is entirely on the state. Ms. Shaver was not required to take the stand, expose herself to criticism, ridicule, or the misstatement here or there. That burden stays on the state. We know, in this case, it became evidently clear, and should be to everybody here, that Ms. Shaver was in a marriage that had gone bad. It was a case of where children lived in an environment that, as Isabel said, it just became commonplace to see these things happening. My dad striking forcefully, acting out on my mom, and she said, I soon developed an attitude of feeling a need to protect my mom. I soon just responded with a attitude of response trying to protect my mom. That's how bad it got. So she said on the day that this happened, she goes, she was kind of in shock, went to school and just kind of tried to put it out of her mind. And that's what happened. And yet the state, despite all this, wants to criticize that girl who's a victim in this case. Shame on them. This little girl is a victim of a house with continual domestic violence. And the state says, well, why didn't she get counseling? Why didn't she get counseling more? The state chose to ignore this girl. She was brought to their attention, as well as Mr. Ballou. Mr. Ballou had prior tensions with Mr. Shaver. That's why his name was mentioned. Mr. Townsend's name was given to the state. The state took no aggressive action to look into this case. I asked Tamara Dale, state talk to you about this? Did you make any efforts to go see her? Not ask Kelly Johnson, hey, if she wants to come by, why don't you just bring her over? I mean, is that investigation? That's not investigation. That's just saying, bring us some evidence. We'll
How did
maybe
I
look at
know
it.
he was still going to be going?
State was aware of the domestic violence in the house. They had evidence.
Go lay down.
They had prosecuted
Go lay down.
Mr. Shaver
Said
for a
lay
battery.
down.
They knew about it. Wilma Nichols gets up there on the stand and says, yeah, well, Michael's story at an earlier date and time was that his wife attacked him. I said, are you talking about the same incident where he was prosecuted and the state went after him? Well, yeah. Yeah, that had a lot of merit, didn't it? There was nothing contrived by Laurie Shaver and this minor child. Now listen to me. The judge is going to tell you you had the privilege of believing all, some, or none of the witnesses' testimony. So if you find that there was misrepresentations by Laurie Shaver here or there or one way or another, okay, you can disregard those. You can say I don't believe that truth. But again, whereas the state led you to believe that Laurie Shaver killed Michael Shaver, they haven't.
Y'all,
There's no evidence in that regard.
why can't I hear myself? Can't even hear this.
We know there was times when Michael was not residing at the
Are y'all
residence.
hearing this?
That wasn't contradicted. His former girlfriend gets on the stand and says, yeah, he was living at the hangar here and there. Laurie said, I let him in the house. There were injunctions. He was coming and going. Did the state offer evidence that there was not an injunction or he was not restrained from the house, not permitted into the house on a date specific when any homicide occurred? No. No. Now,
Are you
let's
hearing
shift
this?
over to, for a moment, to the digital data. That was interesting to me. Kind of interesting. Okay. You got some guy at the sheriff's office, corporal, he had to advise me, that does some tech work out of there. We never heard his qualifications, any experience really he had. Okay. I heard a lot of arguments from him.
Thank you.
But
Got it.
we heard Connor take the bench, a man that had been involved in I don't know how many trials, federal trials, trials everywhere. And he had testified in court with his special skills. And he spoke to us real clear and simple. And he said, now think about it. He said this, the IP records from Facebook, CenturyLink, etc., at a point in time, they expire and don't tell you the physical address it's coming from. They may have IP logs, records, you see, but you don't know where it's coming from. It could be Starbucks, it could be overseas, it could be here or there. So the state, trying to throw some mud on the wall, says, look at these IP logs, look at this, look at this. But you know what? It doesn't tell you where it's coming from, any device, or any user. You see? That's a significant fact. So the state says, well, somebody sent this and somebody sent this and this went here and that went there. That would create a lack of evidence, a conflict in the evidence as well. And it certainly would not create stability in the way in which you think about it. If Jeremy Townsend is sending some of these, he could be at Starbucks, he could be at his house, he could be anywhere. He could be in a driveway, and he certainly had a motive that can't be excluded. Now, this child wants to be the state disparages this child because she doesn't know it's state specific. She said sometime in the spring. She didn't say summertime. Mr. Camuccio went on and he said, now today, well, she said the spring and the summer. And that's not true. Mr. Camuccio's not presenting evidence here today, but some of his statements were not accurate as to the content of the witnesses themselves. You'll have to rely on your memory, the notes you've taken here. Now, there's a discrepancy exactly, precisely, in what Laurie said and what Isabel said. Isabel, I believe, says, and you have to rely on your memory, she made some statement to the extent Jay threatened to kill us or something of that nature. Laurie said he implied it or something to the children. There was a little discrepancy, but they got the message loud and clear. Okay, don't tell anybody or you guys are going to get in trouble and you're going to be harmed. So One, she doesn't have a duty to report anything, and somebody's threatened her. She's been the victim, we know, of repeated violence. It kind of makes sense this woman doesn't want to come forward with that kind of threat against her. It kind of makes sense that Isabel is not going to school and wanting to tell everybody all about it as well. Now, let's talk about a little bit about this shooting. The state's made issue of this, and I want to bring something to your attention, and I hope you picked up on it in trial. We heard from Dr. Shaw, the medical examiner. We heard several things I did, and it was brought out through his testimony. One, he said there was a gunshot here to the rear of his skull, and we know that, okay? And I elicited testimony from him when I said there was no soft tissue on this body, correct? Yes. And I said, could it be that somebody shot through some soft tissue and that may account for the presence of the shrapnel? He says, yeah. And so you may have a bullet that goes in, exits the night, and there's some shrapnel in that skull. I asked him, did anybody do any meteorological testing on the fragment together with the shell to see if they were linked together? No? Now, who's in charge in directing them to do these things? The state. Does that create a lack of evidence? Correct. Does it create a conflict in the evidence? Yes. Does it create stability in your mind? It shouldn't. Okay. Whose obligation is that? And the burden rests with to come in here and prove these facts. The state and only the state. Now, one thing further I brought out through Dr. Shaw, and I know you all probably heard it. I don't know if you picked up on the significance of it at that time, but I asked him about injuries and the nature of the injuries that existed on this body. And I said, were there post-mortem injuries to the body? And he said, yes, there were. And he noted several ribs. And he said those were post-mortem injuries. And I said, when we talk about post-mortem injuries, how do you identify them? And he described about buccal fractures in the ribs and the way to identify it. And he said, this is where the body is broken after the death, and there's a discoloration in the ribs here and there. And I said, could that be accounted for? And he said that can be accounted for by moving the body.
CPR.
Correct. So
CPR can
Jeremy
cause that.
Townsend logically tells Laurie Shaver, I'll take care of this. She understands they got property elsewhere, logically. That body disappears at that time. Now, when did the body logically and arguably show up? When after that shooting, when Laurie said, it's over. It's over. Okay. She even took the stand, and I thought this was kind of sad listening to this. And after all the violence she incurred, she started crying and saying, I still loved Michael. So we know any relationship between these two was logically over. Now, maybe, and I don't know, we talk about flowers being sent, cards being sent. Was that sent by Laurie maybe to make sure Jeremy's not coming back? Maybe to get him in trouble with his wife? Possibly. You may interpret it that way. Now, we also heard from Mr. Cios, remember? And the state called him. It was their witness. And he said, I asked him this, Didn't you call Laurie, advise her somebody was trespassing on your property? Yeah, she was gone, and I saw somebody trespassing. Who had any motive to come back to that property, deliver something back to that property if it had been removed? Jeremy. You see, that fits together a little tighter. Now, talking about that gravesite, did the police think about the depth of the site, the height of Mr. Townsend versus Laurie Shaver? No. Never even analyzed that mentally. It's not that difficult to think about that. Okay. Also, there's a blue tarp in the grave, right? We heard all about that. And I said this, and I don't know why this wasn't done. We had told the state about Jeremy Townsend. I said, did anybody do a financial audit of anybody's accounts to see who may have purchased a blue tarp? No. They should have. I'm telling you, if they had one on my client, they'd be in here waving it up in the air. It's her tarp. Lack of evidence, conflict in the evidence. I asked the officer as well. I said, did you guys, I said, you didn't find any prints on that tarp, did you? Now, I like the way the state tries to cover some of these lack of evidence up. Okay, I really kind of got entertained by it at a point. They'd say this, well, you weren't surprised, officer, that given the evidence was degraded that you couldn't find that, could you? No. And I'd say this, hey, what do you mean degraded? The evidence may have never been there in the first place. It could have been degraded when it went into the ground and evidence was put on it prior. How do you know the condition of the item before it went in the ground? But they had to acknowledge that, yeah? So the state would repeatedly, to try to cover up the lack of evidence, well, you're not surprised at this. It was all degraded. You wouldn't expect it to be there, would you? No, no.
That's
No.
true, case one.
So that's how they try to defend themselves against the lack of evidence. We saw that repeatedly in this trial. Now, we heard with regards to the TARP, the state never investigated it. One, party with the burden of proof. Two, we heard Laurie and Isabel both take the stand. We didn't have one. We didn't have one. Now, that logically goes with the theory that that body had been off the ground, off that site, because it comes back to the property and it ends up in the gravesite. Can we assume that Mr. Townsend put that in there with the straps, wrapped it up, took it off site, damaged the body, brings it back and puts it in the grave? That's a logical conclusion. I asked the investigator, I asked the tech people, listen, were there any telltale signs on that tarp that tarp had been dragged across the yard? Huh? What do you mean? I said, did you ask for any kind of chlorophyll testing underneath it to see if it had been dragged by somebody? No. You see? Do you know if Laurie took it out there? I don't know. Do you know the distance from the house? No, we don't. Somebody else can tell you that. So what does the state do? They offer some evidence showing she's working out, and you're just to jump to this conspiracy theory and say she could have dragged it out there. She could have done this. She might have done this. for you to fill in the gaps that the state failed to investigate? And that's what we see in this evidence thrown in your face without a real connection. You look at the forensics. I brought out, state didn't do it. The defense brought it out. There's no DNA in the house, no evidence of how the crime occurred in the house, no prints, no hair analysis, yet there were hairs. Okay. No match of any flooring that was found in the gravesite to implicate Laurie Shaver. Those all create a reasonable doubt. The state can't ignore it. Instead, they just want to say she lied about this or she lied about that and she's sleeping around. That's their case. That's the state's case. Now think about the gun we heard about. We have a gun in evidence. Again, kind of a comical display to me. You get this lady up there, and she goes through this litany as to her experience and everything. And she talks about, well, it has the signs of other guns, meaning this manufacturer that make Colt or Smith & Wesson that may manufacture a 38. They got a machine. It's going to have ridges in it. They all have that common characteristic. Millions of them. Okay? But she can't identify any specific features of the gun. She can't narrow it down from millions to say it's this gun. Wow. Wow. So the state says it can't be excluded? Oh, no, it can't be excluded. Right. That's reliable evidence for you to hang your head on and to fill out a verdict for the state? No. The state's position is, well, we don't have to prove this case by 100%. No, they don't. Okay. That's not their requirement. We know what the requirement is. When Jeremy Townsend, the state was informed of Jeremy Townsend, why, ask yourself,
Banging on the
didn't they
stand,
look
too.
into his financial records? Lack of evidence. 2, why didn't they look into his Facebook aside from his banking? Do you remember what the testimony was on that by Tamara Dale? Here's
What?
what she said. Well, those records were too old. What do you mean they're too old? You're going to stand in here and tout that Laurie Shavers are reliable at the same period of time and not look into Jeremy Townsend, who you've been advised shot the guy? And not even look? Not even look anywhere into his matters? No. She was closer to the body. Okay. Now, let's talk about the patio. State thinks that's a big deal. I don't. Why? Because they cleaned it out to make a pond. We all know that. Okay. They get tired of building this pond and it sits for a while. Concrete is bought. Now let's think about that. Nobody goes and tries to conceal themselves when they're buying any concrete. They don't go paying cash. They don't go in there with a hat on or anything like that, trying to disguise themselves. It's open and clear. They're not trying to conceal themselves. They go rent a mixer, not trying to conceal themselves, not trying to make it private, or a hidden event. They even post it on Facebook. Like this is a big secret? No. No. Who would do that?
Some ways to
If they
hide a
tried
secret is
to
to not
hide
hide the secret.
a fact against the public and knowledge. You wouldn't do it that way. That's just common sense. Okay? You take the evidence and then you rely on your common sense or the lack of evidence thereof. That's the point. Who would write their name in concrete on top of a grave of somebody that they allegedly murdered? Not any person in the face of this earth would
Oh,
do such a
yes.
thing.
Are you kidding? Some people
You
take the
got to
body
admit
parts and
that.
wear it around their neck.
So you see, there's another reasonable doubt the state can't account for. We
That's
had
not
Holcomb,
reasonable doubt.
officer, take the stand and said, oh, it was right in the middle. Okay, like it was obviously trying to be concealed. Wasn't when I pressed her on the video. She said, well, you know, it wasn't on the middle actually. Then the next officer said, well, it was a darkened spot. And you look on the photos, well, there's about 3 or 4 darkened spots all over the place. Okay, doesn't mean, you know, we know there's a body on there. There is clear evidence of guilt or anything like that. I want you to think about all those things that create a reasonable doubt. There's multiple, and the state can't excuse that. They cannot excuse those factors. There's a question, who killed, actually, Mr. Shaver? We know there's shrapnel. We know there's one fragment, but the shrapnel could have been a second shell. We know that from Shaw himself. Has the state eliminated self-defense? No. No, they haven't. Who has that burden exclusively and only? The state. We know this is a violent man who most likely didn't have a right to even be in the house.
Why did she
Is
let
there
him?
evidence that the body was moved? Yes, there is. Has the state refuted that? No. Why no forensic audits? None. Now, again, the state is looking for a verdict on something. Give me something. Give me something. So they got lessers, a primary, and an accessory. You have to understand, Laurie Shaver is not guilty. She's not guilty. Don't be pulled into an emotional game trying to compromise, thinking you're doing justice one way or another. You have to understand that. Laurie Shaver is not guilty of any crime. She has not committed a crime. The state has not refuted it through an investigation and presentation of evidence in this case. Again, I'll remind you with regard to the crime of accessory, it must first be established that a crime was committed. If there was a right to self-defense, no crime has been committed. You see? And there is anything that Laurie Shaver did was lawful. The state can't link up any transaction unjustified or evidence of a cover-up if there is no crime that is committed. Likewise, the crime of accessory must establish a firm timeline as to when the crime occurred. You're not at liberty to say, well, the state says this and Laurie says this. Let's just pick a number. Could have happened between this date. The court will instruct you that that accessory requires the completion of one event before the start of an accessory offense. Okay? Has the state firmly established that? No. What they do is they say, well, there is, he didn't show up at work, so you got to admit, you got to assume that she murdered him. And then let's take the next step and say all this stuff was to aid or assist in concealing an offense versus living expenses and money that she had a right to touch and use. An accessory, when you see accessory, normally what you would see is somebody buying somebody a flight ticket to leave town, putting them in private housing, doing things to conceal them in that manner, not living like this. It kind of reminds me, this case, when I listen to it. It's all, it's all speculative, what you call circumstantial evidence. I'm sitting here listening, sitting at my table between approaching the bench, I guess, and listening to this, and I'm going, it's like playing a game of Jinko. Sooner or later, this thing's got to topple. You can't just keep putting little boards on top of each other without a firm foundation, you see? It's not going to stick. So the state just piles up some evidence and says, there you go. Come back here, reach us a verdict, okay? Give us what we want. Now, again, I remind you, and I'll sit down, leave it to you. The people that may have been misrepresented, the people that any lies or misstatements were given to, really are not relevant in this case. Laurie's not on trial for lying. She's on trial for murder. Any misstatement must have been to make and conceal a crime which never has occurred. You see, if she lied about Michael, where he was or what happened or where his tools were or where he'd been, is not really relevant in this matter. So don't be distracted in that regard. Going back to the digital data, I'll leave on this. Remember, I asked these witnesses, did you find anything in the digital data that announced or indicated somebody had shot anybody? No. Did you see any evidence in the digital data of any effort to conceal a crime? No. Could you tell me where this was coming from physically? No. Could you tell me who was using the device? No. So what did we have? I found it, I don't know, I don't want to say it, but we get memes thrown in front of us and some emails from this place to that place. And you're supposed to say, let me hang my hat on this meme. Sometimes you got to burn a bridge and move on. That means Laurie Shaver killed somebody? And that's what the state is asking you to hang your hat on and just pile up a bunch of memes like a Jinko game? No. That's not how you prove a criminal case with suspicion, bare innuendos, without physical evidence of guilt. Now you have, likewise, and I mentioned it to these people on cross. I said, you got a certificate over there, a business record certificate from Facebook, right?
I'm gonna check. Approach.
Sidebar, please.
Business record certificates from Facebook. Really interesting. I brought it out on cross examination. I mean, kind of floored by it. But here's what they say. In essence, read them yourselves. Well, we once had this data. We gave it to you earlier. We're sure we gave you something that was accurate, but we don't have the information anymore. So we got to just assume it was accurate. Okay? That's what the state's going to hang their hat on and say this digital data is even reliable? for your consideration, that's not even digital data. And we know what Connor said. You can't even link it up from this place to this place because IP addresses have expired the physical location, and the state's hanging their hat on it to throw all this out there. It's unbelievable. Further, the state doesn't even have a computer. There's no computer in this case. Not a computer for them to try to connect it to. I want you to think about these factors. This is where, ladies and gentlemen, my power ends. This is where yours begins under our Constitution. I can only ask, I can only beg you to do your duty. Don't compromise your duty. I've listed to you multiple reasonable doubts in this case. They should never be compromised by any single one of you. I asked each and every one of you as well to please hold your verdict, and if it disagrees with other ones on this verdict, on this full jury, that you please hold your ground. I've shown you everything, every way the state has failed in this cause. Don't be misled, I ask you. The state will have the last word in this case. They always do. Wasn't like that always when I practiced law, but it is. But as Mr. Camuccio speaks, I ask you to listen. Give him the due concern that you've given me. But I ask you to ask yourself as he speaks, what would Mr. Wiggs point to refute that? Have you answered Mr. Wiggs's questions? What about this question? What about the grave? What about the lack of evidence? What about the gun? Let's hear an answer to all these things. He can't give you an answer. So I ask that when you go back there, I know the answer, which should be given by you, but I can't do it. But I ask you to do the right thing and come back on all counts, all issues, and do justice, not seek a verdict for the state. Seek justice, as I've asked, and return a verdict on all counts of not guilty. Thank you.
All right,
Thank you, Judge.
Thank you, Mr. Wiggs. At this time, I'd like to give the jurors a comfort break. We've been in proceedings for nearly 2.5 hours, so let's take a 10-minute comfort break. Thank you.
Guys, I'm kind of going to Broken Baker just to give him hell, just because I can.
Are we stand down, Judge?
Yes, sir. So we're in recess for 10
You're right.
minutes.
It
Thank
was
you.
a crazy exit. He is delusional. Everybody is like, this is the worst defense attorney they've ever seen. I'm all like, yep. Let's see. I'm gonna hear him in my sleep and not in a good way, y'all. I'm gonna be hearing that man in my sleep and not a good way. I was teasing over at Broken Baker, and I said, "This sounds like a preacher that should have retired years ago." Years ago, and then Zach comes up, "I'm a retired preacher," and I said, "Yeah, I know, I'm a chaplain, so I can say it." He's fighting as hard as he can, but he's not it it his logic isn't together for me. Ooh, I got something started over there, I'm gonna not look. I got something going over there about preaching. Now you wanna go watch? Oh, yeah. Oh. Yep. Oh, yeah, now they're going off on who wrote the Bible. I did not mean to get that started. Yeah, very guilty. I I wonder what's gonna happen, honestly, I'm concerned for the daughter. Out of all of this, no matter what, at some level or another, that girl is a victim, and I'm worried about her because if mama goes bye-bye, if mama goes bye-bye, honey boo boo, we gonna have a problem. Mm, that poor baby girl needs some TLC. That baby girl's well, I don't either. Um, why didn't I bump my camera that way? That is not the way it's supposed to be, and I'm supposed to be zoomed in a little more. The way I see it is this little girl. Well, psychologically, clinically, it's proven when a major trauma like that happens, a lot of times we get stuck emotionally back at that stage on a certain level. Girl, I have 500 of these. Do y'all want one? I'll be happy to share if I can get them to you. Yeah, I'm handing these out to our customers. I got seriously 500 of these. Someone gave me the biggest box I've ever seen of these. I probably only eaten about 20, if that. If you include what's sitting in my desk, there's 25 out of that. So 475 of them. Mhm. If there are 500 people on here, I have enough to give everyone one. I'm looking at my little logo over there on top. I think I need to add some red down below and some of that blue and yellow. Mm. But anyway, no, I am not surprised at the way the defense is. I mean, a lot of people are saying a lot of stuff. Everybody's a little irritated with him. Um, I get that. I really do. Hey, I want a membership over there. Oh no, Dallas born Boston. This jury should be the 12 disciples. What is with the six jurors' name? Oh no, what did I start? What did I start over there? Um, I love this. Listen. Oh, this is funny, y'all. I'll read it. It's not like we're going political, religious, so to speak, but it's funny. Um, someone said, "How many tribes of Israel were there? How many disciples?" And someone said, "Baker, can you say and do whatever he wants at this point?" The lawyer. Uh, then Nunya Bitness, hey Nunya Bitness, Nunya Bitness is over there, and she said, um, this guy needs to retire because he's lost his mind. Yeah, I was like, definitely, he had lost his mind. So anyway, and then they're like, make him stop. And then someone said 12 tribes, 12 named disciples. Does that does this man speak on two times speed? Everyone's like, let's speed this up. The jury, okay, there's a lot of people who are upset that the only in Florida, the only time they have a 12-person jury seated is if this is DP. Right now, it's a 6-person just with a couple of alternates. And so they're saying this should be the 12 disciples. Uh Everyone's being summoned by a higher power. Just play Charlie Brown's teacher to represent what Wiggs is saying. Wah, 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 wah. Oh, I'm seeing this over on another live. Uh, I started something over there. I said over there that this guy reminds me of a pretty much a washed up preacher, but I didn't want to go that far. And someone over there who we know, Zach, says, I'm a retired pastor. I said, I still is one. I am. And so and then they got started on the disciples. There weren't 6, we need 12. Yeah, I know, it's crazy. I love watching other lives, kind of see what's going on in their chat and how it's going, and I really appreciate um other content creators. But didn't anticipate getting a membership for free. Thank you very much. Oh my gosh. We have gotten almost 600 views on our ASL post with the debate when we were interpreting the debate in ASL. So that's always wonderful. That is always wonderful. Okay, let's get this back up there with me. Hello. Corroborate. No, I was over here for this one. Why is it way down there? Oh yeah, I'm too close. Um. Oh gosh. Yeah, I'm I tuned out on that one. I'm sorry, guys. I I just reminded me of old school stuff, and I'm just like done. So I'm going to go in here and try. I didn't ask for this. I want this over here. I want this in. And okay, they're coming back.
Oh, you may be seated. Wait for Mr. Wiggs and his client to return. Thank you.
Hmm. I wonder. They still talking. Are you gonna say, I plead guilty, Your Honor? Is she gonna plead guilty? Pin your jury watch and Winston from the jury and so on. What? Weston from the jury and so on? I don't know what you're talking about, love. We're not there yet. When jury goes in, I actually have a banner.
Are we ready for the jurors?
Yes, sir.
Yes, sir.
Okay, please bring in the jury. Thank you.
Mm.
You may be seated. I see that all of the members of the jury have returned. State, you may proceed.
May I please record?
Yes, sir. Counsel.
Yes, sir.
Mr. Wiggs asked who would write their name in concrete over the grave of their dead husband. A woman who killed her husband with ill will, evil intent, hatred, and spite, and then over a period of years covered that up with lies and manipulation against all the people that knew him. That is who writes their initials on top of that grave. And that
Snap.
is what happened in this case.
That. Wow.
Mr. Wiggs brought up numerous things. I'll try to address as many as possible, as quickly as possible. But some of the things he said, I ask that you go back and think about what's your memory of the evidence and the testimony and realize that that's just not the way it happened. One of the things he brought up was talking about how the state didn't bring you any things about how there was no DNA evidence in this case. I did. Edgar Perez from the Florida Department of Law Enforcement testified about the DNA analysis in this case. Who called him? Mr. Wiggs? From state. We presented that to you. We presented you the fact that what the DNA evidence was, and the fact that it's not that it was someone else's DNA and we can't match it up. There's just not enough genetic material in anything that was in that gravesite to compare it to anyone. But that came from the state. And Mr. Wiggs got up here and talked to you and said that he was the one that brought that up. And that's not true. It just goes back to you can't trust the little things. How can you trust the big things? He talks about what he refers to as shrapnel in the skull and how that's evidence of potential 2 bullets. That's what Dr. Shaw told you. That's not what Dr. Shaw or Dr. Coverley told you. They said that shrapnel is not evidence of a second bullet, but when there is gunshots like that, typically there will be small metal fragments from the bullet. There's only one entry wound. There's no exit wounds, and there is one projectile. There's no second bullet. There's no second shot.
talks about how the state has presented no evidence to refute self-defense. The state has presented undeniable evidence that Michael Shaver has been dead since November of 2015. And if he is dead in 2015, he can't possibly be on the Shaver porch sometime in May in 2016 and have the events that were relayed to you happen. That's how we've proven to you beyond a reasonable doubt that this wasn't self-defense, because we've proven to you beyond a reasonable doubt that he has been dead since November of 2015. And if he's been dead since November of 2015, Jeremy Townsend had nothing to do with it, because that relationship had just started at that point, continued up until April of 2016 when the affair was exposed, and then it was over. Laurie Shaver can tell you what day she kicked her husband out of the home in November of 2015, but cannot tell you the day he died. Think about that. Isabel can't even tell you what month or what year, but Joy says she's a kid, that's not a big deal. Laurie Shaver cannot tell you the day her husband was killed on her front porch. That is completely unreasonable. And the only reason for that is because she's afraid I'm going to find something in some of these records to completely refute it. So if she tries to keep it vague, that's harder to do. But Michael Shaver has been dead since November, and if he's dead in November, the way Isabel and Laurie described these events to you could not have happened, and therefore it's not self-defense or defense of others. Once again, talking about Isabel and her inability to even remotely tell you when this happened, Mr. Wiggs says that I just completely made up this summer time frame. I asked you to go back, think about her testimony, look at your notes. When I went through and I asked her, can you tell me what grade you were in? No. Can you tell me what year it was? No. Can you tell me if it was around a holiday? No. The best she could do is say that we went to the beach, so it was sometime between spring and summer. And then I asked her, what spring is to you and what summer is to you might be different to me. So what is spring to you? And she said April. I said, what is summer? End of summer. And she said that would be before school, August. That was her testimony. But to rely on your own memory of those issues. Briefly talking about accessory after the fact. And the reason why I say briefly is because the state has presented to you evidence beyond a reasonable doubt that she is in fact the murderer in this case, because her husband was killed in November of 2015. The evidence, the story, with all of its holes that the defense has been presented to you, if you were to believe that and ignore all the evidence and just ignore the facts that Mike was completely disappeared off the face of the earth for 6 months without a car, without a job, without a bank, without a phone, without any contact from friends, family, coworkers for 6 months, and showed up without a vehicle, dressed in shorts and socks, and this event happened in May. the events as described to you by the defense show that she's guilty of accessory after the fact. Even if the initial shot by Isabel was in defense of others, according to them, when Jeremy Townsend comes up and shoots again, coup de grace, puts him out, kills him for sure. That's not self-defense or defense of others anymore, folks. That's murder. And when Laurie lies, manipulates, and covers up the fact that her husband has been dead for years, that's maintaining, assisting, and another person to conceal evidence of this crime. The defense's story is that she's guilty of accessory after the fact. The evidence in this case is that she's guilty of second-degree murder. And as I told you, the law says you can't be an accessory to your own crime. One of the things that I think is very important, one of the details that also undermines their whole disappearing body story, is Laurie's actions when law enforcement comes and excavates the gravesite. First and foremost, their story is somehow in that short drive back and forth to Pine Ridge School, Jeremy somehow got the body out, cleaned it up. They speculate maybe he drove a couple hours to Crystal River to hide the body up at his parents' house for a while, only to return at some other point to bury the body unbeknownst to Laurie Shaver in the backyard. She never notices any, like, oh my gosh, why is there upturned dirt here? And then returns the body, buries it without her knowledge, and of the entire 5-acre plot, she just so happens to choose that to put a cement slab down. That's completely
Yeah, you'll need giggles.
But she needs to say that in order to convince you that she didn't know the body was there. But you have evidence that absolutely refutes that. Because Jessica Wade testified that they were doing this search and this excavation. And Laurie sat in her truck and was sitting there the whole day, the whole time watching. When did she leave?
Nope. A lot of hot air. Now,
Started to
guys,
pull up
what
that
do you think
concrete
about this one?
over the body of
This
her dead
little,
husband
what I
that
call
she murdered?
banner versus
Law enforcement, when they were done, the process, when they were done,
that one. Which do you like better?
search,
A,
took a
which
couple
is this
days.
one,
Detective Strickland
or B, which is that one?
said, Laurie Shaver, we are done all our work. You are allowed to come back to your property.
Toxic.
Would you
That's
like to
awesome.
know what we took from the property? And she said yes. And he went through and proceeded to tell her everything that they took. We took some swabs, we found some projectiles, we took some other items from inside the house. We took skeletal remains from your backyard. And this woman who is sitting here trying to convince you she had absolutely no idea that her dead husband was buried under the cement slab that she poured or helped pour, had no reaction whatsoever. That's why we played that call. That's why we had that for you to listen to. So you could see just how she reacted when told there was a dead body in her backyard.
Yeah, how did she
Nothing.
react?
Because she knew it was there. She absolutely knew that. The defense has talked about how law enforcement, how their investigation, and, you know, they didn't look into self-defense. They didn't look into this story.
It's the
And
colors.
Despite the fact
Here's
that
A.
Kelly Johnson sat
Look
up
at the
there and
frame.
told you, yes,
And look at
the
the
state
colors.
was asking me repeatedly
E.
if I was going to produce my client, yet I did not do so until they issued a subpoena to her for deposition, thereby giving her immunity. I wasn't going to allow her to talk to them. But he wants to put the blame for not looking into her on me? When the witness he called said I was the one preventing it because I was doing my job as an attorney, and he sits up here and tells you that's me not looking into it? That's just not true. And it's not true based on the evidence he presented. He also talks about, in this, has the state
Are y'all potentially
eliminated
going to adopt
self-defense?
this baby?
And it always is going to come back to the evidence shows you that Mike Shaver was dead since November of 2015. And that is overall how the state has proven to you it's not self-defense, defense of others, because that story in May can't happen if he's dead in November. But also
Just
think
don't
about
call him Shaver.
whether or
when you
not
got
their
him was
story is
during
even
this trial.
reasonable in this
Don't
situation.
go there.
The scenario as outlined by Isabel and Laurie happens. What reasonable person is not calling 911 to let
It
them
may
know?
not have been termination. It may have been
I'm not
surrendering.
saying do it in front of Jeremy under this scenario that they've outlined, but go some other place, call 911,
women-
explain what happens.
Just surrender them.
The idea that Jeremy comes in, sees Mike Shaver shot, and then in that scenario decides he's going to shoot him again and move this body to different parts of the state and come back, that makes no sense whatsoever. And there's no evidence of it at all. He points to the neighbor, Robert Seha, saying, well, I saw a trespasser one night. Well,
That was a surrender.
fine.
Wasn't taken away.
Did that person have anything? Were they doing anything? I mean, I didn't really see. Do you really even know if they were
A lot of people
trespassers?
assume
Not
they're
really.
taken. A lot
But
of times
most
they're also
importantly,
surrendered.
he says that happened in 2018. The cement slab is poured in 2016. The body is already there under. That trespasser has nothing to do with this. The timeline doesn't work.
Very
Also,
possible.
Rebecca was living at the house at the time frame this happened. She says, I moved in there in May. While I was there, Jeremy came over to visit. When? At lunchtime, when Laurie was on her break. Exactly the way Jeremy described when he would come. Not 3 to 4 overnight visits, which would obviously put his wife on notice that something was going on, which makes absolutely no sense. But Rebecca said that she had moved in. Jeremy would come over during lunch, as Jeremy said that, but Rebecca was living there during this time frame. This didn't happen the way Laurie and Isabel said. In talking about the
That's
2014
young, y'all.
incident, Mr. Wiggs talks about how he went after Wilma Nicholas, and he pointed out that, well, the state prosecuted her or him, and you only got one side of the story. But that completely ignores the fact
Okay, guys, give it to
that
the
Tia
jury.
Vasquez, Laurie's friend, came in and said, you know what? Laurie told
don't.
me she fabricated that. That's not
Absolutely
the way it
not.
happened. She was
Toxic.
the aggressor.
Mm-mm.
She threw that flower
can't.
vase and broke the slide glass door. She hit her husband over the head. And when Mike was saying that he was trying to basically grab her, to control her, to stop her from doing these things, that was true. That's her friend saying that. the timeline. Once again, go back to those phone records that establish that Mike Shaver's phone, the phone number that he originally had, changed 2 times, ultimately ending with a phone number that Laurie Shaver admits is hers, puts in a court filing is hers, showing you that she had that device the whole time. They want to insinuate maybe Jeremy Townsend said some of these messages from Facebook. Well, we know he's not sending the 500 pages to his wife to expose the affair. That's not him. Who had motive to do that? Her. We know he's not sending this message in September 20th, 2016, months after the relationship between him and Laurie is over and he's back with his wife, saying, hi, Vanessa, how are you? Moving on looks good on you. Hope you and your son are doing well. After we know Michael Shaver is underneath the cement slab, we know Jeremy Townsend has no reason to send his wife that message. All of this connects back to Laurie, and all of it connects back to her in her attempts to cover up the crime that she committed, the murder. Mr. Wiggs, as he was going through, kind of picked and chose some things here about the heat of passion defense, and just kind of threw out some buzzwords like digital data he's been doing all week. But when he's picking and choosing through the excusable homicide, heat of passion, you can't just pick some choice phrases out. You have to read it as a whole. And as you see, none of this, even under the May 2016 story that has no factual support whatsoever, would apply to this situation. The defense under the May 2016 version of events, which is completely refuted by the evidence, would be defense of others. That's Mr. Wiggs talks about how there's been no investigation into whether or not there was drag marks or chlorophyll testing. That's fake CSI TV stuff, folks. There's been no testimony whether or not that test even exists. Quite frankly, I've never even heard of that. He talks about Richard Connor and the long credentials of Mr. Connor and Corporal Strickland. He's just a corporal. He's just law enforcement. He doesn't even know what he's talking about. What did Corporal Strickland and Richard Connor say that conflicted each other? Nothing. Absolutely nothing. They both told you an IP address is something that is given to you by an internet service provider, and it's assigned a location. It's basically like a physical address. That is what people will use in order to hook up their devices to the internet. They both said that. Richard Connor acknowledges that the Facebook records and the IP logs within them are the types of things that he, as an expert, relies on all the time. Richard Connor told you that those Facebook records that Mr. Wiggs wants to say are unreliable were reliable. He says that the fact that 2 different accounts are accessing the same IP address and close in time is consistent with them being in the same location. Knowing what that physical address is would be nice, but it is not at all necessary when you look at 2 years worth of IP addresses showing multiple times these 2 devices are accessing the same IP address. Where she was using both of these devices doesn't matter. The fact she was utilizing the same IP address shows that it's someone in the close proximity and the same person. That's what Richard Connor said, and that's what Corporal Strickland said. I've got a few more messages to demonstrate how this had nothing to do with Jeremy, and quite frankly, nothing to do with Michael Shaver, who's been dead since November. Mike Shaver has absolutely no reason for Vanessa and Jeremy to get a divorce. Laurie Shaver, posing as Michael Shaver, on April 18th says, "I'm sorry, Vanessa, you must be running scared. I heard JJ Gall is a good divorce attorney." Who stands to benefit? She does. Mike Shaver, who's been dead now for about 5 months, stands nothing to gain from the divorce between Vanessa and Jeremy. Laurie does. We've already discussed the September 20th, after the slab has been poured. Makes no sense for Jeremy to have sent that message, but that is the "Hi Vanessa, how are you? Moving on, looks good on you." This last message, I ask you, is this a message sent by a man trying to inform another woman that his husband is cheating on him? Or is this the message of a woman trying to drive a wedge and get a divorce so she can get the man she wants? This is April 20th, 2016. "Hello, Vanessa. How are you doing? I know you asked for no more information." Right there. Vanessa said, I know there's this affair. You don't need to give me anything more. I got it. But I feel you should be aware of this. There are emails from October through November I have been reading. There is one from November 3rd where she asks him if he changed the sheets. He replied, no, that he had not. Loved being able to smell her and that he would inform you the spot was from him if you noticed. It appears she has been at the house and they have had sex in your bed. Thought you should know that. It also appears he invited her to stop by at your Halloween party, but she declined, not feeling comfortable with you being there. Pictures of that night were sent as well. There's a ton more information about how they met, what transpired. If you would like a copy of email logs, let me know. Vanessa tells him, I got it, I understand they're having this affair, you don't need to give me any more information. But Laurie says, you know I had sex with your husband in your bed, right? Who would do that? Mike Shaver? Jeremy Townsend? Chinese hacker? Laurie Shaver. Mr. Wiggs got up here and said, the state just wants you to be mad and check off guilty of second-degree murder because the state's proven to you that she had some affairs. And he said, specifically, why do we have to hear that evidence? We had to hear that evidence because these are the two individuals that he provided to law enforcement. When Laurie was first arrested, he said, you need to look into Jeremy Townsend and James Ballou. And how are they connected to Laurie Shaver in this case? They were having affairs with her. This all came to light because Mr. Wiggs told law enforcement investigate these people. And they did. They did. Jeremy Townsend talked to law enforcement 3 separate times. Came in for his deposition. Came in, told you what was going on. And his testimony is consistent with the testimony of other people that he has no relationship with, that he has no connection to. Rebecca Urbanowski, who was friends with Laurie, states that Jeremy would come over during the day when she was on lunch break. Wouldn't spend the night. That's what Jeremy said. Isabel and Laurie said he would spend the night 3 to 4 times a week. That's not consistent because it's not true. Oh, minor point, but this is just another example of how I think it's very important for you to rely on your own memory about testimony. Mr. Wiggs talked about Jessica Holcomb and how he says, she said this body was found in the middle of the fire pit. He was very insistent about that. He said, remember that video that was played. Please remember that video that was played. Because he confronted her on cross-examination. Didn't you say it was in the middle of the fire pit? No. Well, where was it then? And she sat there without missing a beat. That fire pit looks like, from top down, looks like the continent of Africa. And if you were to go into the bottom section of it and the point facing the house, and you were to go right under there, under where the depression was, that is where the body was found. That's what she said, not what Mr. Wiggs said. The state has proven second-degree murder beyond all reasonable doubt because of all the evidence points that Michael Shaver, as Laurie said, is not a missing person. He's no longer walking the face of the earth. And he has been that way since before November 10th of 2015, when all indications of him and his life are gone. No bank activity, no phone activity, no contact with family, no contact with friends, no contact with work. Wasn't at the hangar where she said, wasn't in Georgia where she said. He's dead because she killed him. And then she made up this May 2016 story to distract. That's pure and simple what we have. If there is absolutely no evidence consistent with that May 2016 story, ask yourself why. And it's because she killed him in November. And because of that, she's guilty of second-degree murder with a firearm. I ask that you return the only verdict consistent with the law, the evidence, and justice, and that is guilty of second-degree murder with a firearm. She possessed that firearm. She discharged that firearm, and she caused great bodily harm or death. Thank you.
All right, thank you. Members of the jury, I thank you for your attention during this trial. Please pay attention to these additional instructions I'm about to give you. Rules for deliberation. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. In this case, all of us are depending upon you to make a wise and legal decision in this matter. Number 2, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not. In accord with the law, it is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be reached as to each crime charged. The verdict must be in writing, and for convenience, the necessary verdict forms have been prepared for you. They are as follows. In the Circuit Court of the 5th Judicial Circuit of the State of Florida and in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01, verdict, count 1. We, the jury, find as follows as to count 1 of the charge. In parentheses, it indicates check only 1 as to this count. And there are A, B, and C. A, the defendant is guilty of second-degree murder. In parentheses, it states, if you checked A, please answer the following questions. Number 1, was the defendant in actual possession of a firearm? Yes or no. Number 2, did the defendant discharge a firearm? Yes or no. Number 3, did the discharge cause great bodily harm? Yes or no. In Section B, it states the defendant is guilty of manslaughter, a lesser included offense. In parentheses, if you checked B, please answer the following question. Number 1, during the commission of the manslaughter, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no. And C, the defendant is not guilty. So say we all, dated this blank day of September 2024, and there's a signature line for the foreperson. Verdict form, count 2. In the Circuit Court of the 5th Judicial Circuit of the State of Florida and in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01. We, the jury, find as follows as to count 2 of the charge. In parentheses, it states check only 1 as to this count. There are options A, B, and C. A states the defendant is guilty of accessory after the fact to second-degree murder. B states the defendant is guilty of accessory after the fact to manslaughter. In parentheses, if you check B, please answer the following question. Number 1, during the commission of the manslaughter, did the person who committed the manslaughter personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no. And for option C, that states the defendant is not guilty. So say we all, dated this blank day of September 2024, and again, there's a signature line for the foreperson. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over the deliberations. The foreperson should see to it that your discussions are carried out in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, or electronic communication, such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Certain exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibit, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right, at this time, I will excuse the 2 alternate jurors, Ms. Davis and Ms. Hernandez Urbina. You are the alternate jurors. You are excused from further service. Thank you for your time and attention.
I never liked them excusing the alternate jurors just yet. One of the deliberating jurors could have a heart attack, God forbid. I mean, that could happen. Somebody could get sick.
You may be seated.
I have to tell you, I just want to go to sleep, y'all. I am honest. Why were they sitting there? I took a thing for my back and it's making me sleepy. No, it's nothing hard. Not like an HC or anything like that, but it does kind of, it's a little muscle relaxer. Wait till the jury comes back.
All right, then. Is there anything further before the jurors go back to deliberate?
No, sir.
All right, please bring the jurors back to deliberate. Thank you. Yes, ma'am. All right, the jurors have gone back to deliberate.
Their verdict clock is a little faster. I just started mine when he said they were out.
If you would, thank
Yes, sir. Seatbelts attached.
you. Do the parties wish to review the evidence before it goes back?
That's fine. Yeah, go ahead. I'm just finding the final jury instructions to send the task.
Yes, sir. Thank you.
Let's see if my watch will do it. Yeah.
You may be seated.
I only start mine once he says they've gone back. I don't start sooner.
Verdict form to the clerk, so when she's done.
Thank
Yes, there is 3 women. It's an equal balance. And being that it's only 6, sometimes they finish quicker. There's less people to argue.
It's the latest one, Mr. Buxman, then I'm sure.
I'd like to leave through it. So there's no,
Yeah.
It's a fresh warrant.
Ready now? All right, thank you, Madam Clerk. I think, Madam Clerk just received the verdict forms, if you could send. I'm sorry. Yes, sorry. Thank you.
Yes, sir.
Yay, we've reached 75,000 views. In 3 days, we've had 5,000 views. Yay! Thank y'all so much.
I know one is they wanted to use a whiteboard or something they can write on.
Any objections to that? State?
No, I agree with Toxic. They're not going to bother her with perjury. She's got to.
Clean, whiteboard without any additional writings on it.
Yeah, I'm going to do that. Okay, here's the problem. If, for example, the mother did tamper with the memory of the child, which we've discussed the possibilities of, then the thing is that they've got to prove the child did not remember it the way that she said she did. And so they're not going to come after her for perjury. They may scare her a little bit, but they're not going to, I don't think they come after her. I don't know, Case One. They may be ready to get this over with so they don't have to come back Monday. I mean, we had another case. He went to 11:59 when, well, actually 11:40 something, and then verdict was right at midnight. So, yeah, they may go that late. The problem with charging the daughter, and I understand people talking about that. That was a question I had, but after talking to a lawyer, I get the point. Number one, she was too young. They're not going to charge her at the age of 7. But even if she did not give the full, yay, 170 subs on your parrot rescue page. Congratulations. Um, so, they have to be able to prove the intent to lie and deceit. And if it's her recollection, what she remembers, and it's really hard to prove those. So I would be totally shocked if they even tried. They're not going to go after that little girl. But if they can prove that other guy that helped to bury the one that helped to bury him, the decedent, they can go after him for accessory to murder or whatever they call it. Filing a corpse, all kind of crazy stuff they can come up on that one. There is. I point in charging the daughter. Oh, I'm sorry. There is. This was an adult issue between the parents. This is not Isabel's fight from the start. And yeah, you're right. It's not. They're not going to charge her. I got you. I misread it. My bad. But I had other people asking me the other day. Oh, I got me a throw last night at the grocery store. It's fall. I'm comfy. I'm in my chair. Wish I had heat on my back. Gotta go get a new heating pad. Dag nabbit. Yeah, that power washing really screwed with my back last night. I was gonna hunch. I knew I was gonna pay for it when I got about halfway through.
Which phone number would you like to leave with the clerk for contact?
I'd get out of there because it may be your last taste of freedom, honey. Get the hell out of there. Go have some good to eat because you may not be eating so good later. Because if you're found guilty, you're going into the slammer. Oh, I remember those days and I loved every minute of it. Both of my children are miracle babies. I was not supposed to be able to carry children. I could get pregnant, but I couldn't carry. This is true. I could do that, but I'm inside the office. I love them. I love them. I love baby clothes. I tell you, my poor child, as soon as I find out she's pregnant, she's gonna be in trouble. This was actually a true story. When, I was pregnant with my daughter, there was a cutest kids shop, and they were expensive. And there was an old lady who owned it, and we became friends, and I was on bed rest, so the day of my doctor's appointment, I go to the doctor's appointment, then I go sit in her shop, and we chat for hours. It was great. Well, I bought a few things, but then she said, "Look, I I've got a bunch of great stuff. Are you interested?" Oh, these outfits were like $100, and I got a lot of stuff for like 10 and $15, and then, anyway, and they were high quality too. I mean, this is stuff that you can wear, like the baby gowns that drew and had the frills and the matching bows, and yeah, and it was very good, heavy quality material. So when I gave birth to my daughter, as soon as I got into that delivery room, even though I had a C-section and I could barely move my legs, I got her out of that hospital garb and into her own clothes. And I mean, I washed them several times, make sure they were soft and all that. And my husband worked at the hospital, and so we had people coming in all the time. So it was one of those things that wanted to make sure she was dressed. They gave me the award for the best dressed baby ever in the history of that hospital. I thought, oh, my youngest is 20. My eldest is 24. That's awesome, Kristen. I do better with infants and newborns than I do with 3 and 4-year-olds, 5-year-olds. Yeah, because I can't chase after them. My body won't let me do that. I can't chase. Um, so I really like the infant stage. I love all stages, especially my own, but physically, I can't do the running after. Mm. Now, get me in that position again with all those baby clothes
All
and
right,
everything,
party's ready for the
I
jurors.
may not want to.
Please bring out the jurors.
Yay, you're going
All
up
right,
in
just one moment, please.
subs, Kristen. I already subbed.
All right, just one moment, please, Madam Bell.
Mm. Mm. We have a child that's been kidnapped in our community, all over Amber Alerts. So if you see anything from Ingram, Texas, that would be us. That's about 3 minutes, 5 minutes outside where I live. Little sub city. It's awesome.
paperwork, or it's just at the property? Okay.
Wow, radio chatter.
All right, thank you so much.
Right.
Or,
All
I don't
right,
know
please
what
bring in
that
the jurors.
was.
Thank you.
Oh, y'all. I want to be beating, but I can't.
Watch the orange board, please. Remember the orange board up there?
Oh. Everybody's going crazy over Kathy Bates to retire from acting after her performance in Madlog. I thought she was already retired from acting.
All right, thank you. Please be seated.
Uh-oh.
Now, audio tape has been queued up and ready for you to listen to.
Uh-oh. They're back in there already. Already?
Shoes. Did everybody help her open? Yeah, let me see what she's doing.
What in the world is this? It's hurting my ears.
This is good. Hi.
Oh.
Okay, absolutely. Okay. Cell phone. Swab? What's swab? Oh, swab things that you swab. Okay, gotcha. Flash drive, a photograph, miscellaneous paperwork, a HP laptop, additional swab, SD card with photos belonging to the sheriff's office, possible buckshot videos, projectile, unfortunately there was not needed, and human skeletal fluid. So as far as all that, do you have any questions? Yeah. Okay. Do I need to sign any of that paperwork, or it's just at the property? Okay. Okay. All right, thank you so much.
Need to listen to it again?
Would jurors like to listen to it one more time, or was that sufficient? Sufficient?
Yes, sir.
Okay. All right, please bring the jurors out. Thank you.
What?
The jurors have exited the courtroom. You may be seated.
Well, baby girl. Oh. what? You want to get up in
Are there
my
any
lap.
other matters that need to be addressed before we adjourn?
Yes, sir.
Okay.
That's
You
it.
provided the phone number where you can be reached.
Yeah, I've
Okay.
given it to Mr. Capucci.
State, will you be in the courthouse, in your offices, or?
Yes, we're going to have our phone number as well.
Okay.
And we provided the clerk with our phone numbers.
All right. Thank you. If there's nothing further, then we'll adjourn.
Thank you, sir.
Thank you.
Okay, that's interesting. Now, the verdict clock on there says 11 minutes. I have 17. How did I get ahead of them? Me no know. Okay. How are y'all doing? Yes, and I think they had an instant question on a video recording. They wanted to hear this video again. I was quick. Really quick. You know, if it wasn't for the fact that he was found in her pit and her yard, I could believe somebody else could have done it. But it was in her pit in her yard. I just some of the things that the daughter said, some of the things that the mother said, I'm like, not gonna. This is not working for me. I know it sounds crazy, but that's where I'm at. Yeah, they may have, but I don't. It's still a part of their process to me. Y'all, I just want to go to sleep so bad. I just want to go night night. Nighty night, nighty night, nighty good night. I do. I just want to go lay down a little bit and take a nap. Just let this clock run. What are y'all going to do? I wish there was something we could watch that's. Let me see what we can watch. And try and find something. What do we have here? My brain is just not quite functioning well. So now we're in verdict watch. Y'all, I have been hooked on watching. It's not what I wanted. This is what I've been stuck on watching like forever. I mean, it is stinking cute. I mean, I so want. Yeah, we just watched that part. Um I would love to have one of those sprinter vans or something and do this to it. I would want that. I'd love to have that vehicle and do it, but they're so outrageously. Over here. Come on. Get over there. Mama needs to get up underneath here. Sit up better. It would help my back. So, I love these things. I want one. I know. I want one of those. I'm going to go in biggin for now. Just going biggin for now. Guys, my back. I'm sorry, my back is just saying no. Crap, I can see to do my lips. I have a kick butt mirror in my makeup room where I do my makeup because I'm a professional makeup artist and skincare consultant, and it's amazing. But for me, with my old glasses, for me to look in here and do this, everything was blurry. See, I wouldn't have been able to catch that. I can't believe how blurry everything was now that I'm looking through new lenses. Um, I don't know who's calling me from Port Lavaca. I ain't gonna answer it. So, one of the things that concerns me about this trial is that the little girl was, I felt kind of used. Um, I feel um, that she should not have testified. I understand they're using her to save her mother, but at 15 years of age, I don't care how mature you are. Doing what that little girl did took cojones, and that was a big, big, big deal for her to do. But at the same time, it breaks my heart that she had to do that. And I'm really appalled at the fact that she had to do that. And I pray and hope that victims advocacy is helping her through this. And crap, I would get something on my glasses. And that victims advocacy is going to help her, and that they have counseling set up for her, and that she's taking that help. They don't always take the help. If you are ever um, a part of a crime and you are labeled in the reports and everything as a victim, every court in the United States is required to have a victims advocate representative. Utilize their services. It's free to you. Utilize it 100%. Um, it's something that can help you get through the process, both financially, emotionally, um, with anything and everything you need. So, yeah. Okay, guys. Ronnie, I keep going back to that. Why did they not ask her more questions? If I was the prosecution and she talked about, I'm the one who shot him, okay, tell me, how'd you know where the weapon was? How'd you know where the bullets were? Was the weapon loaded? Did you have to put in it? Was it revolver or semi-automatic? Um, how did you hold it? I mean, there's so much that could have been asked. Yeah, exactly. She wouldn't utilize the service for the fear her daughter would confess. Yeah, yeah. So yeah, I feel like the prosecution dropped the ball on that one. Yes, just listening again, and he did and say skeletal remains. That was the call. I got a boo boo there. The kitten accidentally got me. Y'all, anybody suffer from very low back pain, like in the deep hips? Got any advice? Because I am really, really struggling with this. And I'm sorry to say that, but I is. Right now, 90% guilty. That's what I was going to do. I've already done it once, but we'll just do it again anyway. Um, oh, I can be doing. Okay, poll started. Started a poll. Well, I got this back problem. Never had back. And going on 3 years ago this October. And 3 years ago in October, I was nearly hit on by a drunk driver. Sorry, I'm trying to get that to start. And my lower back has given me hell ever since. And they really, it just really, 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 really gets to where I can be fine for a day or two or a week, but when I do anything physical like cleaning or bending is always the worst because they're herniating towards my belly button. So any forward motion hurts like hell. Now, I can arch back all day and be fine. If I could walk in a back arch, I'd be fine, but no. Yes, it does. It's not sciatica. It's actually nerves. The bulging disc in those last three vertebrae between 1 and 2, 2 and 2, 3 and 3 and 4, and cringing on 4 and 5. They're bulging and they're hitting a nerve. But I also have rheumatoid arthritis in my lower back and hips. So when all of that flares up, it's a multiple problem. It's the arthritis and it's the bulging disc. So yeah, I go numb, actually. I don't get, let me rephrase that. I don't get necessarily pain going through my legs. I get numb. Yeah, I might, let me call my son and ask him to bring me that ice pack thing. That may help. Oh. Why do I have a call from Pittsburgh or Port Lavaca? I don't know who that is. I'm going to get my son to bring me something from my back. Can you bring me that ice thing that we use for migraines for my back? Thanks. So we've got Anderson next week, and Thursday I'm out of pocket, y'all. I'm sorry to say I'm out of pocket Thursday. I did dove on my break. I did. It is so tight and so stiff right now. It's not even funny. Nowhere near funny. Now Court TV hops on. I can't put it there. I need you. No. In the big fridge, the thing that we put over our heads for the migraine. I just know. No. What do I got in my hair? Oh gosh, when I was doing that power washing, I never thought it'd be so satisfying doing that. But man, that's what I need. These are great. By the way, if you get migraines, if you put them in the freezer, they're too cold for me. So I like to keep it in the fridge. But if you put this in the freezer and do this and then put it on your spine, it is just right. But getting it there is my problem because I've had my shoulder surgery twice. Well, 3 times actually. Placed once. Trying to get there. Oh, no, I'm not that kind of cray. I'm not that kind of cray for it yet. So let me sit on that for a minute. I don't know why I don't like those stimulator games that everybody talks about. But, gosh, that does feel good. Thank you for reminding me about that. I appreciate it. But I don't know. I guess it's the cool weather has me in a cleaning mood. Reminds me of being pregnant and you get those bursts of energy and nesting. I just hated when I accidentally when I was power washing the big griddle that I have. That Blackstone, huge. I got the largest one they make for home use outside. Has 2 air fryers and a warmer built underneath it. Haven't used it in a long time, but I think now that the fall is here or getting here for us, and I like cooking when it's cold. I do. I like to sit out there on my chair at night with my lights on. She also has it in her brain. On her brain, does she have intracranial hypertension? I was diagnosed. Well, I was misdiagnosed with a migraine when I actually had meningitis, and my temperature got up to 105.6. That feels good. And that's one reason why my hearing is the way it is. But because I was misdiagnosed, and I went for like 4 days misdiagnosed, Thursday through Monday. Yeah, 4 days. And when the labs did their audit for that week, they had figured out that one of the lab techs inverted the numbers. Because when the doctor pulled my spinal fluid, it was milky. He immediately started a very powerful antibiotic. And so if he had not have done that, I would have died. I would have. But yeah, that was a very, very dangerous time for me back then. But when the numbers came back normal, he said, I guess it's a bad migraine. We'll just have to let it go. And it was horrible. So it was spinal fluid. Yeah. So one of the effects of all that is I now produce too much spinal fluid. And I have to get spinal taps to drain it off sometimes. Yeah. I would go see your primary and your neurologist and all of that and see if they can see when you do a spinal tap, it's really not that painful. It's more scary to me at first. Now I'm like, fine, whatever. It's like an epidural. To me, it was about the same. And as soon as they get it in there, it has like a pressure gauge, like a tire gauge does. And it pops out and it'll tell them what the pressure level is in her spinal fluid, in the brain and the spine. And that that along with other testing can see if she's got IH, intracranial hypertension. If her numbers are high enough for long enough, they can put a little shunt up in the brain, and there's a little tube that goes down into the stomach. And it's not horrible surgery, but I'm kind of sort of on the border of being a candidate. Okay, that sucks. Been there, done that. But I guess I've had so many of them that with my doctor, they know exactly where to go. But my problem is I'm building up scar tissue there. So they're having to try to go up or down depending on what's going on. But I am so sorry she went through all that. Do you know what her spinal pressure was or her spinal tap pressure was? 18, sometimes to 20-ish is normal. Ideally, it's 18. But when you start getting 22, 25, 30s, mine was 33. They should have put a shunt in my head, but they didn't. But what that shunt will do is it will drain off. Another question. My question is for 7-year-old daughter shot him. How did she jump into the car and go to school? Yeah, that may have been the shunt. That's what they do. They'll put a shunt in the brain. And then as the spinal fluid gets to a certain level, then it will drain into their stomach. And then it'll come down. There's like a little valve in there, that little thing they put in the brain. And it monitors and controls. And they can adjust it with this, like a same thing like a pacemaker almost. They can adjust things from outside. And then what will happen? So it sounds like she has it. I've refused the shunt at this point. My problem with the shunt situation is that at my age and the fact that you can get it can get blocked. So yeah, I'm at the point that I probably will have to get one in the nearer versus far future. It just depends on how everything's going, but that's one reason why I get headaches a lot. Does she even have a conversation with the daughter after she shoots her father? sends her to school like nothing happened. That alone is so not cool. How long do y'all think before we have a verdict? Okay, have y'all taken our poll? Have you taken our poll since I stopped? I just potted you. 50% say 3 to 5 hours. 2 hours is 30%. 20% 6 hours. One thing though is that you've got to spend time on that verdict form. I need to pop this chat out. There it is. Ooh, yummy. Y'all just ordered a vanilla chai tea from the Tea to Go It. From Tea to Go It. Yummy. Cool. This poor girl has problems in the front, too big, and the back problem. She works for Medicare, taking calls for the country's crankiest population. Who? The United States? Yeah. So that's why headaches to me are very big deal. It really is, because I have a higher chance of stroking. But my children have gotten so, and I know I'm kind of relaxed down, y'all. I apologize, but this ice is helping my back. Cold is. My children have gotten to where they can just see my eyes, because that pressure, my eyes start to kind of look a little buggy. My son said fish-eyed. It affects sometimes my speech. It affects my thinking process. So if y'all ever hear me not able to say full sentences and I'm seeming a little unnatural, go to Discord and look for Steve. That's my son. He's in my Discord. You just grab him.
Laurie Shaver.
Uh-oh, we got noise.
Had a request and not a question. They requested calendar for 2015 and 2016.
They're asking for a calendar for 2015.
Liberty of printing out a 2015 and 2016 calendar. If the parties could approach, view the calendars, and let the court know that it is to their satisfaction.
So they are requesting the calendar for 2015. So they're laying that timeline down on what they believe happened.
And this is the request that the parties need to view it. All right, that's what I got. Mark,
Defense agree with it? Yes.
okay, that stipulates, state stipulates.
Oh no!
Go back to the jurors. There you go. Thank you. All right. I don't believe there's anything further.
Okay, listen to this, guys. This is news to me. 3 Americans and 34 others sentenced to death over coup attempt in the Congo. Military court in Congo handed down the death sentence Friday to the 37 people, including 3 Americans, after convicting them with charges in taking part in the coup attempt. The defendant, who also included a Briton, Belgian, Canadian, and several Congolese, can appeal the verdict on charges that included terrorism, murder, and criminal assassination. 14 were acquitted in the trial, which opened in June. 6 people were unalived in a botched coup attempt led by little-known opposition figure Christian Malanga in May and targeted the presidential palace and its close ally, President Felix whatever. Malanga was fatally shot while resisting arrest soon after live streaming the attack in social media, Congolese army said. Malanga was 21-year-old son of Michael Malanga, who was a U.S. citizen, and two other Americans were convicted in the attack. His mother, Brittany Sawyer, has said that her son is innocent and was simply following his father, who considered himself president of a shadowed government in exile. Oh my gosh, y'all. The other Americans were Taylor Thompson Jr., who flew to Africa from Utah with younger Malanga for what his family believed was a vacation. Benjamin Reuben Solomon Poloon, 36, was reported to have known Christian Malanga through a gold mining company. The company was set up in the Mozambique in 2022, according to the official journey official journal publication of the Mozambique government and reported by African Intelligence Newsletter. Thompson's family maintains he had no knowledge of the elder Malanga's intentions, no plans for political activism, and didn't even plan to enter the Congos. He and Malanga were meant to travel only to South America and Eswatini, Thompson's stepmother said. The reading out of the verdict sentencing before open-air military court broadcast on live TV. Oh my gosh. So they've got... That's horrible. That's horrible. Yeah. Well, let's see how late they go, y'all. They could finish today. Oh no. Story 4 hours ago. Teen shot and faced by Colorado councilman after seeking permission to take a homecoming photo on his property. Teenager was shot in the face by property owner after hopping over a fence trespass while looking for a place for a homecoming photo, according to authorities. The shooting unfolded on Tuesday when a 17-year-old boy and his friends told the investigators they were just looking for a cool place. The Jefferson County office said that the two teenagers claimed they hopped the fence and were looking for the homeowner but couldn't find him there. They said they returned to their cars to write a note to the homeowner seeking permission to take photos on property. At that moment, the sheriff's office said that the man pulled next to them got out and fired the gun through the windshield of the car, striking one of the boys in the face. Okay, that in and of itself, he obviously was not on the inside the fence property because they were in the car. They were probably on the easement. The suspected shooter was identified as Brent Metz, a 38-year-old member of the Mountain View Town Council. The sheriff's office said police have received 911 calls from the Metz girlfriend reporting two trespassers on the property. She had to call her boyfriend, who owns the property, and told him about the incident. When the officers arrived on scene, they found a 17-year-old bleeding heavily in the face and the other teen applying pressure to the wound with a t-shirt. Oh, how horrible. Metz was also on the scene, and the weapon used in the shooting was found inside the truck, the sheriff officer said. He was arrested for first-degree assault, 2 counts of a felony menace, illegal discharge of a firearm, and 2 counts of reckless endangerment. The judge set his bond to $5,000. Are you kidding me? For all of that, you set the bond to $5,000. Criminal defense lawyer Tyrone Glover told Denver 7 that it is categorically unreasonable to me that you think you can shoot a kid in the face through a car window because they're outside of your property at that time. Unless there was a threat or serious bodily injury, maybe there was. We don't necessarily know at this point. But the facts are, as Jeff Coase said, I don't see any excuse. Colorado has Make My Day law, which allows residents to use deadly force against intruder inside the home, not outside the property. According to authorities, shooting took place on public road outside the perimeters of Met's private property. When the contacted for comment, does not have any comment statement at this time. Gosh, what's coming to? Oh, this is horrible, y'all. This is horrible. Absolutely horrible. What's going on with this community these days? I mean, you're a grown man. Why would you do that? Yeah, they're playing people's comments. What's for dinner besides wine? Don't know yet. Don't know yet. Sorry, y'all, I'm struggling a little bit. Oh, yeah, that's what I was going to do. Let's see if I get dinged for this.
And hours of training that goes into knowing how to do this. It is an art and a skill, especially here in LA, when you consider how long these pursuits can last. So initially, just want to let our viewers know this pursuit started at about 1:31. The initial want is a hit and run in Barstow and Ranchero. That's according to the CHP and the information we're getting into our newsroom. And then there we go. The suspect took off, and so a pursuit began. And so far, they have not let up on this suspect, who has gone northbound on the 5 and then back south on the 5. So clearly not sure what this driver intends to do. But thankfully, we haven't seen any collisions. And we have seen, though, erratic driving at high speeds and also going against traffic.
Last time I got dinged for this. Let's see if I do this time.
So a big concern for the community down there.
Big concern for sure. You know, California Highway Patrol and all law enforcement officers that are involved in these pursuits. Pursuit training is very serious. Those officers talk about multitasking. A lot of times they are actually making calls on the radio, saying where they are, keeping an eye on other options that they can take while they're chasing that suspect, and also making sure that the public is safe. They do a lot behind the wheel. That suspect, all that person is doing right now is driving fast and erratic. And again, of course, she doesn't want to collide with something, but, you know, in that same breath, it could happen so quickly. And if they were making our way right now on Telegraph,
I don't know,
the
Ronnie.
traffic out there. I want to say it a little bit tighter just because of when we go through these lights, but that one was green. We did about 2 red lights there just a few moments ago, and look at that, getting a little stuck. Hopefully they don't get into that parking garage. But this is kind of the thing, Sandra. A lot of times we see these chases. A lot of times they're suspects. A lot of times they know, oh, let's go to LAX. Let's go to this parking garage. Let's dump the vehicle. This person doesn't seem to have that type of mindset. She's basically just driving fast, staying away from the officers, playing a game of keep away, which again is not going to last very long, because eventually the California Highway Patrol is still going to follow this vehicle to wherever it goes. If those cars stay behind it, or if that helicopter follows it, some law enforcement is going to keep an eye on it for sure. But right now, I believe that was another red light. Thank goodness there was nothing going on right there. California Highway Patrol right behind it, 2 vehicles. And again, that one is, I believe, has been behind it since we picked it up at that 91.5 split. And that vehicle, let's take a look at some of these speeds. I want to get up close to it and just kind of get you a real number. So 60 miles an hour right now on Atlantic. This is, now we're in the East Los Angeles area. This is we know that it's going to start getting very tight out here. The cars are going to traffic's going to become a lot heavier. And of course, a lot more pedestrian traffic as well. You can see it right there coming up to another, probably a red light. But this is an area where you have sidewalk cafes that we see right there. You have street vendors. You got some construction going on. This is going to be an area that gets really tight. Pedestrians in this area, I always worry. But this big SUV continues to move along. That female driver, hit and run. Minor hit and run, and this is going on. I wonder what is really behind all this, and I wonder if we're ever going to really find out. But we know that we're going to follow it as long as we can. Hopefully that suspect's going to go into custody without any type of injury to herself and or anybody else. As we go against traffic out here, looks like we're running another red light. It's just, you have to wonder, why is this happening? Why is she doing this? Why? But, it is one of those ones where we're just going to watch it, keep an eye on it. California Highway Patrol doing an amazing job staying behind it. East Los Angeles, unincorporated. They do have the sheriffs out here, but some of this area is actually patrolled by California Highway Patrol. We'll keep it, and that was one of the things, too. We talk about it during the chases. There's a sheriff's vehicle right there. Believe me, he's not blindsided by that. He knows what is going on. He's been listening on the radio. They're all talking to each other, going across the median and into oncoming traffic. I don't know if those cruisers can do that. That's the reason why. There you go. We were talking about pursuit training. The one that's behind them, that's one of the reasons why they do that. Because if the front one has a problem, can't get there, well, you know what? My buddy's going to be able to scoop around and get there. And it's a K9. Oh, maybe we're going to get some dog action at the end of this. But right now, we're going to keep going. The pursuit's still moving. East Los Angeles, well established out there. I wonder if we're going to get the Boyle Heights in a few moments. But that white expedition this morning or this afternoon, still going. And that driver determined to stay away from law enforcement.
Yeah, the majority of times you'll never know why a pursuit happens or begins and starts and ends, right? You never know the mindset of these drivers. We follow these and just hope and pray that nothing bad happens to the innocent public and to life and property, basically. And it is such a dangerous situation when you're in these communities, in these neighborhoods, again, approaching pickup time for a lot of students and families out there. And then you see a high-speed, erratic driver like this. Who knows what they're thinking, where they're trying to go, and why they're doing this. But clearly a threat to the neighborhoods out there. But the hopeful thing here, from what I see, is because she is off the freeway, this driver could perhaps, there could be a point where CHP could throw down the spike strips, perhaps do a pit maneuver and stop this vehicle.
Well, Sandra, we've all been watching a lot of pursuits. We live in Los Angeles. How can we not? But the thing is there's got to be a lot of stuff that lines up. The stars have really got to line up for them to do.
Ronnie, there was no video to that article. I apologize.
Right now we're in an area.
I'm
just kind of looking. We're back in the Southgate area, so this is a spot where it's going to be the sheriff's department. Could they get involved? There's a possibility, but the car has got to have the police or the sheriff's vehicle has got to have the spike strips in the trunk. The person driving it has to be certified, and then the opportunity has to be there as well. So there's a lot going on. It isn't just like law enforcement, everybody's got it, we're just going to jump out and throw a spike strip on the ground, and that's going to be the end of it. And also, it is a CHP pursuit.
A female,
so
that's unusual.
To the in this case, the sheriff's department. So there's a lot in the mix right there. I'm guessing right now we're just going to keep following it. Senator, you kept bringing up the schools, and I'm seeing all those. We just passed 2 school buses and 3 school buses.
There we go.
Makes me think there might be a school around here. And that's another thing, we just don't want to see anybody get hurt, heaven forbid a child. But there you go, kind of went a little bit against traffic and a little bit back onto the road. If anything, I'm seeing this vehicle moving just a little bit slower. So I'm wondering if maybe the adrenaline's starting to wear off for the driver or something's going on, because the speeds, you know what, I'm just looking at the numbers. Maybe it just seems like it's going a little slower. They're still going about 50, 60 miles an hour here on these surface streets. And also, we don't know. Is this her vehicle? Is this, is it a rental? But I would venture to say there is some sort of navigation. Any of these new vehicles, especially a big, nice SUV like an Expedition, probably has some sort of navigation in there. So if she's trying to get back to some location, say a freeway, don't. Oh, thank goodness for that. It wouldn't have been bad, but it would have been something right there. Mm-hmm. And that's coming to a stop, almost rear-ended that vehicle, probably getting out of the way for the lights and sirens. And, that's, all law enforcement say that when you hear those lights and sirens, get to the right if you can, but be predictable if you can. And so I'm sure they're hearing those lights and sirens, they're moving out of the way, but that suspect, she's just thinking, okay, I can get by. But you saw it right there. There were two close calls. But again, those speeds way too high for these roads. And again, we're just keeping an eye on it. Just don't want to see anybody get hurt.
That's right. Let's not only talk about speed. Let's show you moments ago how erratic this driver was, in fact, when trying to evade the CHP officers on this person's tail. Let's take a look at how this driver got off the freeway, then off-roaded, and then tried to circle back and got back on the freeway, trying to lose the black and whites that were tailing this driver. But clearly they know better and are still on the case here. So clearly
we are now
this is
1
the erratic
hour
driving
and
that we've
2
been
minutes
following. We've
into
been seeing not only the
deliberation.
high speeds here, but this type.
Again, we are 1 hour, 2 minutes, into the deliberations
of maneuver. And that is something that shows the capability of this suspect that they're in pursuit of. Traffic not stopping this driver either. The driver going on the wrong side of the street against traffic, blowing through stoplights right there and stop signs. So a very big threat at this point, and it's really, really disconcerting to see this driver go past 4 or so school buses that we saw in that neighborhood, in these residential communities, with school, I'm sure, being let out soon, and parents probably trying to pick up their kids from school to start their weekend on this Friday, or perhaps these children filing onto these school buses. So clearly this is something that CHP wants to put an end to make sure this driver who is driving erratically and dangerously gets off the streets, Stu.
That's right. That is the ultimate goal for the law enforcement. They just want to bring this thing to an end peacefully. Ultimate goal for Skybox is just to keep an eye on it and make sure we can see where this goes. Going around a building, this is the Monterey Park area. I would venture to say we are getting into an area that has a lot of city buildings and also law enforcement buildings out here, which is unusual in itself that the suspect is going through this area. But you can see that vehicle. There was very little traffic on that road. This looks to be a little bit more industrial. There are more businesses here. And when I say businesses, I mean office buildings, things like that. They're making their way behind those trees, but we're going to keep an eye on it for sure. California Highway Patrol, they're down there on the ground. They're doing what they can to keep that public safe. Coming up to what looks to be, it was stopped because there was a California Highway Patrol officer there, keeping an eye on traffic. That shows you the coordination and the ability that law enforcement have.
Oh,
geez. Look at that. Man, she got some air on that. Oh, she didn't like that. Did not like that. Doors are open. She's out running. And,
here we go.
The law enforcement's got to be like right there. Of course they are.
Right.
And getting out running. You know what? I got to give it to her. That was probably the smartest thing she could have done, especially after that move. That truck got all 4 wheels off the ground there when it hit that bump. She's basically running to the back seat. There you go. Take
Down.
And there's the canine. There's the canine. But you know what, buddy? Oh, the poor dog just wanted to get a little bit of work in, but not today. Not today. And
go, doggy, go!
Straight to the CHP patrol car. That's right. She knew this was the end.
Yes, but you know what? When she got air like that, really, truly, of all this crazy we saw this morning, this afternoon, that was probably the smartest and best thing that suspect could have done was jump out of that car, especially after she got air like that. And
She hit a
again,
road
law enforcement,
bump. Here,
California Highway Patrol. I would venture to say that
I'm going
guy
to go
in
back
blue.
and watch that. It's
I would
only a
say
few seconds back.
Crazy we saw this morning, this afternoon. That. You can see that
Watch.
vehicle. There was
Watch.
very little traffic on that road. This looks to be a little bit more industrial.
She's probably going in
more
excess of
businesses
100
here.
or at least
And when I
I
say
don't know. She's
businesses,
going
I mean
fast.
office buildings, things like that. They're making their way behind those trees, but we're going to keep an eye
She's
on it
flying.
for sure. California Highway Patrol, they're down there on the ground. They're doing what they can to keep that public safe. Coming up to what looks to be, it was stopped because there was a California Highway Patrol officer there, keeping an eye on traffic. That shows you the coordination and the ability that law enforcement have. Oh, geez.
Gosh.
Look at that. Man,
Okay.
she got some
she
air
hit a
on that.
dip in the road?
She didn't like that. Did not like that. Doors are open. She's out running. And
Here, take down again.
Law enforcement's got to be like right there. Of course they are.
Right.
And getting out running. You know what? I got to give it to her. That was probably the smartest thing she could have done, especially after that move. That truck got all four wheels off the ground there when it hit that bump. She's basically running to the back seat. There you go, taking her
You
down.
should have run down
and there's
the.
the canine. There's
Oh,
the canine,
that's why
but
she didn't
you know
go
what,
down that
buddy?
way. There was a
the
canine.
poor dog just wanted to get a little bit of work in, but not today. Not today. And you got her in custody. She practically ran into the waiting arms of the law enforcement.
Straight to the CHP patrol car. That's right. She knew this was the end.
Yes, but you know what? When she got air like that, really, truly, of all this crazy we saw this morning, this afternoon, that was probably the smartest and best thing that suspect could have done was jump out of that car, especially after she got air like that. And again, law enforcement,
Girl gone
California Highway Patrol.
wild.
I would venture to say that guy in blue. I would
Boy,
say
this
that guy
woke
came
us
all the
up,
way from
didn't it?
Barstow. She's going to have a long ride back to being in custody. But again, coming to an end out here, and we're going to be in the East Los Angeles area near Southgate. Other law enforcement arriving, but wow, what a wild ride for sure. Thank goodness nobody was injured. And whatever that collision was in Barstow, hopefully that other person is okay.
Absolutely. Thankfully, nobody was hurt in all this. And Stu, we appreciate you and the crew up in Skyfox for your work. And we appreciate everyone tuning
Wanna know why
in.
she
We will
ran.
right now send you back to regular programming.
Busted.
Juan Carlos.
Frankenstein?
It is not.
Oh, that was cool. Last time I aired one of those. Copyright. They literally the I don't know who did it, but they blanked me out. They shut me down. Turned off my whole live. I was like, damn. But then I was like, other people are, that we know are sitting here showing the same thing. What? The Pope Francis tell Americans who they should vote for in November. No, thank you. Nobody tells me who to vote for. I don't care who you are. That's one thing I like about voting. It is totally my choice. Hit and run. Yep. But anyway, that was a little interesting, wasn't it? I was looking for something to wake us up. I think that did. See if I can find something else. Wonder how many of those. By the way, guys, we hit more than 75,000 views since I started doing this just a matter of months ago. I can't thank you enough. I know I'm sitting to one side. I got my legs up, ice pack on my back. Oh. Yeah. Excuse me. Yeah, that was breaking news, wasn't it? Yeah. Yeah, but do you know what? And I'm not to say a woman or young girl wouldn't do this, but have you noticed that all of the school shootings have had all boys? I don't think I've heard of a single girl doing this. Oh, yeah, that's true. Most trials have been women. Next week it's grandma. Loudy, loudy, loudy. Yeah, well, I did not see her son's trial. I was doing something else during that point in time of my life. Like I said, I'm fairly new to this. But I tell you, my back. It's interesting. Um, I'm gonna change my thing from Grandma Gotti to Granny Gotti. GRANNYGOTTI or GRANNI. Um, oh, I think I'm getting an ear infection. Dag nabbit. I'm falling apart today, y'all. Well, what people don't realize is that a lot of people who wear hearing aids to the amount of that I do, that this and when you get hot or just a lot of humidity, you actually feels like you got a sunburn in there. And you know how sunburns when they heal, they start itchy. So that's what's going on. Oh, Riley's Auto Parts. I can't get that song out of my head. You guys did it to me. You guys did it to me. It's all your fault. All your fault. Granny Gotti. Yep. I'm going to change it. Oh, King Charles is a son. Prince William stepped in for King Charles under doctor's orders. Okay. Judge warns that there's a about the need for a Supreme Court ethics code. I think that is I would think that's adequate. I think there should be an ethics code for any kind of court, including the Supreme Court. Just because you're a Supreme Justice doesn't mean you get to not have any ethics. Just seriously, people? You're telling me they don't have a code of ethics? But in order for me to just interpret for somebody, we have to have an extensive code of ethics? I know. I won't go there. I'll keep it clean. Won't go there. Let's keep it clean. Oh. I think it's going to be a prednisone day. I'm looking for some stuff. Anybody, y'all, look for some stuff. I'm really trying to get away from court. We've got several verdict watches going on right now. Carly Gregg update. Laurie Shaver verdict watches going on at some places. I'm looking, y'all. I'm looking. So let's see. Wild LA chase ends up with a hit and run suspect trying to escape. We saw that. I was looking, y'all. Let's watch this. Y'all know who this is, right?
In addition to the normal docket sounding business.
This is what we're going to be dealing with next week. So let's watch a little bit of that. How about it?
Attorney David Marcus to quash a subpoena by the defense. And we also have the matter that we need to finish on Sergeant Corbett's testimony. Did everyone receive their copy of the order on the defense's motion in limine yesterday?
Yes, sir.
Yes, Your Honor.
Very well. You may make your notices of appearance.
Georgia Kappelman for the state. Mr. Kappelman, you're for the state.
Dan Rashbaum on behalf of Ms. Adelson.
Alex Morris on behalf of Mrs. Adelson.
Right, Mr. Marcus, I will be with you momentarily. Concerning our docket sounding this morning, let's go ahead and address that. Does the state have any issues that they need to raise at this time?
No, Your Honor, the state's ready.
Has the state extended a final offer to the defendant?
No, Your Honor.
Very
Don't
well.
plan to.
Mr. Morris,
We're not going to give her an offer.
does your client have a counter offer that she wishes to extend to the state at this
How
time?
is this a counter offer
Mrs.
when there's
Adelson,
not
if you
been an
please can rise
original
and raise your
offer?
right hand. Please, do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. Mrs. Adelson, is there any counter offer that you wish for your attorneys to extend to the state before we proceed further in
Counter
this
offer?
matter?
There is no offer on the
Very well.
table.
You may be
How can
seated.
you counter?
Is there any issue the defense needs to raise moving into next week?
No, Your Honor.
Then let's go ahead and address Mr. Marcus's motion to quash the defense subpoena. Mr. Marcus, good morning, sir.
Good morning, Your Honor. Nice to see you.
You as well. I have reviewed your pleading. What is the defense's position?
No, they do
concerning
not,
the
and they
trial
don't have
testimony
Botox
subpoena?
either.
Judge,
Just
the
saying.
defense doesn't seek to elicit any testimony related to Mr. Marcus's attorney-client protected conversations with his client. There are three categories that the state seeks the defense seeks Mr. Marcus's testimony. The first is the state's indicated and they reaffirmed to Your Honor that they intend to ask investigator Isom whether or not Mr. Marcus called immediately after Katie McManua was arrested. The jury, if left there, the jury takes away that someone or somehow the defendants are all in cahoots, if you will. The defense believes that Mr. Marcus would testify that that is not the case at all, and he would provide.
Hey, Swan, can I use
information
that on my
as to
thumbnail? I like
how
that
it
better.
was that he received information about
Do you give me
Ms.
permission to
McManua's
use that on my
arrest
thumbnail?
and how he knew to call investigator Isom. That's the first category. The second one is the state has investigated vigorously to try to pinpoint that the
wonderful. Thank you.
Adelson family has provided legal fees for other lawyers or other co-defendants in the case. I don't know whether the state seeks to elicit testimony of that nature, but as recent as January of this year, the FBI was down in Miami speaking with Mr. Marcus about such things. Mr. Marcus provides an explanation that doesn't involve attorney-client privilege. That didn't happen. Mr. Marcus made a suggestion of the potential legal strategies involved, but nothing ever came to fruition, and there were no discussions with any co-defendants or the Adelsons. And then the third category, Judge, is there's a text message between Mr. Marcus and his client, Charlie Adelson, at the time about him having seen or bumped into Katie McManua outside of his office. And there's a comment about something to the extent of it being a coincidence, but there was no conversation that was had. Again, if the state elicits that testimony in all three of those categories and it's left hanging, it goes unanswered. But in each circumstance, Mr. Marcus is able to respond, and I don't believe that it invades the attorney-client privilege.
Mr. Marcus, I'll allow you to respond to what the defense is proffering and why they would seek your testimony.
Thank you, Your Honor. So I'll take the easiest one first, which is the last one. I had not heard about this text message between me and my former client, but that would obviously be privileged. And so any testimony regarding a text message between me and Charlie Adelson, I would not be able to comment on. So that I think is the easiest one. Let me take the other two.
Let me ask you one question before you continue. Mr. Adelson has not waived any privilege with regard to you.
Correct.
You may continue.
Thank you. Yes, I have not been informed.
It's
that
been
he
an
waived
hour
any
and 20
privilege,
minutes.
by him or anyone else. The other two categories, and I'm sorry for not looking always at the camera, looking at my notes here, Your Honor, but the first is the call to Detective Isom. So I guess I just don't understand how the state putting in this evidence is relevant, and therefore the underlying evidence in my response to it, I think, should be suppressed. The idea that on the morning that Katie McBanilow was arrested, I learned of that arrest and called the detective to find out if Charlie Adelson was being arrested. There's nothing wrong with that. That's what any good lawyer would do. The defense is right that I would respond to any nefarious suggestion by the state that there's nothing wrong with me calling the detective to find out if Charlie was being arrested that morning. But I guess my response would be, I don't think that initial evidence should be able to come in that I made a phone call to the detective to inquire about Charlie. Certainly that has nothing to do with Donna
Welcome,
Adelson.
Carrie.
And even if this was a trial about Charlie Adelson, I don't think it would be relevant, Your Honor. I was trying to find out whether the detective that morning was going to arrest Charlie. Nothing wrong, nothing untoward or abnormal about me calling the detective to inquire about that. So I would ask that whole little snippet be excluded, the underlying evidence, and what my response would be to it. The final thing about legal fees, I addressed this in my motion. I've spoken to the state about it, so I don't think they're going to elicit anything about this. They released me from my subpoena on this issue, so I'm not sure that the defense needs me to rebut anything, because my understanding from speaking to the state is they don't intend to elicit anything on that issue.
Ms. Kappelman, Ms. Dugan, are you seeking to elicit any information or evidence during the trial that would concern Mr. Marcus?
Potentially, yes, Your Honor. We are seeking to introduce the evidence that I mentioned previously at our last hearing about the call to Isom.
And the relevance hook of this would be, it goes to your conspiracy theory, or what exactly?
Yes, sir. Exactly. Would I get into anything about the offer from Mr. Marcus to Catherine McBanilow's attorneys to pay her attorney's fees on behalf of the Adelsons? Potentially, yes. And what's the third question?
I believe the last matter
well,
was any text message between Mr. Marcus and Charles Adelson when he was representing him.
Yeah, I think that the defense has mischaracterized that evidence, but that is a piece that could potentially be inquired about as well.
All right. As to the first issue of the phone call and whether it goes in any form or fashion to the conspiracy, what I'm going to rule is the following. The state may inquire as to the topic. If the defense has a factual related line of questioning to ask Mr. Marcus, the factual line of questioning will be permitted. Nothing that goes into attorney-client privilege may be inquired to. Is everyone clear on this?
Yes.
Very well. As to the second line of questioning, again, Ms. Kappelman, this is being offered for what exactly concerning any possible agreement or payment?
Yes, same relevance argument here, Honor, that it goes to conspiracy, the existence of the conspiracy.
Right. As to this, were the defendants, well, I believe the privilege argument gets a little more thorny at this point. What exactly can Mr. Marcus offer that would not be privileged on this issue?
Are you inquiring to me, Judge?
Either party.
My understanding, and Mr. Marcus can
this case, you mean,
correct me
Ronnie?
where I'm wrong, is that
or the Maddie
there was a
Photo case?
conversation with Katie McBanilow's counsel. I don't believe that Mr. Marcus conferred with his client, but it's something that he does in his normal practices, which a lot of lawyers do, myself included, call co-defendants counsel if there's a necessity of sharing expenses. I think it was his suggestion, and just that, his suggestion versus the Adelsons.
Mr. Marcus, is there any argument as to why this is privileged specifically?
No, Your Honor, if I'm asked the privilege question on the stand, of course, I'll just invoke it at that point. I have no problem doing that, Your Honor. Your Honor, if I could just be heard for 1 second.
Go ahead.
There is of course, a difference with the state arguing the existence of a conspiracy and crazy conspiracy theories. There is no basis to argue the existence of a conspiracy by my calling the detective to find out whether Charlie Adelson was being arrested that morning. There's just no, they have to at least allege some tie, some basis in fact to argue
Yeah,
that
I'm
there
not
was
following that
a
either.
conspiracy that would have some relevance in this trial, Your Honor. I was calling to find out from the detective whether he was arresting my client that morning. There's nothing tied to any conspiracy, certainly with Donna Adelson. So it's just a conspiracy theory with no basis in fact, Your Honor.
I fully understand where you're coming from with both your pleading and your position this morning. As a factual issue, did the phone call take place? There is nothing protected concerning that. How that fits into the larger narrative of what may be admissible or not, yet to be determined. The state, they have their fair opportunity to put on their case. If further objection needs to be raised at that time, I will address at the time. But as to the pure factual issue and whether or not you have knowledge on that topic that does not go to privilege, that is where they will be permitted to inquire. That is where the defense will be permitted to rebut. Nothing more, nothing further. As to the second issue of the offering of fees, is there any privilege that you can assert concerning this, or this was just an idea between you to the other attorneys?
The latter.
As to that topic, factually, it may be inquired into. How this again fits into the larger weaving of the evidence. If there needs to be an objection at that time, it may be raised, but on the pure factual issue, state may inquire, defense may rebut. As to the third issue of the text message between attorney and Mr. Marcus and Mr. Adelson.
I have my facts wrong on that, Judge. I'm sorry for interrupting. The message is actually, Mr. Marcus spoke with Mr. Adelson. Mr. Adelson then communicated with his mother that he had spoken with Mr. Marcus, and Mr. Marcus had indicated that he had bumped into Ms. McManaway. So my sequence of events a little off.
And the state would be seeking to offer this also under the same conspiracy theory.
Yes, Your Honor.
Right. Mr. Marcus, are you alleging or asserting at this point that a privileged matter was discussed through that text message?
I don't know what text message they're referring to, Your Honor. I have not seen it, but if they're referring at all to a text message between me and my client, of course, that would be privileged. If I'm hearing Mr. Morris right, he's now referring to a text message between Charlie Adelson and Donna Adelson. I don't know whether that would be privileged or not. I doubt it, but I don't have any, that's not between me and my client and my former client.
Was this a communication that was captured through the wiretap?
No, sir. It's part of what was captured off of the devices that were searched.
So this was a text message from Mr. Adelson to Mrs. Adelson?
That's correct, Your Honor.
All right. As to that, Mr. Marcus, if it does not include any advice or opinions that you're providing to your client, if there was no joint defense agreement concerning them, ultimately this can be argued as a communication between co-conspirators. It just merely mentions your name, if I'm understanding this correctly. Is there any correction that needs to be given on this point? Okay.
No, Your Honor.
Very well. As to that, the state may inquire as to the communication, as to anything that Mr. Marcus discussed with Mr. Adelson that may not be inquired into, but the substance of the text message, if the state in some way is going to argue this goes to conspiracy, they'll be given an opportunity to do so. If an objection needs to be raised, you may do so contemporaneously during the trial itself. So Mr. Marcus has a better opportunity to plan. The parties know when he would actually need to testify. I'm sure he has a very busy schedule, and we're not trying to create a hardship or inconvenience as it relates to his work and business.
As soon as the state rests, the defense intends on calling him.
Right, I believe your previous estimate, Ms. Kappelman, was 6 or 7 days.
Yes, sir.
Let's pinpoint on the calendar then at least a projection that will assist the witness in determining when he would need to be present. Jury selection begins next week on the 17th. If we have a jury by Thursday the 19th, the first day of trial would be Friday the 20th. And that means by Friday the 27th, potentially the state is resting its case, which would lead us then to Monday the 30th, the beginning of the defense case, unless I'm off of my calculations.
You're correct, Your Honor.
You're correct. The defense has a bit of a time pressure also because of the Jewish holidays.
Mr. Marcus, if you can go ahead then and mark on your calendar as to when you may potentially be called, starting with September 30th. If there is any hardship that you need to address in other cases or matters that you're involved with, please let the parties know. If it's another state court matter, perhaps I can pick up the phone, free you up.
Thank you, Your Honor. I am doing federal court on the 1st, but I'll work with the parties to see if I can get called on the 30th if it's actually going to happen. I suspect, Your Honor, that when the factual issues come up in trial, that there will be some debate about whether these items should come in, because again, I'm not as plugged in as everybody here, but it just seems that the 3 topics don't go to any actual conspiracy theory, but I'm hoping that when the objections are raised, they may obviate my need to come on the 30th.
All right. That concludes the motion to quash the subpoena. Have a good day, sir.
Thank you, Your Honor.
Right, let's continue next with the continuation of the motion on the summary. Is Sergeant Corbett present?
You should be judged. Let me see if it's time.
Oh, and also, so the record is clear on this matter, the motion to quash the trial subpoena is denied as to all factual issues in which Mr. Marcus would have personal knowledge and can testify relevantly.
I could just send him a message. I'm sure he's probably parking or on the elevator or something like that. We do have thank you. We do have another part of the motion. If you want, we could take up in the meantime, which was they had objections to specific parts of the presentation as to hearsay and attorney-client joint defense privilege. We could go ahead and take those up now.
Go ahead.
May I approach, Your Honor?
You may.
Judge, it's changing the document, so it's based on what I have so far. So there may be more that comes up in trial, but based on what I have right now.
You've reviewed it all, correct?
What's that?
You've reviewed all of it.
I've reviewed all that we have as of now.
Right, go ahead.
So I think it's page 20. It's an email between Donna Adelson and Renee Griggs. And below it, it's in response to an email from Renee Griggs to Donna Adelson. It's hearsay.
What is this being offered for?
Judge, in that email, the defendant explains that she is stressed about her daughter not being able to relocate. That her daughter, I think, doesn't realize how much it will affect her life, Donna Adelson's life, their whole family's life if this doesn't happen. The comments from the counselor that are concerned about her stress levels, I think, just add context. That's what we would be asking for the whole email to be admissible for. And
So you're not offering it for the truth of the matter asserted, or you're offering it as a party opponent admission of some sort?
yes, we're offering Donna Adelson's comments as admission by a party opponent, also a statement against interest about how stressed she is about her daughter not being able to relocate and how much it will affect her family if it doesn't happen. The therapists, or the not therapists, life coaches' comments that are also contained in the email would only be there for context.
Very well. As to that point, Ms. Rauschbaum.
Okay, guys, I'm going to have a
slide
comfort break. I'll be
20,
back
if
in a
there is
minute.
any limiting instruction that you wish to give concerning Mrs. Griggs' responses as only providing context to what the admission may be, that would be appropriate. But if these are party opponent admissions, they are permitted.
Judge, may I briefly just respond and be heard?
Go ahead.
The problem isn't Donna Adelson's comments. We don't have a problem with that. Those are statements against interest, and they're not confusing at all. They say exactly what they just said. The problem is Renee Griggs' email to Donna Adelson, which is hearsay. It doesn't give any additional context to what she says. You can understand Donna Adelson's admissions by her email alone.
So you're saying part then of this is just a response from Griggs to your client?
No, it's a chain, right? So it's a chain of emails between the two of them. We have no issues with Donna's part of the chain coming in. The problem is Renee Griggs' chain doesn't, it's not confusing what Donna's saying. I can read it to you. She says exactly what they just said. So if you never heard what Griggs says, she says, I'm stressed about my son, but honestly, I'm more stressed about Wendy and what will happen if she doesn't get relocation at the June hearing. Her life will change drastically if she has to remain in Tallahassee, and so will ours, and not in a good way. But I'll tell you more about it when we talk. Hope your mother's doing better, or at least stable, Donna. So if you just allow that in, which we don't have an objection to, that's a statement that Donna Adelson's making, you're okay. But
does Griggs respond from there? Does your client respond from the response?
No, Griggs doesn't respond from there, but Griggs' email below is, hi Donna, I'm not sure, and I only have part of it, but I'm not sure if you're back from your trip yet or not. I planned to check in yesterday. However, my mom was in the hospital and I was handling family stuff, so I was a bit out of pocket. More than anything else, I want to see how you're doing. It seems as though you have a great deal of weight on your shoulders. I could both hear and feel it on our phone conversation the other day. I'd really like to be able to help you shed whatever it is that feels so heavy. Please know I'm thinking of you and looking forward to our work together whenever you're ready. Take good care, Renee. I don't see how that isn't blatant hearsay without any exception. It doesn't, you understand again, their relevance that they just put it in for is exactly what Donna Adelson's email says, which we don't have a problem with that piece of it.
Ms. Dugan, what exactly context is being provided by Mrs. Griggs' first email before Ms. Adelson responds?
So the defense, I think, accidentally, when they read about, yes, I'm stressed about my son and my daughter, she doesn't get relocation and how all our lives will change drastically. That was Donna Adelson's email. The last email he read was from Ms. Griggs. In that email from Ms. Griggs, who's the life coach, she basically is just saying, I'm checking in on you. You seemed last time to have a great deal of weight on your shoulders. I'd like to help you. And that's when Donna Adelson talks about how stressed she is and how much their lives will change drastically. So I think that the life coach's email just gives Ms. Adelson's comments a little bit of context as far as explaining why she's kind of pouring her heart out there and explaining why she's been so upset.
How much further does this chain go beyond?
I'm not seeking anything more than this page. I think there is more of this chain, but this is the only page I'd be asking for.
All right. I'll reserve ruling on this from now. I'll look at it again when I have my thumb drive and can review the slide in its entirety. Go ahead.
Judge, I think the next item we have, I think we've gotten new slides on this, but I'll go, I think for ease, we'll go on the slides that you have, because it's the same issue. If you go, it's slides 255. We don't actually have new slides on this, I apologize. It's slide 255, where Agent Corbett is estimating how long travel takes. we're moving to exclude that based on speculation.
Stugan, did Sergeant Corbett do any calculation or in some other way develop this information that can be demonstrated as reliable?
Yes, sir. So on this slide, we have actual versus optimal travel of Wendy Adelson on the day of the crime. The actual travel is based on the events in her call detail records, where it shows the cell towers that her phone is communicating with as she leaves her house and goes on her way that day from by the crime scene to ABC liquor store and up to lunch. That's based on call detail records. And also other evidence like an ABC receipt that she had that day. For the red dotted line, that's the summary of the shortest route. So we're saying this is the actual route versus the shortest route she could have taken from point A to point B, her home to where another liquor store is and the restaurant. What he uses to show travel time or miles is a company called, or a mapping company called Esri, which is, and if you need to hear more about it from Sergeant Corbett, he'll be here in just a second. But basically that is a software that Florida Department of Transportation uses for their mapping and mileage calculations. He uses this very regularly in all of his mapping and travel calculations in all of his presentations. And
Hello,
he knows
Gavin.
it's reliable because several times he's tested it himself. He looks at where the map says the travel time should be in the miles, and he does the drive himself. So he's been able to personally test this several times, and it's been accurate. And what we have in this slide is, one is call records, the other is the summary of the shortest route, and it's literally just saying, hey, this is point A, this is point B, and this is the mileage according to Esri, and this is the minutes it should take. And it's twice as long as the actual, or twice as short as the actual route.
All right. The sergeant also will be able to testify as to his knowledge of this program, its use, and the fact that he is qualified to use this program.
Yes, sir, and I can ask him those questions today if you'd like me to, but he regularly uses this program and has knowledge of it, is qualified to talk about it, and has had personal knowledge of testing its accuracy before.
All right. On this issue, Mr. Rauschbaum, you're essentially objecting that either the sergeant does not have an accurate calculation or in some way misuses the program. What exactly are you getting at?
May I have one moment, Your Honor?
Go ahead.
Judge, the objection isn't as to his knowledge, and you know what, we'll withdraw the objection.
Very well.
Rather
Let's move
cross. Judge, the next one, and let me just confer with my co-counsel for 1 second.
Go ahead.
Judge, the next one is page 318. Some messages between Charlie Adelson and Donna Adelson. Charlie Adelson's messages are hearsay, and they're not in furtherance of a conspiracy.
Response, State.
Yes, sir.
I could just give you the date of the messages too. The date is August 2nd, 2016, which is after the arrests of Sigfredo Garcia and Luis Rivera.
Ronnie, I have to take a quiz. It'll take me less than 30 minutes. I do have a timeline on it. Can you handle chat while I'm doing that. Just keep an eye out. Nothing major. Please.
Stugan.
In the motion, defense also objected to this on the basis of joint defense privilege. Is that no longer being argued?
It's not that. We're the document we objected to on behalf of joint defense privilege is a, hold on, let me just double check. Is a different one, and we're going to withdraw that objection given the court's ruling earlier today.
Okay.
This doesn't have to do with that because it doesn't mention
This
Mr.
is
Marcus.
just hearsay. Okay.
This is just hearsay.
All right. So, Judge, on page 318, what we have are co-conspirator statements. This text message is, it says, this is from August of 2016. So this is going to be after the arrest of Garcia and Rivera. It says, from Charlie Adelson to Donna Adelson. Did you see in the paper where the state star witness that rented the hotel room is a convicted cocaine dealer? Maybe those guys were just up in Tallahassee buying drugs and just in the wrong place at the wrong time. Maybe the coke dealer did it because Danny didn't pay for his drugs, just like he stiffed everybody else he did business with. This whole thing is just crazy. Then Donna Adelson goes on to say, I didn't see which paper. Charlie Adelson says, Tallahassee Democrat. Miss Adelson says, wow, I've stopped reading everything. Charlie Adelson says, the guy admitted to selling them cocaine and hanging out with them. And Donna Adelson says, OMG, exclamation point. Our argument would be that this is co-conspirator statements. This is nothing more than co-conspirators celebrating another possible explanation that does not involve them for this crime. They are theorizing about another possible explanation for Dan Markel's murder. And this is showing just their theorizing and celebration of something that doesn't involve them that could explain the murder.
Okay. I'm going to be looking over here.
Any response?
I don't understand it. I mean, it is, I mean, I can show you the text messages in its entirety if you would like me to bring it up, but that's not what's happening. And I don't even.
I'll review it with my thumb drive as well when I go through the slide deck. The problem, Ms. Dugan, that I'm drawing with this, the communications do not have to be so overt as to saying, you know, we're hiding the gun here or something of that nature. But them essentially mocking, I guess, the drug dealer or the fact that someone else has been arrested in furtherance of their conspiracy. I guess flesh that one out for me a little bit more.
Well, also, I mean, their defense is that they were extorted. And this message pushes back on that. At the time this text was sent,
Don't speak over each other.
Garcia and Rivera had been arrested already. So Donna and Charlie Adelson would have known the people behind Dan Markel's murder. And now those people are behind bars. And now, so why, if they've been extorted by these people for the past several years, why are they theorizing about another possible explanation for this murder? They know what happened to him. Those people have been extorting them for years and they're arrested. Why are they now trying to say maybe he was killed by a cocaine dealer for stiffing him? Why are they theorizing and celebrating something that doesn't involve them?
All right, so I follow your logic. You're not offering this for the truth of the matter asserted, but rather to rebut any theory the defense is planning to present about a extortion conspiracy of some sort.
Right. Yeah, I'm not offering it to show that the state star witness was a cocaine dealer. Maybe Dan Markel was killed by a cocaine dealer, or that's what Charlie Adelson actually thought. It's to push back on extortion.
As to the basis of which it's being offered, Mr. Rauschbaum, what is your argument?
The key is you got to look, and I'm happy to hand it up to you. You have to look at what Donna Adelson says. She doesn't say any of that. She's asking what paper, and I don't know what you're talking about. So it's Charlie Adelson's statements after the conspiracy, the alleged conspiracy. after the arrest, after the murder, and Donna Adelson doesn't respond in any way to what he's saying. She doesn't have a clue what he's talking about.
Right. As to this slide, I'm going to reserve for now. I cannot ask you to show your defense or what you plan to argue, but ultimately, if any way, if it comes down to your client was relying on the statements of Charlie Adelson in some way concerning her behaviors and how she conducted herself and whether she in fact knew of the extortion, if the state plans to rebut the extortion theory of the defense, it is permissible as to that basis, but not for the truth of the matter asserted. If a limiting instruction needs to be given, it will be given as to that specific slide. You may continue.
The next one, Your Honor, I don't have a page number. Let me see if I can figure it out. I think it's 321. It's very small writing, and it involves text messages between Donna Adelson and Wendy Adelson after Charlie Adelson's conviction. Again, the text messages by Donna Adelson are fair game, but the text messages by Wendy Adelson are hearsay.
Response.
And the timing of it is critical. It's after the verdict. It's actually the hours after the verdict in Charlie Adelson's case. So I'm not sure how it could be in furtherance of a conspiracy.
Stay.
So I think that and we may be able to come to an agreement on this. I think that I'm going to, there's several messages between Wendy Adelson and Donna Adelson in this chain. I would only be using from when Donna Adelson says, prayer hands, you shouldn't have to pray. He's telling the truth. He protected his little sister from years. To your brother protected you for years, now you're not guilty. I wouldn't be offering anything after that. So I think the only thing Wendy Adelson says in the meantime is, I love you, call me if you can.
If that's all, then we're okay with that.
How about that? Let's move on.
Okay. The next one is page 324. So
we can come to an agreement on this one too.
We're on a roll, Your Honor. So you're not using.
Do we need me any further? Call it a day?
I'm not going to use that one in the presentation.
Okay.
I tried to give them all the things that I could possibly use and have to try to whittle it down some.
Just to be clear, that's the Cellbrite with the website pages.
I will be using the website page for the non-extradition countries, but not the emotion.
Okay, we're good. That's all I have for now, Your Honor.
Very well.
On this issue.
As to slide 20, I will review the entire email chain and then make a ruling on it. Is Sergeant Corbett here?
Yes, he is.
You can go ahead and step down so we can take the witness. Sergeant, please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You may take your seat.
Thank you, sir.
Mr. Dugan, I will allow you to inquire. The only thing that I would ask is that you hit the points that essentially were at issue in the last hearing. If there's other examination you have for the sergeant, you certainly may get into that as well.
Okay.
You may inquire when you're ready.
Thank you.
Yeah. Of course.
All right, Sergeant Corbett, can you tell us your name, spell it for the record?
Certainly, it's Christopher Corbett, and that's Corbitt.
Okay, I know you've provided testimony a lot of times in this court, but just for the record, can you tell us where you work and what you do there?
Certainly, I'm a sergeant with the City of Tallahassee Police Department, and I supervise the technical operations unit.
Okay, and we're not going to be asking you for any opinions today, I don't believe, but just for the record, have you been qualified as an expert previously in the field of historical communication records analysis?
I have, yes.
And about how many times?
118.
Thank you. All right, so I want to go through a few different things that we see in your summary quickly, or types of things. One is going to be call detail record summaries. The next is going to be the plotting of location. The next is going to be, I want to touch on your routes, something that came up earlier today. And the next is going to be emails and text. For summaries, in this case, did we receive phone records for Wendy Adelson, Charlie Adelson, Donna Adelson, Harvey Adelson, Sigfredo Garcia, Catherine McVanwell, Louis Rivera?
Yes.
And did all of those phone records come from each party's respective carrier or phone company?
They did, yes.
Were each of them accompanied by a certification of business records?
They were, yes.
Are the phone records in this case voluminous?
Yes.
I mean, about how many pages are we talking about? Or just, I mean, hundreds, thousands, something like that, ballpark?
Ballpark is in the thousands. Just one set of records for Charlie Adelson is 4,400 pages, PDF pages. There's probably around 190,000 records that if you put to pages, approximately maybe 8,000, and that's, I think, on the low side.
In the summary that you prepared for the state and a copy has been given to the defense, which is the same copy that you were deposed on a couple of weeks ago. In your summary, were you able to narrow the parties' communication events by focusing on what law enforcement sees as significant days in the planning and execution of this murder?
Yes, I was.
Now, in the presentation, do we see call detail records summaries of communication between the parties?
You do, yes.
All right, I'm going to mark this as states one. I've shown it to defense counsel. This is just is this an example of one of the slides that shows the call detail record summary?
Yes, it is.
Okay. And if I could publish to the court. Thank you.
Is there any objection to this exhibit?
No, Your Honor.
It is admitted as a part of this motion hearing.
Thank you. All right, so in your presentation, do we see several call detail record summaries, just as we saw on Exhibit 1, throughout the presentation for the parties' communication on significant days in the murder?
Yes.
All right, is Exhibit 1 an image of how those look?
Yes.
Is that how they look, though, when you get them from raw records from the phone company?
No.
What do you do to make them easier to read and put them in that format? How do you do that?
First and foremost is assembling all of them together into one database or one pool of information. We will assign names or subscribers to the numbers so that we can recognize which party is speaking with which party. We have to evaluate each of the events to determine if they are valid communication events or if there may be routing events or voicemail events, and those may or may not be included. We would remove duplicate events in a summary like that. If two parties or two subjects are speaking to one another, we would have both of those events. From one party's record, it would be outbound, the others would be inbound. So we would eliminate one side of that so that we could show that it was one communication between the parties, and then it would be assembled in something that's much easier to understand and read, which is the format that you had in your exhibit.
After each one of those call summaries in the presentation, or after most of them rather, are there slides that show photos of the parties with arrows depicting the communication and then showing who communicated with who, the time that happened, and the amount of time they spent on the call?
Yes.
Okay, and what I'm gonna show you, or what I'm showing you, I'll label as states 2. Is states 2, how those, an example of how those, I guess like a chart of the phone communication looks in the summary.
Yes.
All right, at this time I move states 2 into evidence.
Any objection?
No objection.
States 2 is admitted at this time.
May I publish to the court at this time?
You may.
Now this chart, the heads that has the data about the communications, are all of those charts that appear in the summary, are all of those based on the data that we see in States Exhibit 1, the call summary? So are they based on the call summaries for each of those specific charts?
They are based primarily on call summaries. Some of those would also include maybe text messages from another source, an iCloud return or a Cellbrite report. There may be calendar entries and things like that, primarily from the call detail summaries.
Okay, meaning that that's going to track a communication, whether it be a text or an email, that occurred between the parties.
That's correct.
And then you're saying that some of the charts with the heads and the arrows, when it contains the content of a text, that content would be from a Cellbrite report.
It could be, yes.
Okay. Regardless of whether it was from a Cellbrite or from the call detail records, is all of that communication in those charts from voluminous records, whether it be from a Cellbrite or from a call detail record from a phone company?
Yes.
For some of the communication events, I'm now going to move on to the location data. For some of the communication events in the call detail records that you told us about are these voluminous records from the cell phone companies. Were you able to determine location data for some of those events?
Yes.
All right. And I know you've given the court explanations in the past of how you do that. Judge, do we need to talk through that today?
Just briefly, so
Okay.
it's part of the record for the motion hearing.
Thank you. Would you give us a brief summary of how you do that?
How I determine locations?
From call detail records. Yes.
So the call detail records themselves will generally contain, for most events, the location information in the form of the cell site or cell tower that the handset is communicating with for that particular event. From that, either directly in the records or from another key or cell site database, we would be able to determine the location of that cell site, where it physically is, plot that on a map, and then start to make some determinations about location. Generally, historical cell site analysis is about inclusion and exclusion. Given locations, places, times, and ask if a handset could be consistent with being at that location based on the cell site that it's communicating with, or inconsistent with that location. In addition to the cell site, we're also generally provided a side or a sector of a cell site. Most of our cell sites are broken down into multiple sides. And so that helps us kind of further narrow down where a handset may or may not be.
How does your specialized training allow you to determine the location of a handset or the distance from a cell site of a handset that a layperson might not be able to?
There's obviously a significant amount that goes into that. First and foremost, locating the cell site, determining the accurate sector or side, determining the width of that sector or side, how many degrees or how far across on a clock, so to speak, that sector might cover. Evaluating adjacent cell sites or nearby cell sites to determine what the appropriate effective coverage area of that cell site may be, taking into consideration topography, buildings, bodies of water, other things that may affect that radio signal. And then again, ultimately determining if I believe that a handset could have been at a particular location at a particular time.
When you determine, or when you are able to determine location of handsets, do you plot the cell sites on a map showing the cell sites, the time that the phone was communicating with that cell site, and the sector that they were communicating with?
Yes, sometimes we don't need to be as granular as the sector, and so sometimes we only plot the cell site itself. That may be good enough for the point, or there are times, yes, that we will indicate the sector as well.
Okay. And do we see those maps throughout your summary?
You do, yes.
All right. Do you use other things besides just call detail records to help you determine the location of a handset or who may be operating a handset at the time of a certain communication?
Yes.
Okay. In this case, did you use, let's start with, are there some examples of text in this case between the parties that helped you form an opinion on a party's location?
Yes.
Okay. Are some of those examples, if Charlie McBanwa and Catherine, I'm sorry, Charlie Adelson and Catherine McBanwa are making plans to meet up, and do you help or do you look to that text message to help you determine their location when you then look at the call records and maybe see evidence of a meetup?
Yes, absolutely.
Okay. Or if you see a text message that says outside your house, can that help you determine a party's location when you're looking at the call detail records to see if their location is also consistent with being outside a person's house?
Yes.
In the summary, we also have, in addition to texts that have location data, we also have traffic tickets, car rental agreements, GPS pings of a rental car, Premier Jim still shot from footage, bank records of Rivera showing a picture of him at an ATM. I guess were some of those, I guess like a bank record, could that be part of a voluminous record as well?
Yes.
Some of those arguably not part of a voluminous record, like a traffic ticket or a rental car agreement. Would you agree with that?
Sure.
Okay. Why were those included though in your presentation? All those things that I just named, in addition to the text with location?
Again, the cell site analysis is about locations and times. So, for instance, the rental car agreement for the first rental car provides a location and a time. It's an address of the rental agency and a time that the car was rented. So this allows me to take that location and time and compare to the call detail records. I can look at the locations of the involved parties to determine who was present, who drove to the rental car location, who did not. The citation afterwards, the location of the citation tells me that Mr. Garcia was in a different location than Ms. McBanwa, because we don't have Mr. Garcia's cell site locations in that time frame. So the location of the traffic ticket helps me understand that after the rental, he went somewhere different than she did. Helps me understand that at the time of the rental, where other parties were. Mr. Rivera was still at his home. Mr. Adelson was nowhere near. So we can determine again who was present, because that rental agreement gives me that location and time to compare records to. It's also the type of event. So it's a, picking up of a rental car. And so as we look at the call detail records and who may be communicating with who in that time frame, understanding generally how car rentals are conducted, knowing that Mr. Rivera or Mr. Garcia ends up with the vehicle, Ms. McBanwa takes him out there. It's presumable that they're both in the car together heading to that event. So I don't expect really to see communications between them, nor I might not expect to see communications between Ms. McBanwa and Mr. Adelson, because she would be in the company of Mr. Garcia. And then I know the date and time that the rental actually happened, and I would from that deduce when they separated. And then I start to see communications from Ms. McBanwa to Mr. Adelson, because now, again, based on how a rental car generally happens, she has dropped him off, he has the vehicle, and now she would be by herself in the car and free to communicate. So all of that together goes into the analysis, if that helps.
Okay. Does the documents that you just spoke about, along with the other car rental agreement and traffic ticket, GPS ping, the Premier Gym footage, the ATM picture, do those documents help you determine cell phone location and help you form your opinion on where the cell phones are and who was using them and put the communication around them in contact?
Yes, they're all locations and times that I can compare the records to. It's a validation of the records themselves. When I see someone in a picture or a video, I expect that their handset locations would be consistent with that. And if they're not, then there was an issue. In this case, they are consistent. So that's a validation of the records themselves. Yeah.
Okay. I was briefly going to touch on the routes, but now I'm remembering that that objection was withdrawn. Is the court requiring any questioning on the software he uses to route? Okay, thank you.
You may lay any record, though, you think is necessary.
Okay, at this point, I don't think any is necessary, but if it comes up later, we can. Emails and texts are the next things I wanted to touch on. In your presentation, are there several emails involving statements by Donna Adelson?
Yes.
Were all of the emails provided by Google, which is the company that Wendy Adelson and Donna Adelson use to service their email?
Yes.
Does that contain a business record certification?
I'm
It does, yes.
Now, why were the emails
Today
included in this
is the
presentation?
13th.
They were included
Yepper.
to illustrate the content.
I just scored
and as far
100% of
as
my
potential
quiz.
motive or
That is an open
events
book,
that were
so.
occurring at particular times during the
Okay.
investigation.
That's what it is.
Do the ones that were chosen involve Donna Adelson's interest in the custody battle and motive in this case?
Yes.
So currently
Are
we
the
are
amount
at
of emails
literally
in this case from Google voluminous?
They are, yes.
1
About how
hour,
many emails?
no, 2
would you
hours and
say
12
that there
minutes.
are?
Wendy Adelson's account has over, I believe, 87,000. Donna Adelson's account is over, I believe, 57,000 individual emails.
Okay. And I'm just looking for a ballpark here. In
I'm
your
going to call my daughter real quick. I'll
draft
be
of
right
your
back.
presentation, the same one you were deposed on, about how many emails did we send to defense as emails that these are of interest to us and we may use in your presentation?
No more than 25.
Okay. Since then, have we been able to kind of whittle those down to a smaller number?
Yes, we have.
Maybe 5 or 5 to 10?
Definitely less than 10, I think 5 or 6.
Okay. But despite how many we use in our presentation, are all of those from voluminous records?
They are, yes.
As far as, we also have several text messages in your presentation that don't have anything to do with location. Earlier, I asked you about texts that had to do with location, like let's go to your house tonight or outside your house, things like that. Are there several texts in your presentation that are from Charlie Adelson's iCloud or the cell rights from the phones seized in this case that don't have anything to do with location?
Yes.
All right, not going to go through them all, but do some that are going to be included in your summary, do some involve Donna Adelson's interest in Wendy Adelson's custody battle and venting to Charlie Adelson about that?
Yes.
Are there some that push back on a possible extortion defense?
Yes.
Are the total amount of text that we have in this case from Charlie Adelson's iCloud or from all of the parties' cell rights, are those voluminous?
They are, yes.
About ballpark, how many?
I believe from Miss Adelson's phone, there's over 10,000 WhatsApp chats, 20-some thousand instant messages. Charlie Adelson's iCloud account is, I believe, well over 280,000 messages. Another probably 10 or 20,000 text messages. They're kind of categorized separately, so we're in the hundreds of thousands of messages.
Okay, and thank you for clarifying that. So when I say text message, I mean any message communication as far as text, instant message, or WhatsApp. So thanks for clarifying that. And so that we've gone from, and how many would you say we've included in your presentation to show the jury at this point?
I haven't counted them. There may be less than 20 chats with, maybe, I would probably say less than 50 actual messages. But again, I have not tallied those up.
All right, but from tens of thousands to less than 50?
Yes.
Okay, and those are all speaking to specific issues in this case?
Correct.
Okay. Those are all my questions I had for him, Judge. If you wanted to, I can address any specific slide or document that you feel I didn't ask enough about that you need more of a record on? Okay, thank
No
you.
need. Mr. Rauschbaum, do you have an examination for the witness?
Very, very briefly, Your Honor. So, good morning.
Good morning.
So you testified that with regards to these detailed summaries, there's thousands and thousands of pages, right?
That's correct.
Okay. But on the days that you're using, so in other words, I think Ms. Dugan showed you Exhibit 2, where you're doing the arrows. On those days, if you look at the call summary, it's less than 5 pages, right? It's mostly 2 pages on most of those days.
For those days, the summary that you have may be a page or 2 pages. It took a significantly greater number of pages to get down to those 1 or 2, because again, if there's 5 or 6 subjects in that one summary, well, that's 5 or 6 subjects worth of records. And their records for a 3-day, 5-day period, maybe 20 pages each. So there's 100 pages to work down to get to just the unique communications that populate that 1 or 2 that's in the summary.
So let's get a little granular, okay? So you have one of those days is July 18, 2014.
Yes, sir.
Okay, and you do a
My
summary
daughter
of that day.
Is crazy.
If you took all your call records of that day,
My
would
daughter
it surprise you? All of them. If you took the call records
Drive
for
2.5 hours.
Charlie
to
Edelson,
college
everyone you
at night.
got, would it surprise you
And
that
dinner.
it's under
And drive
15
back home.
pages?
She is very
For
long.
one day to be under 15 pages, it
And
would
then
not
her
surprise me.
boyfriend
Right.
showing up.
Well, I'm telling you, it's under 12 pages.
Okay.
Did that surprise you?
But I
No.
mean, my
Okay,
mom.
so that's not that voluminous, right?
But that's 12 pages to get down to 1. Right.
I get it, but I'm saying if you're putting in a document, in other words, if I use the emails as an example, or the text messages, Ms. Dugan brings up that there's 20,000 text messages, or 12,776 text messages. You can take my word for that. You're only using, though, let's say 8 text messages. I don't know what you're using, but let's say it's 8. How long are those 8 text messages that you're using? They're less than a page, right, each?
They could be, yes.
Okay. The emails that you're using, you've got however number of emails you're using here. Wendy Adelson's email account had hundreds of thousands of emails, I presume, right?
Yes.
Okay, but each email that you're actually putting into evidence, do you know what the longest email is of the ones that you're putting into evidence in?
It would depend on how you format to print, probably not more than 4 to 6 pages.
Yeah, it's 6 pages, right? So the actual piece of evidence that's going to go back to the jury, which is the actual email, not the 100,000 irrelevant emails that no one cares about, but the actual document that's going to go back to the jury is 6 pages long, right?
I would agree with that, yes.
Right? So we're talking about, and Ms. Dugan uses the word summaries, but these aren't summaries, right? These are just taking pieces of evidence that are already going to be in evidence and sticking it into a PowerPoint presentation, which is a way of persuading, right? A demonstrative, not a summary.
I would object to
No,
argument.
my daughter is up in
Sustained.
college.
Okay, I'll
It's
move on.
2.5 hours away.
With the
And she wanted
location
my
data
son and
that
I to
you're
come up
talking
for dinner
about,
with her and visit her tonight.
just centering
Because
on
it's
Donna
6:30.
Edelson.
We won't get there
And I don't
tonight.
know if you
It's
have
6:30
your
to 7:30,
reference
8:30,
up
9
there, so I'll just show
o'clock.
you a page.
Have a late
And we can mark this
dinner
as
with her.
defense exhibit
That's an hour and a
1 for
half.
purposes of this hearing.
And then
And this is
That's
page
11 o'clock
271 of
before
my
we hit the
version of
road.
your- I'm sure it's changed.
Another 2.5 hours to get home.
Yes, sir.
That's 2 o'clock in the
enough
morning
approach.
before I get home and in bed, at least, if not 2:30. We're like,
So
No.
your
she goes,
expertise
well, my boyfriend's
in doing
going to be
this
here tomorrow.
page,
I'm like,
am I right that what you're basically doing is you're taking
my poor daughter
Donna
is lonely.
Adelson's call record, you're seeing
No,
when there's
she's
an
not
event,
driving.
you're looking at what location on the call
Mm.
record the event hits, you're then going to a map
Case
that
one,
AT&T provides you.
driving,
It's AT&T in this case.
shopping.
You're then
Always
looking at
assume
what
you're
the
on someone's
longitude and
camera.
latitude is on that map, and then you're
Safe
just
bet.
plugging it on that piece of paper, right?
That is part of what I do, yes.
on that piece of paper, is that what you did?
You need to say this, Sergeant.
No, I don't. Thank you, sir. Again, to start that, I have to go through, and this is combined. This is Donna Adelson and Harvey Adelson's records. So it's 2 sets of records. So I go through the records to find the relevant time frame, and there's 3 data sets for each set of records. There's voice calls, there's data sessions, and there's text messages.
No,
so I isolate out each of those 3 data sets.
I am not doing
for
it on a bad back.
2 sets of records. And then I have to evaluate those records for what I consider to be valid location information. And so a number of records are eliminated based on my understanding and knowledge of AT&T records. A lot of those locations are eliminated so that I have valid locations to plot.
Surprisingly,
So
$50.
from that, each of the locations in the records have to be verified against a records key or some other database for me to make sure that the information provided in the records is accurate. And then that is plotted onto a map. And then from that, some estimation or determination about where the handset was during those events can be made.
Okay, let's try to simplify that. I know you like to make it a little bit more complicated than it is, but when you say you eliminate events, you eliminate them, for instance, when it says 0 seconds, correct?
0 seconds could be a factor.
What really helped me is I have a heated mattress pad on my bed.
It depends. Location information, the duration may play into the validity of data sessions. In particular, with these records at that particular time, not all the locations contained in the data sessions are accurate at the time. So I have to go in and evaluate each one of those to make sure that they are the correct usable
I
locations.
have 2 hours and 22 minutes.
And I guess I'm not the one to determine how much expertise that takes, but I believe that it certainly requires it.
Well, on that piece of paper, which is all Donna Adelson's, everyone that relates to Donna Adelson looks like that, okay? So on that piece of paper, would it surprise you that all you needed to do for that piece
I
of
would
paper?
object to relevance to what would surprise him.
Yeah, I would too.
Okay.
Please
I'll rephrase it. On that piece of paper, you can see those times directly on either Harvey Adelson or Donna Adelson's chart. You see a call
I know
or a
when
text
the
message.
phone has been picked up,
You
but
go
they
and you
don't know
look at
if
what
it's
time
me
it is,
picking up
right?
or my daughter
Says
next to me picking it up.
8:15 next to the call.
Correct.
The only thing is it
And
doesn't
then
know
to the right of
who
it,
is
it
picking
gives
it
you
up,
a
but it knows
longitude
that
and
it's been
latitude
elevated and put back
It
down.
does.
for
It
each of
does.
these. And then you take an AT&T map and you plug in that longitude and latitude, which is what you did, right?
Well, I don't take an AT&T map. I take the mapping software that we use, the Esri mapping.
Fair enough. You plug in that longitude and latitude and it spits out a point to put a dot on a map, right?
It does.
And so even though it can be difficult, I'm not saying that there aren't examples that are difficult. In the ones that you're doing for Donna Adelson, it's on these pages. It's as simple as that. It's as simple as looking at the data, plotting it in, and doing dots.
Again, I don't know that I'm the one to quantify what is simple or difficult, but I will tell you that if you took her records and you plotted every event in that time frame, you would be plotting some incorrect locations. So it at least requires the recognition of valid locations at the very minimum.
So tell me, on that piece of paper, what events were invalid that you got rid of? Because I don't think there were any invalid on that piece of paper. I don't think there are any other cell site data that showed up. I think those are the only ones that showed up.
In that sequence, that travel sequence in those
Tell me what you eliminated.
time, there are a number of data sessions, and I would have to be looking at the records themselves, that are continuous data sessions. And so they show locations, particularly for Mr. Adelson's cell phone, as I recall, of data sessions that originated at his office. And those data sessions continue to show the original location, even though the times increase. And so
You're talking about Charles Adams.
I'm talking about Harvey.
Okay, here, over here.
It showed him at his office on that
Really?
day?
It did, yes.
On July 18th?
As I recall, that
Are you sure about that?
I don't want to say office. There are, if I can look at the records, there are data sessions that originated earlier in the day that continue to show the original location.
Okay, let me ask you a more simple question. On the actual exhibit that you're using, which starts at 8:15, I think, it plots, I think, 4 locations. On those 4 locations, was there anything that you had to eliminate in between those 4 data points?
I don't recall specifically. I could look at the records and tell you, but I do not recall if there were other things.
Well, do you have the records in front of you?
I have my laptop. I can pull them up. It will take a minute, but
sure.
Go ahead.
Come here. No, Cynthia, come here.
Judge, while he's getting his computer out, the court, my memory serves me. It seems like this line of questioning is Mr. Ashbaum's trying to inquire into his level of expertise and why does it require an expert to do this type of work. Did the court already, I believe the court already ruled at our last hearing that he would be able to testify as an expert, form an opinion.
Hey, Matt, I need your help with Sensei.
Locations of cell phones,
Please.
all of the things we would be offering him for in that purpose.
That ruling was made. Ultimately, is this going to an opinion that he is not permitted to give in some way, Mr. Ashbaum?
No, I mean, I'm trying to show that there's no expertise in these particular documents. There might be in showing where Sigfredo Garcia's timepiece was, but that there is an expertise with regards to Donna Adelson's. And I'm going to using this to show that the documents that he has chosen here, or that the state has chosen for him, that it's a demonstrative. It's not a summary exhibit as iterated under the Florida statutes. Again, we're not arguing that the demonstrative can't
You're gonna
be
break
used,
my
and we're
name.
not arguing that the underlying documents can't come in. We're arguing that his presentation is not a proper summary, but is rather a closing argument that shouldn't go back to the jury.
As to that point, I'll permit it, but let's not have a full cross-examination of the witness that goes beyond the issues as to the admission of the evidence.
Fair enough, Your Honor.
Now you're going to be dead weight, aren't you? Oh. Oh my God, were you a pain in the butt? Her. I don't know why that was so hard for her. That was like brutal.
Sergeant,
I got to scoot up.
We can move on to.
not difficult. It will be a little time consuming again.
Let's move on. I think we've made the point. Sergeant Corbett.
Wow.
These emails and these text messages that you pulled, how were they chosen? Did you choose them?
I did not choose them, no.
Okay. Who chose them for you?
They were ultimately chosen by the state attorney's office.
Okay. May I have one moment, Your Honor?
Go ahead.
I have no further questions.
Any redirect examination for the sergeant?
No, sir.
You may step down, sir.
Thanks, sir.
In addition to the argument that was made at the previous hearing, does either party have any additional argument to offer before the court rules?
Very briefly. Or did you want them?
Whoever's ready.
Why you don't?
You are the proponent, Ms. Dugan, so you get the first crack.
All right, so we heard about several different types of items that are in the summary. The first is the summary of CDRs, and the example is states 1. We heard that those are pulled from voluminous business records for certain periods of time. Then we saw the charts that are basically a visual depiction of that communication that's but in a more digestible format for the jury. It's based on data from those call detail records, from the voluminous business records, and also from voluminous records in the Cellbrite. The only thing in the chart that is from Cellbrites would just be some charts have contents of text messages in there. All the rest are going to be calls back and forth with the time and the person making the call and the person receiving the call. But all of that information is based on the data, and we can't just give the jury all of these cell phone records and say, even if a certain day is 16 pages across 3 sets of records, and say, good luck. That's why the summary rule
I lost a
allows
nail.
us to pull this information, put it together in
Now I got to get
digestible
them all off.
format
I
for the
can't do
jury.
it.
The second type are the maps with the cell site locations. These are summaries of the parties' locations at certain times that are also pulled from the voluminous cell phone records. The same records that the call detail record summaries and the charts with the heads are pulled from. Other items like the premiered surveillance footage, the tickets, the texts that talk about a person's location, the bank records, the car rental agreements. All of those things are in the summary because they help Sergeant Corbett form an opinion
Is this
on
live?
who had the handset at the time and where that handset was located. And they help verify the call detail records themselves. Finally, we heard about
Hello, sneaky
emails and text
side.
messages. The emails are business records from Google. These are voluminous records. They're being testified to by a sergeant who specializes in communication records. He has identified and verified these as being from these accounts. There are thousands of emails. We found several emails, lots of emails that go to motive or go to the interest in the custody battle here. We're going to be using about a handful in the presentation. The same with the texts. These are maybe 50 texts narrowed down from hundreds and thousands that show certain relevant issues.
Yes, she's in my lap.
On extortion or other things. And these are all pulled, though, the emails and the texts. The texts that aren't location data is what I'm talking about. They're all pulled from voluminous records, and they're all a summary of evidence showing a relevant issue.
Since I broke my nails, they're coming off.
Thanks.
Thank you. Mr. Rashbaum.
Judge, you've seen their summary. Their summary is a closing argument. It's not a summary. It's a demonstrative. Our ask here is not a big ask. The underlying exhibits are going to go to the jury. They're not voluminous. The fact that there's a universe of text messages and they've chosen 10, 15, or 20 of them does not mean that they can make a summary of it. That's not how the rule works. They can put in the text messages, none of which, not one text message is voluminous in this case. Not one email is voluminous in this case. And by the way, the call records aren't voluminous because what they're going to put into evidence are they're going to put in the overall call records, and then they can put in, if they want, a subset of the call records. For instance, July 18th.
We are still on the verdict watch.
They're
Yes.
literally less than 12 pages. Now, we're not suggesting that Sergeant Corbett cannot have a demonstrative that illustrates the issue, but to allow a 320-page document or whatever it's going to turn out to be, which is purely argumentative. I mean, they're taking text messages and homes and cell locations, and they're all making their argument of what it means, is precisely what the court in Pete Incorporated v. Vanguard 378 F3rd 1154 cautioned against. When it said, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. That's what they're doing here, Your Honor. They're putting a closing argument. They're trying to put his demonstrative as a summary exhibit of a closing argument to go back to the jury. That shouldn't be allowed. And so, Judge, we're not asking that a demonstrative not be used. We're not asking that the underlying documents don't come in, but we're asking that the exhibit be a demonstrative exhibit, that does not go back to the jury.
Baby girl, I love you, but 50 pounds
So
on
briefly,
leg
it will
can't handle it.
tickle my ears and we'll move on. Go ahead.
There is no argument in any of these slides. This is all data and information from the records. There's plenty of evidence in this case that is not in this presentation that would be in a closing argument demonstrative. This is not a closing argument demonstrative.
Judge, may I briefly respond?
Let me set my watch. It's 11:02 and 32 seconds. By 11:03, you will be done.
Argument is when you plot lines on a map and then you take a text message and you put it next to a house and you put it all together. That's argument. That's using data to make an argument. That is the definition of argument.
Within time. Thank you.
Your Honor.
All right. As to the rulings on this matter, the court has previously ruled that Sergeant Corbett can be qualified to testify to the
Okay, I need you to
interpretation
get off. Come on. I
of
can't do it.
historic
Legs hurt. Go.
communication data.
Come on.
The summary will be available to the state as a demonstrative in front of the jury. Also, in researching this matter, I came across a recent
feel like
case
she's
of
breaking my
DCA
legs.
dealing with summaries, which I believe has a relevant ruling to this matter. This is EJD Construction Contractors and Investment Corporation versus Preston, found at 306 Southern 3rd, 1053. And ultimately, the third DCA held when a summary is accurate and not misleading, it can be properly admitted during trial. The summary may also include opinions by the individual preparing the summary, as long as the opinion is based on the underlying evidence and data that is admissible. To that point, the court will permit a summary to be admitted to the jury. However, the summary may include a page cross-referencing all voluminous records or state exhibits that Sergeant Corbett used in forming his opinion, his method of analysis, and the conclusions that he reached, or any inferences which may be properly drawn from the evidence. The summary is not to include any cumulative repetition of admitted state exhibits, and this is specifically going to matters such as emails, text messages, videos, things of that nature. Any inadmissible information or any opinion the witness is not qualified to give. This is going to cut down the pages that actually go back to the jury, but a summary that is based on the voluminous records and exhibits and the opinion that was reached by the sergeant that is proper and meets the definition of a summary pursuant to 90.956 will be permitted. Any additional objection that needs to be raised at the time it is offered, the defense may raise at that point. The parties need any clarification on the ruling?
No, sir.
And just so it's clear, as far as the call records, summaries, and I believe the arrow charts, those will be permitted as far as being in the summary itself. The location maps, that will be permitted as well. But again, all of the other matters that are not
We have hit 2 hours and 38 minutes.
Emails, text messages, or videos. It can be cross-referenced as to what the sergeant used, but it will not be a part of what is admitted. The demonstrative itself, though, can be used as the state would like to use it. Ultimately, for that, if there are any inadmissible items that still need to be ruled upon, I believe slide 20 is the only one outstanding. I will give you a ruling on that matter before it is to be used even as the demonstrative. There are no questions. We are finished at this time. I will see everyone on Tuesday morning at 8:30, and we will begin with the jury selection process. The process will be, as we did in the last trial, going through the same 5 questions dealing with pretrial publicity and any hardship. The parties will be permitted to examine the prospective jurors based on the court's questioning. Anything that we need to address before we finish?
Nothing from the state.
Judge, there is just one scheduling issue.
Go ahead.
And look, maybe trial will go quicker. I'm hoping it does, but based on what I'm seeing, October 3rd is Rosh Hashanah, the Jewish holiday. And just wanted to see.
I believe the court is closed on that day.
And I'll sit down now.
I'm not going to make you work on a holiday,
So,
Rush,
I know I'm
but
focused on getting these nails off. Once I break a nail, I have to get them off. I can't do it. I just can't. And these have been on for 3 weeks. I can't believe they've been on 3
Yes,
weeks
sir.
already. So I'll go get my nails done and
All right, let's
maybe
have a
Sunday.
sidebar.
So we're gonna watch her again. We're gonna watch her again. I wanna see this again, okay? Do y'all want to? Well, too bad. We're watching. Speak now, forever hold your peace. Here is the actual testimony of the mom again.
We
Uh-oh.
are in Florida.
Didn't mean to do that.
Yes, sir.
Okay.
All
I
right,
wanna
let's
see
have a
this
sidebar.
again. If y'all are mind with it. That's right. We can zoom.
I don't.
Mr. Wig. That's okay. Now, the biggest question I have for you, because you didn't mention it once in your entire story, is when did your husband get killed?
The exact date I cannot recall. It was
How
beginning of
can you
May
not?
2016. It was not November.
Okay. So sometime, you don't know, but sometime in May of 2016 is when this happened. Okay.
Yeah, but
Now,
everybody is saying that's not accurate.
your phone number prior to this homicide was 352-431-0419, correct? You don't know your phone number?
That's not my phone number now.
Okay. You don't.
I do not recall my.
Okay. But if that's the phone number that is from all those screenshots between you and Jeremy Townsend that you saw, would that refresh your memory that was your phone number?
Yeah.
Okay. And you, at some point, changed your number to 352-431-8444, correct?
I don't believe. I can't recall that because at some point I put my parents on my phone line.
You remember seeing the court document that was submitted into evidence where you put your address and phone number on it?
Yes.
And that 844 number was what you listed?
Yeah. I don't remember the phone numbers from back then. And since then, I have also had my parents on my phone bill.
My question was whether or not that was your phone number. You agree that the 8444 number was your phone number based on that court document?
Yes.
You would have been truthful in a court document, correct? Yes. Okay. Now, I also, one of the statements that you made, I think you said you wouldn't recognize Jeremy.
Today, when he walked in, I would have never recognized him today. That's not what he looks like.
All right. Now, you mentioned the fact that he had this skull tattoo. You have a skull tattoo too, right? All right. So that doesn't really mean anything.
Well, I had mine way before.
Okay. Now.
What? Do you guys know? Do you guys know how freaking painful? That is one of the most painful tattoos you can get. So she was a bad girl. All off. I know I hate it, but I'll get them done.
You were saying that you met Jeremy Townsend in August of 2015.
Yes, at the end of August.
And that he passed you some sort of Post-it note. Yes? All right. And you had
talked about because you had marks on your face or something like that. Is that a yes? All right. Now, according to you, Michael Shaver had left the residence in November of 2015, correct? Your residence.
Yes.
All right.
I had kicked him out.
All right. And well, I thought that you were the type of person that would just shut down and retreat and couldn't confront anybody. That was your words, right?
No, I said that I'm not the type of person where if you come at me and say something like belittling me or anything like that, I shut down and retreat. I'm not confrontational.
All right.
And that was in the context of me and my daughter.
But you can't. But you were confrontational with Mike Shaver.
Yeah, I told him to get out because he knew that if I called the cops, and he would definitely be kicked out, and he would be picked up. So yes, it was pretty much easy to get him out.
Let's try to figure out this timeline. In September of 2014,
yes, shall we?
He was arrested for a domestic incident that involved you, correct?
Correct.
And that is when he went to the airport hangar, correct? Where he started living.
Yes.
All right. Did
Who lives at an airport?
Move back into
How
the
do you
house
live at
after
an
that?
airport?
Yes.
That
All
doesn't
right.
make
When did that
sense
happen?
to me.
I don't know the exact time.
Okay.
It was.
How long had he
It
been gone?
wasn't. He had been gone over a year.
All right. So sometime in 2015.
It was, yeah, probably summer 2015.
Okay. So if the arrest was in September of 2014, approximately 6 to 8 months that he was gone?
No, it was greater than that because he had finished his probation period.
Okay. And in that incident, he also suffered injuries, correct?
Yes.
Because you hit him over the head with a gun, correct?
Well, he had the gun pointed at my head, and at that point, I was done. I thought I was giving up at that point. I had nothing left in me until I seen my kids come out and start screaming. And as soon as I seen them, I took and slammed that gun into his head.
Okay. Have you ever told anyone that he was not at fault for that incident and it was actually you?
No.
Did you throw a vase of flowers into the sliding glass door and break that?
I did.
We're getting into specific conduct that the state has moved to exclude.
Can we approach, please?
Sidebar, please.
I think I have found a semi-comfortable position. I think I found a semi-comfortable position, but I got to keep my toes out of all the cables. Just saying. I'm kind of keeping an eye on Brandy Page because she's in the courtroom in that area anyway. Oh, she's back on. So Brandy just got back. They thought they had something, but they don't. Mm. I'm watching her because she was eyeing something, so give me a minute.
Then in August, I'm sorry, you're saying you actually started a relationship with Jeremy Towson in August of 2015?
Started talking in August, and Michael was still at the residence.
I'll be back.
Okay. So after November of 2015, he does not come back to the house.
Correct.
So that check that was sent to him and deposited in his account, he would not have received, correct?
I don't know. He got his mail.
How did he get his mail if he wasn't at the house?
The mailbox was not at my residence. It was at the end of the road.
Okay. So after he left in November of 2015, are you saying that he would just come by every day to pick up his mail?
I don't know what he did.
Did you ever notice any mail missing?
How would I know if it was missing?
Did you ever notice any of your stuff missing?
No. Did he?
Did you ever notice any mail coming for Michael Shaver to that address after he left?
Yes, a few things.
What would you do with that in order to get it to him?
I would take it back to the post office and do return mail. No longer at this address.
Where was it going?
I don't know.
Where was it?
I don't know. I assumed probably back at the hangar.
If he left in November of 2015 and went to go live at the hangar, why would he quit his job at Disney?
Because there was a sexual harassment charge against him.
Okay. You heard that his supervisor came in and said there was no such thing and there's nothing in those records, correct?
Oh, I did. I heard that.
Are you saying that Disney falsified those records?
The sexual harassment complaint filed against him came directly from Michael's mouth.
Okay. And you had access to his bank accounts, correct?
Yes, he had access to mine as well.
And you withdrew money from his accounts, correct?
And deposited money, correct?
Right. In November of 2015, and what deposits were you making in his account?
I have no idea. I'm not sure that I was.
Deposit that Mariner check into his account?
No, I have no idea what that is.
All right. The money from the sale of all of his property, how did you get that to him?
Well, it was not necessarily his property.
Okay,
It was
what about
on
his guns.
his guns. Okay, so after he was arrested and
My question was, how did you get the money from the sale of his guns to him if you didn't know where he was?
I did not give him the money from the sale of the guns. Those were not his guns.
Would you have any way, if you say you don't even know where he is, would you have any way of getting him any of that money?
No, I never said I gave him money.
You just said you deposited money into his account.
No, I mean, that was throughout the whole marital. I would deposit money and take out money. He worked overnights. So during the day, if he needed anything, any shopping and all of that for the well-being of the house and the kids, I would do that during the day because he was sleeping because he worked overnights.
As far as the Facebook records, all the stuff from the Laurie Shaver Facebook account, you would agree you posted, correct? None of that stuff was anybody hacking you or anything like that.
Did not appear so.
All right. And you had access to Michael Shaver's Facebook, correct?
Previously,
Okay. How did you have access to his account?
well, previously we had a joint account. After we had separated in 2014, I believe we separated emails, Facebook. Prior to that, everything was joint. After that, we went from a joint bank account to two bank accounts, 2 emails, 2 Facebooks. Prior to that, everything was joint because he controlled everything.
Did you have his password?
Previously, well, it was a joint password because it was a joint account.
When he had his own account, when did he start his own account?
After we had separated in 2014.
Did you have his password for that account?
Well, that was our account.
When you said he started his own account, my question is, all right, and did you ever post anything on his account?
No, I did not.
Did your daughter have his password?
I don't believe so.
Was anyone else living in your house after May of 2016 that had access to his phone or password for Facebook?
I don't know about the password, but there was 2 tablets. There was a laptop and a desktop.
Did they have his Facebook profile in it?
Everything was automatic. Everything was already logged in. So all you had to do was just log it, like open it up, and you were automatically logged in.
Was your daughter posting on his Facebook? No. Was your son posting on his Facebook? Oh. Now, did you ever tell anyone that after he left in November of 2015 that he was in jail for failing to pay child support?
I did.
That wasn't true, correct?
No, it was not. That was an old manager that I had a relationship with way back when, and he had moved back from Connecticut to Florida and was reaching out to me, and he was curious.
That's Ramin, correct?
Correct.
And that, when you say relationship, that's another affair, correct? But you told him that Mike was in jail for failing to pay child support and his license was suspended, correct?
My personal information, and he was asking about that because.
Okay, wait, hold on one second. How is Mike being in jail your personal information?
Accurate personal information, because he was questioning. Because prior to that, there was conversations where Michael had threatened once again, after finding out, to kill me.
All right. So when you told your manager that you had a prior affair with, that Mike was in jail, that was a lie. Did you tell your sister that you guys had been working out a separation agreement?
Yes. Well, we actually did work out a separation agreement, and it was filed with court.
In order to do that, you have to get was that here in Lake County?
It was.
Okay, so there is some sort of divorce proceeding with your name on it and Michael Shaver's, because you just said you filed something in court, correct?
I did not say divorce. You said separation. So after 2014, after that incident, we both had attorney representation, and Michael and I came up with an agreement, handwritten. We both signed it. That was filed.
Where?
Here.
Where?
At this courthouse.
What case is that in?
Whatever the prior DCF is, and I had won that case with no adjudication. I don't know where that record is, but it was filed. And in that agreement, he agreed to pay X amount of money. I would keep the kids. He could not take the kids. He would see them every other weekend, whatever. We had that separation. I made more money than he did. I covered the health insurance. I covered the kids. I kept the house. He was moving out of the house, and he was going to pay XYZ. That was a handwritten document that both of us signed in front of the mediator at this DCF agreement that I won with no adjudication.
Was there ever a divorce proceeding started?
No, there was not. Not in the state of Florida.
After 2015, was there ever a divorce proceeding started?
No.
When law enforcement came and asked you about the whereabouts of your husband, you were not truthful with them, correct?
I didn't know where he went. Mm-hmm.
You know what happened to him, correct? All right, you didn't tell him that, correct? The Walmart purchase that was on your husband's bank account, you did that, correct?
I don't recall doing that.
That was sent to your house with your name on it, correct? All right.
I don't recall like the exact parameters around it or what I bought or anything like that.
So this event happens in May of 2016, correct? Say yes?
Yes.
Your relationship with Jeremy Townsend ends very tumultuously in May of 2016, correct? Say yes?
Yes.
And your relationship with Travis Filmer then begins in May of 2016, correct?
He came over at the end of May. Yes.
And you were actually engaged to him in July of 2016, correct?
Yes.
In April of 2016, Rebecca Urbanowski was living with you, correct?
Correct.
Okay. And the fire pit itself was built in March of 2016.
I guess so. I don't
That's when you posted it, right? And then how big was your property? And out of all of that land, you just happened to choose the area where your dead husband's body was found to put that cement slab. That's basically what you're saying here, correct?
know, because I did not know his body was there. It went there because that area was already dug out.
Quite a coincidence, you'd agree, correct?
No, not necessarily. Not if you realize the whole parameters of what came first and how that all transpired. Like I said, that was something that Jeremy and I had originally talked about doing because I had gotten rid of the animals and we had the fire pit and we were talking about wanting to, I mean, it was his suggestion to put in concrete.
So the March 2016 is when you put that fire pit in, and 2 months later is when your husband is still on your property, correct?
Yes. But the concrete was not poured until September.
Correct, by you and your now husband.
But I had no knowledge that he was under there. If I was trying to cover him up, why would I do that so many months later? And only...
I haven't asked you a question, ma'am. So the incident that led to your husband's death, your husband had not been around for months, correct?
Correct.
And he just happens to show up sometime in May of 2016, correct?
Not just happened. That was pretty typical of him being gone for months and then showing up and us getting back together.
Okay.
That was...
And then during that time frame, this was sometime before you were going to take your kids to school, correct?
Yes, he was out on the porch when I went.
How was he dressed?
Shorts, t-shirt.
Okay. And an argument between the two of you starts.
Yes, I went outside. I got the kids settled and I went outside to talk to him.
How old was your daughter at this point?
7.
And is there a reason why you never taught your daughter how to dial 911?
I mean, we just had
Make
cell
sure
phones.
we're
We didn't
okay,
have
and then
any
I'll hop back
landlines.
in.
She knew how to dial 911, but like I said, I had my cell phone on me. The security system that we had, she would not have been able to reach. It was above the keys where the door was.
But when she said, I didn't know how to call 911, I'm asking why you wouldn't have taught her.
I did teach her how to call 911, but she didn't have a phone.
Okay. Now, your testimony is that she shot him, correct?
Yes.
And at that
I
point,
just did all that muted.
that you were able to get out from underneath
I was saying
Mr. Shaver, correct?
we're still in jury countdown. Jury's been deliberating exactly 3 hours and 4 minutes. I have a lady here who has specialty teas. Ollie Tea Company, and I have sampled her tea, and gosh, y'all, do you know how I love my coffee? I'm even pickier with my tea, and that stuff is freaking good. So I will be right back. I'm going to visit with her a little bit, but we're just coming up on 3 hours and 5 minutes. I'm going to let you keep watching this cray-cray woman's testimony over here. I don't know if I have the stomach for it again, but y'all have fun.
I did not crawl away until he was falling to the ground. After she shot him, I was still looking at her, like still comprehending everything that was happening. I wasn't 2 yet because he had his foot on my face, smushing it into the ground. It took me, I mean, it wasn't that long, but it took me a little bit to kind of comprehend what was occurring. And
Certainly
then
didn't get up after being shot, correct? He certainly didn't get up out of the chair after being shot, correct?
no, not until no. After the second shot, he fell forward. The first shot, he sat in the chair.
At the time of his death, Mike Shaver was about 5'3".
5'3".
Mhm.
5'8", 5'10".
Now, the
I'm 5'2".
the probable cause affidavit around the time of his arrest listed him at 5'3" and 130 pounds. You're saying that's inaccurate?
That was probably me.
Okay, you weren't arrested, right?
His probable cause from 2014?
Yes. You're saying that 5'3" and 130 pounds is inaccurate, is what you're saying?
Yes, that's
Okay.
not definitely probably not what's on his driver's license. He was not 5'3". He was like 5'8" and 150, 160 pounds. I was 5'2" and 115, 20.
When Mike left, he left his vehicle, correct?
You're talking about the black car.
No, I'm talking about he had a vehicle and he left it behind, correct?
His black car had been sitting there for a while. He had a bent rim and the air in the tire could not stay inflated. So he was driving my truck back and forth to work.
Right. My question was, when he left and moved out, he left his car, correct? And he left everything that he had that had any sort of value that could be sold, correct? His guns,
He took
his
stuff,
tools,
yes.
his ATV, left all that behind.
All the tools that were in the shed were of no use to him. They were like old tools and stuff like that. And it wasn't an ATV.
My question was, he left the stuff behind, stuff that he could have sold, correct?
Correct.
He stopped going to work and lost his job because of it, correct?
I was not aware of that at that time.
So he lost his ability to make any money, correct?
I was not aware of that at that time.
Prior to November of
Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love.
in 2015, he would call you using the phone frequently, correct?
Yes, because he was back in the house and we were trying to work things out.
After November of 2015, there is absolutely no calls to you after that November 7th, 2015, correct?
I don't recall.
There's not a single call to you, to the children, anything, correct?
I don't recall.
There's no activity on his bank other than withdrawals from the ATM in Claremont where you lived, correct?
I wouldn't know that.
November 2015, he just vanishes off the face of the earth. No one can account for him, correct?
I don't believe that's true.
But you've definitely not had any contact with him in any ways until he shows up someday, which you do not know, in May of 2016 when this incident occurs, correct?
No, he showed up prior to May.
I
At
asked
my
you,
property, but he was already causing trouble prior to that, which fits within his history of doing this.
my question to you previously was, after you kicked him out in November of 2015 and prior to him coming up the day that he was killed, I asked you, did he ever come, have any contact with you? You said no, correct?
Not physically, correct. But calls and stuff like that, yes.
Calls?
Texts, his threats, stuff like that.
You saw the phone records, which show absolutely no
Text,
calls from
Facebook
him
messages,
after November
there
7th,
was-
correct?
All right,
He was-
allow the witness to finish. Thank you.
He was communicating with Jeremy. I believe he had sent me text. He had sent me a nasty text prior to that, telling me I was just like my mom, something to that effect. He was communicating.
From your IP address.
I don't know that that's my IP address. How can you verify that?
Because it's the same IP address that your account that you says you used posted on as well.
Okay, how do we know that he didn't post on my face or log into my Facebook?
So what vehicle, the day that he showed up in May of 2016, what vehicle did you use to get to your house that day?
I don't know.
What vehicle was in your yard that you didn't recognize that day?
In May?
Yes. So he gets walked? He just showed up without a vehicle in your house on the back porch.
Not paying attention to that.
Nothing further, Judge.
Thank you, Mr. Wiggs.
I don't have anything. Thank you, Judge.
All right, yes, sir. Thank you. You may step down from the witness stand.
We are in Florida, where defendant Laurie Shaver was back in court for a motions hearing. The Claremont, Florida mom is accused of fatally shooting her husband, Michael, back in 2015, and then burying his body in the backyard underneath a concrete slab. Prosecutors say Shaver then went on to use her husband's phone and social media account to send messages to his friends and family in order to avoid suspicion. Shaver was arrested for the murder 5 years later in 2020 and now claims that her daughter, who was just 7 years old at the time, was the one who actually shot Michael. Before we would get you back into court, here's Court TV's Julia Janae with more on the case against Laurie Shaver.
November 7th, 2015, 33-year-old Michael Shaver left work as a Disney World mechanic and was never seen again. 3 years later, local station WFTV was there as Lake County, Florida police dug up his skeletal remains. They were buried under a concrete slab and fire pit in his backyard in Florida. He had been shot once in the back of the head.
Not every day somebody digs a body up out of your backyard.
Michael Shaver was married with 2 young kids when he disappeared. His wife, Lourie, told his friends and his employer that Michael had left her and moved to Georgia so they could work on their marriage.
My name is Laurie Filmer, also known as Laurie Shaver, and I'm a devoted mother. My life is my children.
According to court documents, friends and family received text and Facebook messages from Michael after he disappeared, but they said those messages didn't sound like him. They also began to question Laurie's decision to give away or sell Michael's guns, tools, and car.
The word crazy, I think, sums it all up.
In February of 2018, Michael's best friend asked police to conduct a wellness check. Laurie initially cooperated with police, but later refused to let them bring a cadaver dog to search the property. A month later, Michael's body was found.
She's always been a suspect. Yes, we've always considered her a suspect. Detectives are confident that she is the last person to see Mr. Shaver alive.
In 2020, Laurie Shaver was charged with second-degree murder. She pleaded not guilty. In 2023, her defense team filed a notice that they wanted to introduce evidence of prior bad acts and violence inside of the home. The motion further states that she did not shoot and kill Michael Shaver, but that their minor child, who had just turned 8 years old, acted to protect her mother.
I am not guilty, and anybody that knows me knows that my life is my children.
Laurie and her attorney posted a YouTube video to assert her innocence and asked for donations to fund her defense.
I had nothing to do with the murder of Michael Shaver.
Let's get you back into court now for more of that hearing. The attorneys are still arguing over the state's notice of intent to rely on the evidence summary.
Stated that you can't link the IP up with the digital data.
Looks like we have a whole brand new sponsor. I'll be sharing you with you all about that in a little bit. I think what we're going to do is just give me a few more minutes, but I want to find and replay in a few more minutes the recording of the daughter. Now, she did not show up in court herself. Well, she was, but they didn't show it live, so we'll have to listen to it. So what we're going to do is I'm just going to put it on our timer. Everybody take a comfort break. Go to the, comfort room, get yourself some coffee. Those of you who love hot tea, get your tea, get you a snack, and come on back, and we're going to start talking. I'll probably start diving into some of the paperwork and court documents that I have for the Brown trial. Not Brown. Sorry, that's my last name. Sarah Boone trial. Like I said, Miss Boone, who we just absolutely love. If you don't know, Miss Boone put her boyfriend in a suitcase, zipped him up, and let him die. So we will be doing that as well. And it's almost time for karaoke with Kristen. So we'll see. I may hop on there. I don't know. I might sign a song. Okay. I shall return. Let me get some music going for y'all. Everybody take your comfort break, and we'll be right back, y'all.
Okay, guys, I'm back. Oh my gosh, I have another sponsor. You know what? Sometimes I know Long Crime has a different clock. Their clock is different because they, how do I put it? Uh-oh, okay, it's still counting. They stop when the jury asks questions. So that's why don't stop mine. Okay? So when sorry, I can't have this within view. So when the questions happened, I let it stay running. I started my clock when the judge made it official. The jury was out of the room and he said deliberating. So I started it when he started it. So that's why there's a difference in the clock. I don't know why there's 24 unless they've had some pauses I didn't know about. Oh, that's why we're a little bit behind, guys. Sorry. Yeah, we're about 6, 7 minutes apart. So I'm sorry, it paused on me. My bad. I'm gonna listen to something. They were talking about pizza on Brandy's. I'm listening. Hold on. Mm. Brandy's watching something. She's sitting here going. The lawyers just passed behind her. Oh my god, the defendant and her lawyer just walked past her. Brandy. I'm not gonna share it because she has a guest on. So anyway, the tea company name is Ollie T OLI, separate word TEA company. Handcrafted artisan olive leaf tea, herbal tea blends. I'm gonna pull them up. I'm gonna pull it up and see what it's all about. She sampled me the tea. Oh my gosh, y'all. It is some of the smoothest tea I have ever had. I've never had olive tea. It's olive based. Oh my gosh. I mean, it was so good. There's one that she had that had she's got lavender citrus. Why are you stopping? I didn't stop. She has one that's called Restore, which was fabulous. Hibiscus lemon, I can't have that. The olive leaf tea is so smooth. It's like what you would use for dinner, iced tea. It's fabulous. Hold on. So the olive tea, they have Not Too Shy for Chai was really good, y'all. Oh my gosh, it was fabulous. Lemony mint, orange mint. Restore, oh man, that was good. That had turmeric. It was really good. The olive leaf tea, the lavender citrus, I said that. Hibiscus lemon, basilicious, that was really good. But that one would be good for people who are sick and need some warm tea that's healing. Of course, the chamomile and apple, oh, that was good. Oh, their strainers are cute. Oh, stainless steel strainer. I like that one. Tea steepers. Y'all, this is good. I'm gonna do this since she's gonna be our sponsor. I'm gonna share this with y'all. Here's the web page. Look at this. This is so good. Rockin' Rooster. Oh, this is the lung and health breathing. It's a unique flavor, but it's something that I liked. Like, if I'm sick, she said it's really good for lung health when you've got an upper respiratory allergy. Be right back. Gonna let my parrot talk. And another parrot online. Oh, okay. So we have 3 hours and 30 minutes and counting. I'm not too shy for chai. That's what the tea leaves look like. Isn't that fabulous? Oh, wow. Look at that lemony mint, orange citrus, restore, olive tea, and they're not expensive. Lavender tea, hibiscus, lemon. See, she doesn't have anything in their tea that's preserved, that's a chemical base. It is all natural. Oh, basil, delicious. Oh, yum. Chamomile and apple. Oh, aren't these cute? So you put one arm under the on the edge of the mug. You put one arm on the edge. Oh, that is so cute. They're reasonable. I don't like these personally. These are fabulous. Love these. And they're reasonable. Look at the price. And that's this kind. That's a good one. Sorry. And she has a couple of these. Oh, I have one of these, but, I like hers better. Mine just has a little ball at the end. This is cute. So they are our new sponsor, y'all. Excuse me again. Oh my gosh, y'all. Okay. How you doing, Miss Cockatoo? Okay. Ronnie, how are you doing? Let's find some more stuff to watch, y'all. I'm rejuvenated. And one thing about her tea, she said, which I like, is that you could drink one of this kind and one of that kind, and they're not real clash, which is good. So I'm gonna look forward to trying all of her teas out. I tasted about 50% while she was here. Where everybody I'm trying to just find some, videos of court that we can watch. I gotta find this video he's showing. It is insane. I wanna see if this guy if I can find this video. Oh my god, this was freaking hysterical. Holy crap, that was so funny. I'm hoping he'll share the link. Y'all gotta see this. Y'all got to see that. Oh, I need y'all to see that. This thing was absolutely hysterical. So, you see. Man, this guy did this weird thing for his back. That was insane. I'm over on Broken Baker and just looking around to see what we got going on. Thank you. Oh, this is funny, y'all. Okay, I gotta show you this. This is hysterical as this is hysterical. Y'all gotta see this. Okay. Y'all gotta see this. I gotta get it up. I got so many things open. Okay, this is called I gotta get everything over. Okay, guys, are you ready for this? Are you ready? Are you ready for a laugh? Have you recently had a comfort break? Um, did you eliminate? Because you're gonna need to. This guy is yoga from the heart. Okay, I'm gonna share. Are y'all ready? Da, 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 da. This is crazy. Let's go.
A laughing yoga, laughing exercise for the heart and mind. What you can do, just laugh. Very easy. Don't feel shy. And I am happy, I am relaxed. I am happy, I am relaxed. I am happy, I am relaxed. Boo, 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 boo. You can laugh without sound. Your lungs, heart, kidney, colon, spleen, pancreas start dancing. How? Now you can do full laughter. Inhale, exhale. And I am happy, I am relaxed. I am happy, I am relaxed. I am happy, I am relaxed. Boo, 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 boo. Now, how to energize your whole body from sacrum to pituitary gland, clean your inner chakras, will center, so your prana level goes up and you feel good. So what you do, just
Broken Baker had this on his live, and I thought I was gonna bust a gut. This guy believes the crap he's saying, and he is so funny. It is just watch. It's just
Oh my gosh. Oh my gosh.
Stretch your hands at the side, or you can bring it at the back on the sacrum and breathe out from the nose. Now this is the water center. Breathe out. Fire center, digestive power.
And people pay for
Now
this
heart
crap.
chakra. Now
What's up
your
with the
throat,
gown?
medulla.
It is a train.
Your third eye, power of 10,000 suns. Your wisdom center, crown chakra. Now your body is charged from sacrum to the pituitary gland
Serena.
all the way in, and laughing yoga.
Oh,
As service
Works. Vegas, coming to you from Sam's Town Live. Here's your
sorry,
host,
guys.
Darren Peck.
I want to welcome
Let me get
everybody.
it.
First of all, for weeks now, we have been watching some of the hottest talent here in Vegas. Fox 5 held auditions back in March, searching for the hottest undiscovered talent in Southern Nevada. More than 500 hopefuls put their
Where
talents to
is
the
it?
test.
I
And
lost
tonight,
it.
you will meet 5
There we
of the
go.
top 25 contenders.
Okay. This guy, Broken Baker, had on his thing. And I just had to. Oh my God, y'all. This guy is freaking insane. And all I could do was just keep from losing it. That little one did good, huh? Did the baby do well? I'm sure he did. Watch the beginning. Let me get the sound on.
Just laugh. Laughing yoga, laughing exercise for the heart and mind. What you can do, just laugh. Very easy. Don't feel shy. And I am happy, I am relaxed. I am happy, I am relaxed. I am happy, I am relaxed. Boo, 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 boo. You can laugh without sound. Your lungs, heart, kidney, colon, spleen, pancreas start dancing. How?
He is now, because he's no longer
Now
alive.
you
This
can do full
was years
laughter.
ago.
Inhale, exhale.
He's with. Oh, this is probably from like the 80s. So this guy is with his laughing ghost now.
And I am happy, I am relaxed. I am
I'm
happy, I am
happy,
relaxed.
I'm alive.
I'm
I'm
happy, I am
happy,
relaxed.
I'm alive.
Boo, 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 boo.
Okay,
Now,
that's
how
a
to
new one for
energize
us.
your whole body from sacrum to pituitary gland, clean your inner chakras, will center, so your prana level goes up and you feel good. So what you do, just stretch your hands at the side, or you can bring it at the back on the sacrum and breathe out from the nose. Now this is the water center. Breathe out. Fire center, digestive power. Now heart chakra.
And they used to sell
Now
these
your throat,
videos.
medulla. Your third eye, power of 10,000 suns. Your wisdom center, crown chakra. Now your body is charged from sacrum to the pituitary glands all the way in, and life force is running, and you feel good, right? It's called instant relaxation technique. And I am happy, I am relaxed. I am happy, I am relaxed. Boo, 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 boo. It's yoga time for stress relief.
Okay, so when we're frustrated with court, we're gonna go. You ready? I'm happy I'm alive. I'm happy I'm alive. Boo, 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 boo. I'm not happy.
For busy people, for the heart, body, and mind. Always say when you are stressed out, I'm happy, I'm relaxed. I am happy, I'm relaxed. I am happy, I'm relaxed. I am happy, I'm relaxed. Woo! Feel the energy, feel the joy, feel the love. You are here to enjoy your life. So wake up now, energize your body, energize your mind, and be happy and relaxed. I am happy, I am relaxed. So that is the instant relaxation technique for the busy people. It's stress free, power within you. Yoga for you, power within you.
Okay, guys, we do have a jury question. I saw the camera wiggle a second, but until it comes back, we're gonna watch this fool. He's almost done.
Now energize and love yourself. Oh.
Oh no. Oh, Broken Baker, you're horrible. You are horrible, Broken Baker, but we love it. I don't. That is so funny. Very funny. Oh my god. That was funny. Okay. So I think, we're on verdict. We are at 3 hours and 46 minutes, almost 47 minutes. Um, they have a question. I don't think they're gonna be deadlocked just after 3 hours, but then again, we've had that happen. Um Oh, somebody gave her a Brandy a piece of pizza. Then someone gave her a pizza. Well, because the snack machines are down at the courthouse. So